Well, good morning there. Good afternoon, wherever you are. I am huge. I'm going to bring myself down a little bit. Welcome to Trial TV Live. I am the Squeegee of Justice. Thank you for joining us. A little bit late, but got some food in me, so I am ready to go. We ride north. All right, so we are into Day 7, which is the defense. The state rested yesterday. State rests. Day 7, actually Day 6. Day 6, state rests. So we start Day 7. We're going to go all the way through to the verdict. So how's everybody doing? Who's with us today? Lil Miss, good morning, or now good afternoon. Julie, as always, thank you so much for everything you do. Therapist, you know. Two of our wonderful, wonderful mods, Brat. All our mods are here. OnlyFan, thank you guys. Thank you so much for showing up day after day after day. Really appreciate it. Curville, Jenny, legal-minded friends. Excuse me. How are you guys today? Dwayne Harris, where is Unbalanced Brother? Yep, he wasn't here yesterday either. That's the question of the day. Let's see. Krista Limited Edition, how are you? Baka of 3, Lily Wayne. Glad you guys are joining us today. Brad Cowell, will he take the stand? That is a excellent question. We shall see. Shirley Roth, how are you? Fanny Pack, Kathy Smith, Dreama Landry, Lacey, everybody's coming in. Great. All right, are you guys ready? Let's get to Day 7 of Iowa versus Jerry Burns. The state rested yesterday. And this trial was in 2020, February of 2020, and the event, if you will, happened December 19th, 1979, which, if you caught our stream yesterday, was the 45th anniversary of Michelle Martinko's passing. So let me grab my feeds here. All right, Day 7. Do we have closed captioning? Yes, we do. All right, cool. We have closed captioning for this one. All right, let me pipsqueeze myself down. Cover poor Michelle's beautiful face for just a moment. And all right, you guys ready?
Good morning, members of the jury. At the close, when we closed yesterday, the state of Iowa had rested its case in State of Iowa versus Jerry Lynn Burns. And now, at this time, Mr. Spees, if you choose to, you may present your case.
Thank you, Your Honor. The defense called Dr. Michael Spence.
Good morning, sir. Please pause and raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Go ahead and take a seat in that witness chair. There are just a couple of expectations in the courtroom when you are a witness. Please allow whichever attorney is asking you questions to finish the question before you begin your answer. They'll give you the same courtesy of allowing you to finish your answer before they ask the next question. Obviously, there's a microphone in front of you. That's because we all want to hear your testimony. And with that, would you please state your full name and spell your first and last names for the record?
Yes, my name is Dr. Michael J. Spence. That's Michael. The last name is Spence.
Thank you. You may conduct your direct examination, Mr. Spees.
Thank you, Your Honor. Good morning, Doctor.
Good morning.
Dr. Spence, you're here to help us understand some important issues in this case. And before we get into the meat of those issues, please tell us what your professional address is.
My professional location?
Yes.
Is in Las Cruces, New Mexico.
And are you a native of New Mexico?
You might say that. I was born in Baltimore, but I grew up in the Southwest.
And where do you currently office?
In my home in Las Cruces, New Mexico.
Okay. Could you tell us, Doctor, your educational background that leads you to the position that you hold now?
Yes, I have a bachelor's degree and a master's degree. Both of those are in microbiology, and both of those are from UT El Paso. I then went on to earn a PhD in molecular biology, and that's from New Mexico State University, which is there in Las Cruces, New Mexico.
Now, you mentioned U of T. T is for Texas, right?
That's correct.
Okay. And could you tell us about the work that you've been engaged in since you obtained your doctorate?
Once I finished my doctorate, I went on to what's called postdoctoral positions, and I got a research position at the University of Vermont Medical School, worked there for 4 years. I then went on to another position that was in Boise, Idaho at the Boise VA Medical Center, and that was for 8 additional years. So I did a lot of research, and all related to DNA. More and more so as time went on, it became more and more cancer research related.
And in connection with your work in cancer DNA and biology, did you participate in research that led to the publication of any scientific articles?
Yes, I have 14 published articles. Some of those were earlier that weren't related to cancer. A lot of those were later, mostly at Boise, that did relate to cancer.
And in addition, and important for your work here this morning, have you done any writing or publication in the field of forensic biology and forensic DNA?
Yes, since a latter part of 2015, I've been working on a chapter that is going to be published later in the year, probably summer. Late summer is what's being targeted. The title of the chapter is Chapter 8, Forensic Use of DNA, and it's going to be published by Thomson Reuters, along with a lot of other topics in medicine, psychology, and psychiatry from other authors across the country.
And, you know, kind of leaping from your early research and work in cancer research, how did you become involved in forensic DNA casework? And by forensic, we mean legal connections.
Yes, I was in Idaho working on the cancer research project that I had, and I started looking around at law enforcement positions because DNA was becoming a big part of law enforcement investigations. So I looked around at various law enforcement facilities and settled on the Indiana State Police, and they settled on me and gave me a position in May of 2003 and assigned me to their Evansville Regional Lab.
And where was that regional lab located, Doctor?
That's the southern tip of the state, pretty close to Kentucky, or very close to Kentucky.
So what kind of work did you do for the Indiana State Police?
Well, I had quite a bit of experience on working with DNA, but I had a lot to learn about how things work in a law enforcement lab, about chain of custody, about how to handle evidence and look for body fluids. Wasn't typical what I had been doing in cancer research, but identifying body fluids and ultimately doing their specialized techniques for extracting DNA, quantifying how much DNA is there in each sample, and then ultimately doing the typing that I'm sure the jury's probably already heard some about, and making comparisons between knowns and known individuals and what's on the evidence, and reporting that, and then, when needed, testifying to it.
So in your work with the Indiana State Police, did you have to get some specialized training to acquaint yourself with all the topics you just mentioned?
Yes.
And what kind of training did you receive for that?
There was a training program just to begin with what they call serology, and it's sort of a misused term because that's the study of blood, but the body fluid part, the evidence examination part. So I needed to have a deep understanding that the evidence can be anything. It can be garments, it can be shoes, it can be weapons, it can be swabs collected from various areas, and I needed to understand how to process those and examine those, look for stains on some items, and then ultimately used the specialized techniques. As I mentioned, the extractions were a little bit different than I was used to, and then the typing and comparisons was definitely a new thing to me.
Again, how long were you with the Indiana State Police Crime Laboratory?
That began in May of 2003 and went through May of 2007, so 4 years.
After your work at the Indiana State Police Crime Laboratory, where did you go from there in your professional life?
Well, for the most part, I was homesick and wanted to go back to New Mexico and had a position there that was very suitable. So I left in May of '07 and took a position as a technical leader, technical manager of a startup lab. The laboratory there was already doing parentage testing. What they wanted to do is spin off a lab that could do outsourced DNA testing for criminal cases, either for to help with backlogs for crime labs or to help with defense testing. And so I worked there for about 8 months before I turned in my resignation and started doing what I'm doing right now, and that was February of 2008.
So since February of 2008, have you been self-employed?
Yes.
And tell the men and women of the jury about just generally the nature of the work that you do now.
I launched my company, Spence Forensic Resources, and that's based out of Las Cruces, New Mexico, and I provide consulting for whoever calls who has a need to understand the technology associated usually with criminal cases, but it can be also civil cases that involves body fluids, typing DNA, and the investigation of DNA for the purpose of human identification. And as I said, usually for criminal cases. I've been doing that for 12 years now.
In connection with the work that you do now, Doctor, do you actually have a laboratory where you do lab work?
I do not.
And so the work that you do now in consultation involves, as you said, mostly criminal cases and occasionally civil cases?
Yes.
Could you estimate for the men and women of the jury the number of DNA-related criminal cases or civil cases in which you've consulted?
Consulted, or at least I'd say reviewed. There was a lot of peer review that I did with the Indiana State Police, and then a lot more cases in the last 12 years. Usually, as you said, criminal cases, it's come to about 1,025.
And how many open DNA cases are you working on right now?
About 40.
So you are obviously here at our request, and have you ever provided consultation services to prosecutors or to state law enforcement agencies?
Not as an independent consultant over the last 12 years, but the first 16 cases that I testified in, and all the cases that I worked on where I didn't testify, were for the Indiana State Police. But over the last 12 years, it's been usually defense cases.
If the prosecution asked you to consult with them about a forensic DNA matter, would you do so?
Yes, it would be the first time, but I would gladly do that, yes.
Okay. Do you charge for your work?
Yes, I do.
And how do you charge for your work?
My rate is $300 per hour. I reduced that to $150 per hour for my travel time. And occasionally I do a pro bono case. There are some that I'm continuing to work on, but the vast majority of my cases are at that rate.
All right. And Doctor, how do you maintain proficiency in the work that you do? By that I mean professional proficiency.
There are a lot of ways to do that. I maintain no proficiency on doing hands-on work. There are mechanisms to do that, but as a consultant, it's not really necessary. I don't have a lab. So what I do is I have to do a lot of reading. There was a lot of reading involved just in preparing the chapter that I'm writing, and I've reread that more times than I even care to admit. But I do read a lot of journal articles. Those are available through services, through the internet, typically for free, peer-reviewed scientific articles through something called Science Direct or ResearchGate. I also have relationships with people out there who work in outsourced labs or they do research. I at least know them through email and so forth, and I send papers to them, they send papers to me. But really just the casework is probably the biggest way to keep up and understand what's going on in forensic biology and DNA, looking at so many cases in so many states from so many labs. I'm looking at not only their standard operating procedures, their SOPs, I'm looking at their technical manuals and how they do the work in each individual case. So there's a lot to be learned from within the documents, and I'm continually looking at many, many cases.
Okay. In fact, you anticipated a question I was going to ask a little bit later about what you reviewed in this case, but would that be typical of the type of work that you do in a consultation case like this one, reviewing all of that type of evidence, that type of documentation?
Yes.
Okay. Do you often have other professionals review your work?
Sometimes I have other professionals look at some parts of my work, but typically I'm working entirely on my own. I have an assistant who helps me, and this assistant is administrative, not scientific. So the review of my work is really through any instances where I'm asked to write a report, if there's a report to review, or if I am interviewed sometimes by opposing counsel, that's an opportunity to review what I've looked at, or what I'm doing right now. I'm testifying. There's an opportunity to have analysts listen in on what I've done on the case, what my assessments are, what my opinions are, and respond to those.
Okay. How many different laboratories whose work was in question have you reviewed?
I'd say about 85. It's probably coming up on 90, but it's at least 85.
And how many different states have those laboratories been located?
In 30 different states.
Have you testified in court before as a DNA forensic expert,
Yes, I have.
including in Iowa?
Yes, one time in Idaho. I'm sorry, I keep saying that, Iowa. I used to live in Idaho, sorry.
Well, it's a mistake often made. So you have testified in court a number of times, and have you been qualified to testify in those situations in specialized areas of DNA forensic science?
Yes, I qualified on 16 occasions with the Indiana State Police and 119 additional occasions since then. And there's specialized areas such as minimizing contamination in the handling and testing of DNA, DNA mixture analysis, something that's called YSTR analysis, which isn't associated with this case, but also DNA transfer events.
Okay. Yeah, now, in the situations in which you've consulted in these hundreds of cases, have you always found something wrong?
No, often there's nothing wrong with the work, there's nothing wrong with the interpretation, and just as a gauge, only about 15% of the cases I'm needed to testify. The other 85%, it's not necessary for me to travel anywhere and provide testimony.
And is that because there's just no issue that arises in the case?
For the most part, or if there's issues, I can describe those to counsel, and they may not need me to come in and talk about that.
Okay. So if I may approach, Your Honor.
You may.
I'm handing you, Dr. Spence, what's been labeled as Defendant's Exhibit S1. If you would take a moment to familiarize yourself with that and tell the men and women of the jury and us what that is.
Yes, this is my curriculum vitae, my resume.
This summarizes your professional experience and background.
Yes, it does.
We offer Defendant's Exhibit S1.
Has the state had an opportunity to review S1?
Yes, and we have no objection.
S1 will be received and made part of the record.
So, Doctor, you're here for a very important reason, and just to get some additional background, we've retained you to assist in our understanding of some scientific and forensic issues in this case. What have you done to familiarize yourself with the issues you're about to talk with us about?
Well, I've reviewed the case file and the reports, and I've discussed this with defense counsel as to what the circumstances of the case were.
Okay. Have you prepared any written reports about your casework here?
No, I have not.
And by the case file, would the case file include the information that was obtained from the State Division of Criminal Investigation here in Iowa, the outsourcing of the scientific research done by DNA Labs, Bodhi Technology, Parabon, all of that material?
Yes, to varying degrees. I've reviewed those. I had a big file folder as I walked in. It's down there. I won't pick it up, but it's a lot of material, yes. And I did look through some of those materials very carefully, and other materials I glanced through just to identify what they were.
Okay. Now, based on your education and your training and your experience, have you reached some opinions in this case that would be, in your opinion, helpful to the jury?
Yes, I do.
And the opinions that you hold in this case, do you hold them to a degree of scientific certainty,
Yes, I do.
including the scientific analysis of critical items of evidence in this case?
Yes.
And about the crime scene itself?
To some degree, yes.
Doctor, would it be helpful to the men and women of the jury to have a rough illustration of some of the issues you're going to be talking about today?
Absolutely.
Okay. If we could present a demonstrative exhibit, Your Honor.
You may. Has the state had an opportunity to review the demonstrative aid?
Yes, Your Honor.
Okay.
There above your left shoulder, Dr. Spence, is a diagram. And could you, in general terms, explain what this diagram represents?
Yes, you see in the center, that's the most important part. It says trace DNA, and that's a little vague, but we're talking about small amounts of DNA in some instances that are going to be detected on criminal case evidence. As we go around, there are descriptions of ways that trace amounts of DNA, and sometimes more than trace amounts of DNA, can arrive on those items that are being analyzed. It can be from coughs, sneezes, speaking, as I'm doing right now. I'm sure my DNA is right here on this microphone head. Touching, we know now that things you touch, you're going to leave behind skin cells. Dilute fluids, and this would refer to body fluids, presumably. That's what we're talking about here. Sweat, blood, semen, saliva. There are other body fluids that are involved. Mucus. There can be indirect transfer. So you can have DNA transferred from a person onto an object through any of those mechanisms I just described, and then transferred subsequently to another object. And this has been tested and in research studies way too many times, probably, the hundreds of papers that have come out, research papers on that. And just talking about the kind of objects we can see from one person to another person. You can get DNA onto another person from the first person. Shaking hands is an easy example. Hugging. At crime scenes, there can be transfer events from people who arrive at that crime scene. Prior to the crime scene, during the crime scene, after the crime scene, there can be transfer events. These are concerns for handling DNA as far as contamination for the people who collect crime scene evidence. So these are all objects and persons that can have an effect on what we ultimately see on items at the end, where we're taking a snapshot, essentially, with our DNA typing as to what's on that item at the very end of the analytical step.
Okay. Thank you. So we're going to ask you this morning to focus on some specific items of evidence, in particular, a very important item of evidence, and this is the dress that Michelle Martinko was wearing when she was killed in 1979. I think it'll be helpful for us to focus on the clothing that she wore, and in particular spots on that clothing, okay?
Okay.
We know that at the time of her death, she was wearing this dress, and that eventually crime scene analysts were able to focus on a spot which is now known as spot F5 on this dress. Are you familiar with what I'm talking about?
Very much so.
And the testimony and the evidence introduced in the trial so far showed that the dress was removed from Ms. Martinko at her autopsy. It was turned over to law enforcement. It was dried at the police department, and then it was at some point packaged by identification officers, what are now called maybe crime scene technicians, there at the Cedar Rapids Police Department. I'd like you to take a look, first of all, at Exhibit 17K, if I may approach.
You may.
And if you would take a moment, Dr. Spence, to familiarize yourself with 17K. May we publish that, Your Honor?
You may.
Yes.
And 17K has been described as I guess, a black and white photo of the outside packaging of some of the clothing that was worn by Ms. Martinko. And if you look at the very bottom of 17K, there is an evidence tag that shows 12/19/79. If you look over your shoulder there, you can see the highlighted portions.
See if you can find.
And
Yes.
Beneath that 12/19/80. The
Yes.
testimony in the case showed that, of course, 12/19/79 was the date of the homicide, and an identification officer testified he wasn't sure if that 12/19/80 date was the date that the clothing was originally packaged, or if that was a misprint. He just didn't recall. But you understand, at least at some point, the items were packaged within a year of the homicide, right?
It would appear based on what's on the tag, yes.
Sure. And then further up on Exhibit 17K, we have another notation made by Identification Officer Murphy. And is your understanding that these items of clothing were repackaged in 1996?
That's my understanding. I've seen that on descriptions of how the item was handled, and you see that right there on the packaging
All right.
photo.
And so this would have been some years later. By the way, Identification Officer Murphy testified that the reason the items were repackaged because the Iowa Division of Criminal Investigation no longer wanted to have staples in the bags, and they also wanted to mark it as a biohazard. So that was the explanation given for it being repackaged. Is it correct from your understanding that the clothing that Ms. Martinko was wearing was bundled together or packaged together?
Yes, that's my understanding.
And if we could take a look at the Exhibit 17E. I'm sorry, not 17E. If we're going to kind of jump ahead here to get to the critical time period, is it correct that the contents of that package, including the clothing, were examined about 2 years later in 1997?
Yes, that's correct.
And it was again examined in about 2002,
That's correct.
again in about 2003,
Yes.
and then finally again in 2005?
Yes, I wouldn't say finally, but the next one that was
Sure.
of importance was '05, yes.
And in your work in this case, did you follow those sequence of events in your work?
Those were very important dates, yes, for a forensic biologist, DNA scientist like myself to focus on.
All right. And we also understand from the testimony in this case that in about 2008, some of the evidence in the case was affected by a flood in Cedar Rapids, Iowa. Are you familiar with that, too?
I'm familiar that there was an issue with that, yes.
Now, importantly, we've heard, and is demonstrated by the packaging, that the items of Ms. Martinko's clothing, her dress, her underpants, her pantyhose, were bundled together at various times during the packaging and repackaging. Can you let us know your thoughts from a scientific point of view, Dr. Spence, about the issue of bundling items like this together?
Yes, it's improper, especially for the modern day analysis, and by modern day, I'm talking about coming into the late 90s and beyond, just as to put down a time, not an exact time date, but in that range. Things shouldn't be packaged in that way. They should be separated out. And if something is packaged, of course, in 1960 or 1979, people weren't aware, who were working scenes, that the prominence that DNA was going to gain over the next few decades. But as those items are opened up, it is best at some point, it's better late than never, to separate out the individual clothing items into separate packages.
Now, a retired criminalist, Linda Sauer, testified to the men and women of the jury that, and she, of course, did a lot of the identification evidence you're going to be talking about, said that if the items are in a dry state, that is, if they're not moist, that biologic material that might be on those clothes will not transfer. Was she right?
No, that's completely incorrect. That is not what the research has told us, and as the sensitivity of DNA typing is going up, higher and higher sensitivity over the years, over the decades, that's clearly not correct. Our ability to detect things even back in the early 2000s was at a point where no dry transfer of DNA has been established through research and through looking at casework. We know that happens.
Okay. And we also had testimony from Identification Officer Murphy, who testified that if all the clothing came from the same person, that wasn't a problem. Was he correct?
I disagree with that completely.
Why is that?
I think that you need to separate out the items as early as you possibly can. I can understand why law enforcement officers in 1979 might not have thought of that. But as we've developed the testing methods, and as soon as it was noted that all these items were bundled together, they should have been unbundled and put into separate packages. It's vital to do that.
Now, is this based on your opinion and your knowledge, or is, as you said, is this notion of transfer and contamination substantiated by other research?
Yeah, the idea of dry transfer of DNA, and that doesn't diminish the fact that damp sources of DNA certainly can be transferred even more readily, but dry transfer of DNA, there are articles on that, hundreds and hundreds of them, and just to focus on a recent review article, there were 298 previous articles that were cited in that, and it's the research on the actual casework and the research studies on transfer of DNA. It's very prevalent, and this can happen in situations, especially where you're bundling different items together.
And the article that you just referred to, is this in a authoritative research journal?
This was a peer-reviewed scientific journal.
And was it authored by people who are authoritative in the field?
Well, the particular one I'm referring to, which is out of January of 19, was authored by essentially the most renowned people working on DNA transfer events, and there's a lot of individuals doing that, but the ones who are the most prolific in generating information on the understanding of transfer events were those individuals.
So when we talk about transfer events, we're meaning DNA going from one location to another location?
Yes, much like the diagram that we saw that said trace DNA in the middle.
Now, you mentioned dry transfer. Could you be more specific about what you mean by dry transfer?
Well, you can have, that's a good question. You can have, first of all, it's just skin cells transferred directly. If I touch this glass, I'm going to be having a dry transfer of skin cells from me onto the surface of this cup. You know that's going to happen. This is because the average human from head to toe sloughs off, sheds about 2 million cells per minute. So items that get touched and the clothing items that I'm wearing, I'm going to be transferring my skin cells onto my own clothing. We know that. Other types of transfer can involve something like body fluids that can get onto an item, and then that becomes very dry over time. But still, when those items come into contact with other people or other items, there can be a secondary transfer event of what was in those body fluids, whether we're talking about sweat, mucus, saliva, blood, semen, and we know these dry transfers do occur, whether it was originally from a body fluid or whether it's from skin cells.
So you mentioned the article. Is the recognition of how frequent dry transfer occurs becoming more and more prevalent in crime laboratories across the United States?
Yes, within that article, they referred to, first of all, the doubts that there were over the years that really these transfer events are really that prevalent. But it has become very clear through the research that it is very prevalent, and law enforcement has responded. Investigators who work crime scenes know that they can swab off steering wheels, doorknobs, collect clothing where they're not necessarily looking for a body fluid on the clothing, but just who wore the clothing. And because of that, in the modern day, from this research review article that I looked at within the introduction, they state that more than half of the evidence that are in crime labs are believed to be from some sort of dry transfer, touch, handling kind of event, as opposed to a blood drop that's swabbed off of a floor, that's body fluid. Or sexual assault cases where they're looking for semen, for example, that's body fluids. But more than half of the items in crime labs now are looking for the dry transfer handling events.
And would you agree with that?
Yeah, absolutely. That's what I've seen in the casework. More so as the years go by, there's more and more of those types of items are the focus of investigations.
So we're going to turn now to the meat of the case, Dr. Spence, and we've heard testimony from retired criminalist Linda Sauer about her work in the case, and I'd like to direct your attention to her work in, first of all, 2003, and if I may approach, Your Honor.
You may.
I'm going to hand you State's Exhibit Number 9C. And if you would take a minute to acquaint yourself with that, please.
Yes, I've reviewed this.
Okay, and tell us what 9C is.
This is one of the many reports that were released, but I believe it's the only report from 2003 signed by Ms. Sauer.
And if we may publish that, Your Honor.
You may.
Up on the screen now, above your left shoulder, Dr. Spence, is 9C, and highlighted there is the date of September 8, 2003. This is the report that Ms. Sauer prepared in her work in 2003. Is that right?
That's correct.
Okay. And in that report, she identifies that she received the scarf and the pantyhose, and I believe there were other items attached as well. Do you remember that?
Yes, the scarf, pantyhose, the panties, and the dress were in that one package F.
Okay. I'd like you next to look at State's Exhibit 9C2. These have been identified as Ms. Sauer's bench notes from August of 2003. Are you familiar with those?
Yes, I've reviewed these as well.
And Ms. Sauer testified that these were her handwritten comments of how she examined the evidence in that case. And I'm going to ask you some specific questions about those as well. Can we get that up? Again, above your left shoulder is State's Exhibit 9C2, and these are the bench notes, right?
That's correct.
And in the bench notes, it appears that she noted that the items had been repackaged in 1994. Do you see that highlighted?
Yes, I do.
And again, you talked about the risk of repackaging. What are the risk of packaging and repackaging items, like clothing?
Well, for each time that you open it up and take things out, when you have to put them back in, and that's where I'm saying if you put them all back in together again the way they were, there's just more opportunities for there to be contact between various items, and we know there are 4 items here. And they're going to be squished together as you get that sealed tight and seal the outer edges of the package. And that's going to be stored for however long it is before you open it up and take them out again. This is where I was saying it's best to, at that point, when you take them out and you recognize that there are distinct items, and you're going to repackage them anyway, perhaps for good reason, go ahead and repackage them in separate packages.
And again, up over your left shoulder, we have highlighted 4 references to what she examined on that date. And can you tell us what she examined on the date of this lab note?
Well, at least what she focused or examined on is one thing, but what she's inventorying here within the package is the black dress, the matching scarf or wrap, the pair of pantyhose, and a pair of panties. And then it mentions that there were digital photos. The amount of examination that went beyond that is a separate issue, but this is basically an inventory of what was found within that package F.
Now, notable, again, in the bottom highlighted portion there, she said no exams on F2 and F3 at this time. And I think that F2 was the matching scarf, and F3 was the pantyhose, so she did not examine those?
Yeah, that's where I was making that note, and she's making that note. Those two items were not going to be examined at the time, but the other two were.
Okay. In her lab notes, I think on the next page, she mentions using an ALS, or view dress with ALS. Could you tell us what ALS is?
This is an alternate light source, and maybe a lot of you know what a black light is, and that's a similar thing, although it's just a wavelength or maybe a couple of wavelengths that are available on a black light. These are much more sophisticated. They have much more settings of different wavelengths, and they help to illuminate items so that perhaps you can see discolorations on any kind of given item that you're examining.
Now, I use a black light, as I mentioned earlier, to look for urine spots for my dog, but the alternate light source used in a situation like this, would it make blood glow?
But no, it won't. Blood is going to have the completely absolute opposite effect. When you have an item that has blood on it, it's going to pretty much absorb all the light, and it's going to appear black. And we're talking about, just to give you the idea, you're turning out all the laboratory lights. So you're not using high-intensity light to look at the item. You might have already done that. But for this ALS, you're going to switch off all the lights and use only that source on given items. And you can find body fluids that fluoresce, but blood is going to go the opposite direction and appear very dark on an object.
So when Ms. Sauer testified about her examination of the dress, she talked about looking for texture. And what do you understand to be her looking for texture on a black dress?
Well, typically you're going to look for any kind of fluorescence if it's a body fluid that fluoresces, or if it absorbs the light like blood does, you'll look for the blackness of it. But we've got a dress that we can all see is very dark, so that's going to make it very challenging to see where blood stains begin and end. So looking at the texture is a very intuitive thing for any analyst to do, is to see if there's some kind of textural clues that there might be some kind of a deposit somewhere on a particular area of the garment you're looking at.
Based on what you saw from the lab notes and what you saw from the other records that you reviewed, was it plain to you that Ms. Sauer made a thorough examination of the dress in 2003?
Very thorough, yes.
Did she note anything about any blood spots on the back of the dress, as you recall?
I believe that there was one area that was looked at on the back of the dress, but it's not the one that we're most concerned about that comes later. I believe it's the F4 area, and there's a little confusion there because there's items named F. So it's area F4 on the dress, which was a pretty distinct, I believe she used the word in her description, obvious blood-stained area, and did test positive for blood.
And I believe that in her report, Exhibit 9C, that she identified that the 4 spots that she located on the dress were all determined to be the blood of Michelle Martinko.
Yes, there's 3 blood stains on the front and 1 on the back, and all those did type to Ms. Martinko.
Now, in Exhibit 9C, I think that she also mentions that she located spermatozoa in the underpants, item F4.
Yeah, and that's where the confusion comes in. It's item F4 as opposed to area F4 on the dress. It's item F4, and yes, she did visualize sperm cells under the microscope on that particular item.
Did she explore that at all?
She did.
And did she make any findings about the spermatozoa?
Well, beyond noting the presence of spermatozoa and that there were small numbers of them, she did conduct typing on those. She performed a specialized extraction of DNA that would try to isolate and concentrate out the spermatozoa into one fraction, whereas the other fraction would be what we call a non-sperm fraction. That wasn't really worth looking at, but the sperm fraction, she did see evidence of male DNA, but it was not conclusive at all. It was a very weak profile.
Okay. So you described for us the manner in which she examined the dress, and based on the documentation that you've looked at, Doctor, do you have any quarrel with her examination of the dress in 2003?
No, I do not.
The next report of her evaluation of the dress was in December of 2005. And if we could have Exhibit 9D, if I may approach.
Did you say D or B? I'm sorry. D or B?
D.
We'll take those away.
Taking a look at State's Exhibit number 9D, can you tell the court and the men and women of the jury what that is?
Yes, it's a subsequent report that's released on December 5th of 2005.
And does this also include examination of the dress again, Exhibit F?
Yes, it does.
And from your review of Exhibit 9D, did she also reach some additional new conclusions about Exhibit F?
Yes, she refers to previous conclusions from the previous report. There's a couple of reports that we had looked at here just now, but indicated that there were additional screening tests looking for blood on various parts of the dress.
All right. And now I'm going to approach and hand you Exhibit 9D1. And tell us again what Exhibit 9D1 is.
Well, similar to what we just talked about with the report and then the corresponding bench notes. We have a report here from December of '05, and we have the corresponding bench notes, which are dated October 31st, '05. So as she was going through the items, these are the notes that she took, and then the report came out subsequently to that.
Could you tell us in general, if I may publish 9D1, Your Honor,
You may.
what she did in examining the dress in October of 2005?
When she examined the dress, she's moving on to other areas that could be identified on the dress where she perhaps had textural issues that she's looking for. As I mentioned, it's going to be difficult with the bright lights of the lab or the ALS to identify where any blood stains are, but she's picking out new areas to collect samples and run examinations for body fluids or DNA or both.
Now, in the bench notes and, of course, in her report, she notes that she again located blood that she attributed to Michelle Martinko. Is that right?
Yes, she did.
And she also identified a new spot on the back of the dress that she labeled F5. Is that accurate as well?
Yeah, and to be clear, we're talking about area F5 on the dress, and this as it is at the lower back, near the seam area in the middle of the back of the dress.
Can you tell from the bench notes, Dr. Spence, how she went about identifying F5, location F5, and how she determined that it was or was not blood?
It's not clear on exactly what she did at the F5 area as far as identifying any kind of textural issue or anything. And it's not clear that she even did run presumptive tests for blood, but it's in the report that she did collect samples and test for blood.
Now, she talked in her testimony about how she marked different areas on the dress. Sometimes she would circle areas with a white pen or white marker of some sort. Are you aware whether or not she marked the area F5 with any kind of a marker?
I've seen no photos. I've seen photos of where F5 is and close-ups of what it looks like today and previous photos from back in 15 years ago. And I've never seen any white markings in that area.
In the exhibit that we have up on the screen, this is Exhibit 9D1, she mentions that she screened positive for blood those new areas, number 5, number 6, number 7, and number 8. She told the men and women of the jury that in screening she used what she called a presumptive test or two presumptive tests. Are you familiar with that concept?
I'm familiar that there are two presumptive tests, and I know which tests that they're talking about. One of those was a test we commonly use with the Indiana State Police. This was in the middle of the time where I was with the Indiana State Police, and we used what we call and I hate to use these long terms, but phenolphthalein. That was one of them, and I'm aware from communication with counsel that the other one was leucomalachite green, a second presumptive test.
And how are those tests done, if you will?
I've been made aware through counsel that it was a swabbing, and this is common, what an analyst will do in the beginning of looking at the bottom part of the dress. They'd swab off that area, and then that would be consumed for the presumptive tests, which in this case for area F5 they were both positive.
For blood.
Yes.
She, again, we're going to focus on F5. She testified that she used a swab for these two presumptive tests, and then she, I believe, also took a cutting from F5. Is that your understanding as well?
That's correct.
So would the swabs that would be used for these presumptive tests also be used for testing for DNA?
No, typically not, and I don't believe there's any reason to believe that that's the way that worked. You wouldn't want to do that with the DNA. You're already adding chemicals to that cuttings from the swab. You typically want to go back and collect a cutting, and we know from the holes that we can see in that area that one cutting was collected at least there in 2005.
So in making a cutting like that, how would Ms. Sauer or any criminalist be sure that they were getting a cutting from the same place that they got the swab to determine that there was blood present?
Well, you can't be absolutely sure. One thing is if you've circled the area with the white marker, then you'd have a pretty good idea of where to go back and collect your cutting. But if it's too difficult to see where you need to mark, you certainly don't want to go and mark over an area that might be an actual stain where you're hitting the marking. And this is why sometimes analysts, and when I did the same kind of analysis, sometimes I would circle an area that was very clear where I could see where a stain was. But if it was uncertain, you don't want to put markings on there, so you're going to have the challenge of going back and trying to hit the area you just swabbed as best as you can.
Could swabbing actually remove DNA from a site?
It could remove the body fluid. It can remove the goal is to get enough material to see a positive blood test if there's one to be had there. Once you've consumed that swab and you go back to collect a cutting, there's going to be a challenge to figure out where that is. And yes, you may have removed any percentage of that blood area, whether it's 50% or 90% or more. You're not going to really know.
You know, there was other testimony in the case about the presence of blood on the steering wheel of the Martinko vehicle, and there was retired identification officer White testified about taking a lift from the steering wheel to raise blood off of the steering wheel, and that item H. Are you familiar with item H from the steering wheel?
Yes, I am.
And was there any DNA detected on item H?
Well, first of all, as I understand, there was a swabbing collected of that tape lift, and the swabbing showed the positive blood test similar to Area 5 on the dress. And so there was an indication of blood, but the DNA, there was no DNA typing information that was interpretable there.
Would blood, if it was present on that lift, typically hold DNA?
Well, blood is an extremely rich source of DNA. Within a single drop of blood, you're going to have about 400,000 DNA containing cells. So this is going to be very rich. If you have even 1/2000th of a drop of blood, if you can wrap your brain around that and imagine that tiny amount, that would still give you enough DNA to get probably a full profile. So it may have been that on that steering wheel tape lift, the blood might have been removed completely by the initial swab to do the presumptive tests.
Okay. So was there an indication in Ms. Sauer's analysis of the Area 5 that Ms. Martinko's blood was at Area 5?
There is some indication that that might be the case, and typically with blood being a rich source, we see very little information that's pointing to Ms. Martinko there. There is a mixture on the Area 5 results, but the very low-level added person in the mixture, it's what we call a major-minor mixture. The major was not her. The lower-level information that was there had some consistency with Ms. Martinko, but it was very, very little genetic information. But intuitively, you would assume that if you have a few markers there that point to her, that it's her dress, and there is blood in other areas of the dress.
Well, you mentioned, Doctor, this being a mixture, and in that mixture was a male profile.
Yes, there was.
So is there any question that there was male DNA at area F5?
Area F5 on the lower part of that dress, there was male DNA. There's no question about that.
And although we've heard it was not a complete male profile, do you agree, based on what you've read, what you understand from the trial testimony in this case, that that male profile is consistent with the profile of Jerry Burns?
Yes, there's a clear consistency there with Mr. Burns.
Now, Ms. Sauer testified that she could not be certain that the tiny bit of male DNA, and was it a tiny bit of male DNA?
It was a low-level amount of male DNA. It was not what we call low copy number DNA, and that's where it's really a very trace amount. But it was a very small amount of DNA, and it doesn't take much in the modern day, and 2005 really counts. DNA is more sensitive now, the typing is, but back then it was modern day typing, STR typing, very sensitive, and the amount that's there, even though it's incredibly small, was more than enough to get typing information.
Okay. And again, she testified that, that she could not be certain that that male DNA came from blood, or whether it came from saliva, or whether it came from mucus or sweat. And she, I think, acknowledged in answering a question from government counsel that the blood could not be the only explanation of the source of that male DNA. Do you agree with that?
Absolutely.
And I believe Mike Schmidt testified as well that he could not be certain where that male DNA came from. And would you agree with that as well?
I agree with him as well.
I want to ask you just a few more questions about the testing that Ms. Sauer did and the DNA yield at that site. And if we could approach, again, Your Honor, with Defendant's Exhibit T1.
You may.
Could you tell us, please, what Exhibit T1 is?
Yes, this is labeled as a case summary sheet for PowerPlex 16. Now, this is the platform of testing that was done, but it's also summarizing what the DNA yield results were. And in this instance, there's a column here showing the amount of DNA, the total amount of DNA that was recovered from that cutting.
And would this exhibit help the jury understand your explanation of the potential sources of the DNA at F5?
Perhaps. It's numbers on here, and they need explanation.
And would you be able to offer that explanation?
Yes.
Okay. We offer Defendant's Exhibit T1.
Does the state had an opportunity to review the proposed exhibit?
Yes, Your Honor, no objection.
T1 will be received and made part of the record.
May we publish that, please?
You may.
Highlighted on Exhibit T1 is, well, first of all, if you could explain the columns and what those columns mean for us, please.
The far left column is identifying what the exhibit is, and we have highlighted F5, and that's the most important one to look at. It shows extraction date, but also where it says quanti blot. And this is an old technique that's what I was using with the Indiana State Police as well. We've upgraded that to something called real-time PCR, but back then the real-time PCR can be inaccurate on measuring the DNA. This was even more inaccurate. So it's an estimation. It's a guess of roughly how much DNA is in these samples. That's where it says result, and it says NG/, and the next is a Greek letter mu and an L. That's the concentration of the DNA. So it doesn't tell you the total amount of DNA there. It tells you how concentrated it is, much like as if you make lemonade. If you take a whole can of frozen lemonade and put it just in a quart of water, it's going to be way too concentrated to drink. If you put it in a huge vat, you'd barely be able to taste it. That would be not very concentrated at all. So what we're doing here is we're getting a measure of what the concentration is. You also need to know how big the amount is, and perhaps if it's a drop, That would be, you take the number there, which is 0.062, and you multiply that times 50 if you have a drop that's 50 microliters.
So can you tell us, based on what's highlighted there for Exhibit F5, either how concentrated or the amount of DNA that Ms. Sauer was able to extract and examine?
It's not very concentrated. It comes out to if you have a drop of DNA liquid, which is what you want to have. You don't want to have a whole full tube this big of DNA. It's too much volume. You don't need all that. And you don't want to have such a small amount you can barely even use a pipetter on it. So in between that is about 50 microliters, and that would be 3 nanograms. And I can explain what a nanogram is. I have to do that now.
Please.
A nanogram is 1/billionth of a gram. So to help juries understand, visualize that, if you know how much material is in an equal packet or a Splenda packet, they put exactly 1 gram in there. So it's 1/billionth of that. So if you were to take an equal packet and dump out the entire amount right here on the stand here, and throw away 999 parts and only keep 1/1000th of it, you have a milligram. If you were to then try to divide that little tiny pile by another 1,000, throw away 999 parts, and you have what's left you may not be able to see. It's about the size of a speck of dust. That's 1/millionth of the original equal packet, and you're still not there. You got to divide that by 1,000 again, throw away another 999 parts, and you're down to something you can't see without a microscope. That's a nanogram, and it's 1/billionth of a gram. We have about 3/billionths of a gram from this cutting from Area 5.
DNA?
Of DNA, and that's the total DNA that's in there. Now, the majority of it does appear to be from a male, and there is a second source in there that may be Ms. Martinko, but it's going to be most of that 3 nanograms is going to be from the male that's present.
So if the male DNA at area F5 from the cutting that Ms. Sauer took had come from blood, would you expect that she would have found more DNA than what she did?
Much more DNA, but just to give you an idea, if you had 1/800th of a drop of blood, that's going to give you about 3 nanograms. If you divide a drop, typical size drop, about 50 microliters by 800, the number of cells you'd have in there is going to be about 500. And that's 500 cells. We know exactly how much DNA is in every nucleated cell, and that's going to be come out to 3 nanograms. So what we have down there, if that was blood from that area, all blood, that would be about 1/800th of a drop.
But she didn't raise that much.
I'm sorry, could you repeat that?
Yeah, she didn't find that much.
She found the 3 nanograms of material, but we don't know if that's blood or if that's some kind of other source of skin cells or transfer or talking that can get onto a microphone, spittle, mucus. We don't have any identifying information other than the preliminary blood test that occurred before the cutting was taken.
So asking you this differently, based on what we know from what she was able to extract and examine at area F5, and based on the reports that you've read about the crime scene, about the testing of the car interior, the purse, the steering wheel, the seats, the door handles, the area around the car, is there any indication, based on that information, that the man or woman who killed Michelle Martinko had cut himself or herself?
No.
And why do you say that?
Well, we don't have the amount of DNA that you typically get from this area where there's male DNA, for example. If we're looking for a foreign profile, we have one. It's at A5. But the amount of original DNA that was in that cutting is not consistent with what you'd normally get from blood unless you're talking about an incredibly small fraction of a drop of blood. And there's no trail anywhere else. As you mentioned, a purse, the seats, other areas in the car, or perhaps a trail of blood drops leading away from the car. I saw nothing in the description of the crime scene that supported that there would be a perpetrator cut and spreading little bits of blood in various places.
Now, we know from testimony earlier in the trial, Dr. Spence, and from examination of the dress, Exhibit 7A, that the dress was sent to DNA Labs International. Are you familiar with that laboratory?
Yes, I've reviewed a fair number of cases where they were involved in the typing.
That the dress was sent there for some additional cuttings from around the area of F5. And what can be made of the fact that DNA Labs International was not able to extract or locate any DNA in the vicinity of F5?
Well, we know that within the vicinity of F5 that there's no white markings, which isn't necessarily a mistake, as I mentioned. If you don't feel like you should mark it, then you don't want to put marks on top of an area that's important. These areas were very close in tight, but a little bit away from that central area that Ms. Sauer collected. And none of those 4 areas showed any indication of blood or interpretable DNA. So what that tells us is that at least that far out, we've got a void space with no sources of DNA.
Now, after Linda Sauer isolated F5 and tested it, and I believe it was re-examined by DNA Internationals, was there any indication from the material that you reviewed that there were any further examinations of the dress for any other DNA?
No, I don't believe that there were any additional areas that were examined for either blood or foreign DNA on places where there might have been some kind of transfer event or some kind of a body fluid deposit anywhere.
Any indication that the scarf that Ms. Martinko was wearing was ever examined for the presence of DNA?
No.
Well, knowing that she attended a banquet at a hotel the night of her death and was at a shopping mall in Cedar Rapids, Iowa, the night of her death, would you expect to find other DNA on her clothing?
Objection. That's pure speculation. Can I voir dire the witness?
You may.
Dr. Spence, so what exactly have you reviewed as a result of this case?
I've reviewed all the reports. There's about 42 of them. In order to examine this case, I've looked at all the supporting documents from that. I focused most of the work on the work from Ms. Sauer. I reviewed the televised testimony of Ms. Sauer. That's all I reviewed within the televised information.
Oh,
And
excuse me. So you've been watching this trial as it's been happening?
that part of it, I did review the testimony from the opposing DNA analyst, yes.
So you knew you were going to be a witness and you watched that testimony
Yes.
take place? Okay. Did you review any of the, or watching the testimony from the lay witnesses who were present at Westdale Mall that night?
No, I know that the trial's gone on for quite a few days, and I wouldn't have time to review. I focused entirely on Ms. Sauer.
Did you review any of their previous witness statements about their interactions with Michelle?
No. Well, that might have been actually in the police reports. I might have seen some mention of those, but it's not really pertinent to the science.
Okay. And that's, I guess, where I'm getting here then. So did you see anything within the witness statements, police reports, anything like that, that indicated a circumstance that would have led to Mr. Burns' DNA being transferred to Michelle Martinko's dress or her car?
Well, it would be hard to discern any involvement with Mr. Burns
So
in that way.
Is that no, then? You didn't see anything like that?
I know that Mr. Burns did go to that mall on occasions. I don't think there was any statement that he knew he had been there on December 19th of 1979. Beyond that, other people's DNA perhaps being on her clothing, it's hard to trace back to who might have touched the dress on that night.
And so with regard to Mr. Burns, did you see any indication from any of the discovery whatsoever, any of the reports that there was a circumstance on or about December 19th, 1979 that would lead Mr. Burns' DNA to be on Michelle Martinko's dress?
No, I don't believe so, no.
Thank
It's
you.
not in there.
Then we object on the grounds that this question calls for pure speculation, Your Honor.
Response to the objection.
Well, it's not speculation, Your Honor. He's a scientist, and he's talked about trace DNA, and this is a question that goes directly to his expertise.
May I respond, Your Honor?
You may.
Your Honor, under the rules of evidence 5.703 regarding expert testimony, the basis of an expert testimony has to be based on facts or data in the case that the expert has been made aware of or personally observed, and it has to be the type that they would reasonably rely on to form an opinion on the subject. And also under 5.701, expert testimony has to be valuable to determine, 5.702, to help the trier of fact to understand the evidence or determine a fact and issue. And there's no evidence upon which this opinion would be based. This is pure speculation. And putting the certificate or the seal of an expert on this opinion would be improper because it's no more than any layperson could speculate.
Any further argument, Mr. Spees?
No, Your Honor, this is well within the realm of the expert's expertise and his explanation of how an item of evidence would be examined.
The objection will be overruled. The jurors will, as the fact finders, the judges of the fact in this case will determine what weight to give all the evidence that they have heard, all the testimony that they have heard, including any opinion given by Dr. Spence. But he will be permitted to answer the question, and the question that was pending was, well, knowing that she attended a banquet at a hotel the night of her death and was at a shopping mall in Cedar Rapids the night of her death, would you expect to find other DNA on her clothing? So you may answer that question, sir.
I think I would expect to find DNA from others on anybody's clothing, as long as they've worn it for any amount of time. And you can even have wash clothing, clothing items that people have worn for, let's say, years, and they're actually washed and dried, and you test those for DNA, and you can have DNA on those as well. Sometimes even the washing or dry cleaning is not going to remove all the DNA. But if you're interacting with other people, there are going to be instances such as the spittle that I accidentally put on this microphone just talking to people. You can get DNA on your clothing from that.
Just by your interaction with other people and your contact with other surfaces?
Yeah, if you touch the other people, if they talk around you, if they leave DNA on an item and you come over and sit down next to it or on it, those kind of things, this is how transfer events do occur.
So since 2005, when Linda Sauer isolated and examined F5, DNA labs attempted unsuccessfully to find other DNA in the vicinity of area F5. To your knowledge, from your review of the investigation, was there any other effort made to determine another male source of DNA on Ms. Martinko's dress?
Beyond December of 2005, no.
Stated differently, in pursuing and focusing on the male DNA profile in F5 and what may have been found on the gear shift, item I, again, was there any attempt to identify any other male profile in the car, the dress, any place in the crime scene?
Yeah, there's other garments. Those were, nobody went back and examined those garments. Once a male profile was found, there was additional examination of what was on item Exhibit I, the gear shift, the area of the dress F5, and there was typing done on known males to try and identify whether or not those happened to be the known male who was on those areas. But there was no additional searching through other garments or other items collected from the car to see if there was another male.
So was F5 the kind of the end of the road scientifically?
The end of the road, except for trying to identify who that was. Yes.
Thank you. Those are all the questions I have for you.
We're going to stand in recess for about 15 minutes. I'm going to give the jury an opportunity to rest before we hear cross.
All right, chat. They are going to take a little break, so we're going to revisit what Dr. Michael Spence just laid on us. So he's a forensic DNA consultant. He works out of his house. He is an evidence tech at DCI. Did I write that? That doesn't sound right. Well, he talked about the flood in 2008. I'm not sure about that. I'm going to remove that. He talked about issues of bundling items. It is improper. He states what they did was wrong, how they bundled Michelle's items, which were her underwear, her pantyhose, her dress as well. And he called it modern day, which is essentially the late 90s and beyond. He said they should be separated. He talked about how damp sources of DNA can be transferred, but also dried transfer can occur. Talked about Linda Sawyer's report. He said all the blood on the dress was tied to Michelle. They talked about sperm cells, item F4. He said there was no question there was male DNA on F5. But then he said clear consistency with Jerry Burns. So I asked you guys, did he just implicate Jerry Burns? And you guys said yes. So what are they doing? I would think you would want to distance yourself from that DNA. But then he said, would you expect DNA to be transferred if she was at the banquet or the mall? That's an objection came in. He said he reviewed all the reports and the TV as well. He said he just watched the testimony on Linda's. He watched it on TV. He didn't watch the rest of it. But alcohol to drink or alcohol as a cleaning substance. I meant as a cleaning substance, Lily Wayne. And he talks about spittle. He's like, yeah, I'm transferring DNA right now while I'm talking spittle into this microphone. Ugh. Yeah, I don't know. Did it move the needle for you guys? Did not for me. But all right, let's continue on. If anything, he buried Jerry even more. But all right, let me pull up the next one. Shirley Roth, first part says it's his DNA, then says no DNA. Yeah, nope, I don't buy it. Nope, yeah, nope. Yeah, I agree, nope, yeah. All right, let's see what else he's got. I'll go, let's see. I think we're coming up with cross now, I believe. But let's see what we got.
The record.
Do we have closed captioning? Yes. Okay, we have closed captioning. All right. Do my little pipsqueeze over here. And away we go. All right, catch you on the other side.
Will reflect that parties and counsel as well as members of the jury have returned to the courtroom after a morning recess. We are ready to hear cross-examination by the state of Dr. Michael Spence. You may proceed, Mr. Maybanks.
Thank you. And good morning again, Dr. Spence.
Good morning.
So there's a store here that sells T-shirts that are kind of Iowa-based, and one of the T-shirts says University of Iowa, Idaho City, Ohio. Is that kind of how you feel being here?
Yes, sometimes.
Maybe you should pick that one up. So I want to talk to you about a few things. First thing is you testified here this morning about secondary transfer of DNA. Is that a fair kind of topic?
In part, yes.
Yeah, okay. And sometimes that's referred to as tertiary transfer, isn't it?
Well, that would be the next step. That's primary secondary and tertiary.
Gotcha. And just to be clear here for the record, and I think we kind of covered this already, but you have not gathered in your investigation any specific facts or any knowledge from the case file or from the proceedings that show that a secondary transfer occurred from Jerry Burns' DNA to Michelle Martinko's dress, correct?
No, I have not.
And so you're not testifying in this case that it's your opinion that the way Jerry Burns' DNA got on her dress was through a secondary transfer?
No, I'm not testifying to that.
So, Dr. Spence, you've testified in a lot of cases around the country, right?
A fair number, yes.
And do you remember a case that you testified in, it would be U.S. v. Dieter, D-I-E-T-E-R? Does that sound familiar to you?
Yes, I do.
Okay, all right. That was fairly recent. That was a decision, well, it was a case from probably 2016 or so. Underlying facts were from 2009. The United States District Court for District of New Mexico filed an opinion upholding a conviction in that case in 2017. You familiar with all that?
Yeah, it seems like my role in that was much earlier.
Okay. Yeah, you've appeared in that case and did a PowerPoint presentation explaining secondary transfer of DNA. Remember that?
I don't recall if I did that, but if you're saying so, I believe so. I think that that would be a case that involved possible transfer events.
And do you remember saying in that case, or maybe this is something you say in a lot of cases where you testify about this, that in that case, the transfer event of DNA was within the realm of possibilities? Remember using that language?
I probably did say that, yes.
Okay. And so I guess my question to you, Dr. Spence, is what exactly is not within the realm of possibilities?
That's a really difficult question to answer.
Right.
It's really hard to nail that down. You can't. I could not sit here and say it's within the realm of possibilities that I don't exist. I mean, I took philosophy class in college, so they teach you that how do you really know that this isn't all just a dream and your actual dream world is the real world. So you can't even say that. So there's a lot of things that are plausible. Some things are very implausible, and it's hard to put a percentage on them.
Okay. I didn't know you were going to wax so philosophical. That's good.
You did that to me.
But that's the point, though. I mean, when you talk about the realm of possibilities, anything's possible, right?
A lot of things are. Some things are extremely improbable, but they're within the realm of possibilities.
With regard to the studies that you reviewed in the area of secondary transfer, first of all, none of those studies, you didn't do any of those studies, right?
No, I did not.
Okay. You just reviewed those in preparation for your testimony here today and other cases you've testified in?
Yes, when I talk about the 298 articles on DNA transfer that are in the recent review,
Right.
I'm sure I haven't read all of those.
To the extent that you can recall those, don't the vast majority of those studies involve the scientists involved in creating purposeful transfers and then measuring them?
I'd say there's more of those than there are studies on possible transfer events that occur in casework, because in the casework, you never can really be sure of the mechanisms. You really are speculating in those instances. So a lot of it is creative research on the plausibility of various circumstances.
So in some cases, scientists in a lab perform these staged handshakes where they handshake for maybe an extended period of time and then test the transfer of something from one to another and then report their findings. Is that a fair, I guess, description of at least some of those studies?
Some of those, yes.
Okay. Are you familiar with the study from the Journal of Forensic Science? This would be a 1999 study called A Systematic Analysis of Secondary DNA Transfer. The researcher was Ladd, L-A-D-D.
I have seen a paper with Ladd being the lead author, yes.
Okay, and in that paper, they were looking over previous statements or a previous study by other scientists, and they were recovering DNA from this previous study. They were recovering DNA from palm swabbings from frequently handled objects such as phones, door handles, and keyboards, and from objects handled under controlled conditions. Does that ring a bell?
I don't recall exactly what the conditions were of that particular study, but that sounds plausible.
And in that study, isn't it true, or maybe if you recall, that when they conducted the analysis, most significantly, in no instance was the profile of the second individual detected?
That may be the case. We have to take that into context. That was 1999. The sensitivity of the technology was gradually improving over the next several years, and it's much more sensitive here in 2020. It was significantly more sensitive in 2005. And it's one study, and I've seen many studies in there where the yield of DNA is remarkably low.
In 1999, they weren't necessarily able to develop as comprehensive or extensive a profile, but they could detect the presence of DNA.
In some instances, yes.
Right. And with regard to the transfer of DNA, wouldn't you agree that when assessing the probability of detecting DNA of interest within a scenario that incorporates multiple contact events, where that transfer may have occurred, one first needs to determine the order of contact of events within the pathway of interest, and then to consider the impact of the variables present at each event. Sound familiar?
That makes sense. And is this, we're still talking about the lab paper, or is this a different one?
No, this is not the lab paper. I think this is one that is far more recent and may have provided the foundation for some of your testimony today from Forensic Science International, DNA Transfer and Forensic Science, a review.
That's the 2019 article,
Correct.
I believe.
Yeah,
Okay.
Yeah. And so that statement then that's contained on page 155 of that article, doesn't that pretty well indicate that you need to know the preceding events in order to properly study whether the transfer events took place?
I think that's what they're trying to say. I think that more accurately, that's the goal. Sometimes it's very difficult to say what the sequence of events are. As I mentioned, when we do typing, we are taking a snapshot of what's there at the time, and you can't really tell the history of what might have led up to getting that snapshot. And I think the authors who wrote that know that. But what they're saying, if there are ways to try to re-piece together through other evidence the sequence of events, that can be really helpful.
And to reach scientifically valid findings, or at least to be able to profess things scientifically, you need to be able to report that you can trace these events and that you made these findings. Otherwise, aren't you just in the realm of possibilities?
Yes.
And there's also a lot of factors involved in DNA secondary transfer, isn't there?
Absolutely.
And as this paper shows from 2018 from the Forensic Science International Journal, some of those factors would involve, for example, when there's a transfer of dried blood from a porous cotton substrate to another cotton substrate, or to a non-porous flat plastic substrate when pressure with friction was applied. That's a variable, right?
Yeah, those were a few variables you mentioned there. One is what the source is. They were mentioning dried blood, and they're talking about friction is definitely going to be pertinent to transfer events.
And in that particular circumstance, according to the study cited by Goray, Goray, Goray found that there was a transfer in less than 1% of those circumstances. Is that right?
In that particular instance, that may have been the instance, yes.
And so then there's a lot of other factors that are required for this transfer as well. For example, I think the same study showed that there was far less transfer in those circumstances, from 0 to 3.4%, when there was no friction applied between the substrates. Does that sound right?
Yeah, and that's getting back to friction's going to be important, duration of the time of the transfer event, whatever they're testing there. And this is in an artificial environment, again, where they're testing to see what happens when they use this amount of friction or an increased amount of friction, and duration is going to be important as well.
In that same study, Goray also found less DNA appeared to be transferred when touch deposits were left for 24 hours prior to transfer than when the material was freshly deposited. Sound right?
Over time, you can definitely see you're not going to get more DNA from it just sitting there. So there's going to be more opportunities for the DNA to get eroded off of an item, or for it to even decay. That's typically going to be when it's much more time.
And there's a lot of studies that they summarize in here. Another one is Buckingham, who found that in transfer experiments that were done there, again, controlled experiments, that DNA picked up by a hand from a previously touched knife handle that subsequently contacted a glass plate or cotton plate was far less retrievable from the cotton than from the glass.
Yeah, the type,
right?
I think you're talking about the type of surface now. That's going to have an impact, whether you're talking about a smooth surface like glass, and this is going to be similar, or if you're talking about a fabric, the transfer rates are going to be different.
These are all things that you need to know to be able to make findings regarding whether transfer DNA occurred.
Yeah, you might
A
have
lot of
said,
factors, right?
yeah, you might have said the word determine, and you're not really going to be able to determine the exact facts, but to shed some light on what you can expect from possible transfer events, friction, duration, the type of surface, whether it's a
Surface.
fabric.
Yep, surface is huge, chemical compositions, fiber type, weave thickness, even the electrical charge will have an impact on a transfer, right?
I suppose so. I don't believe I've seen that paper.
Oh, that's, well, that's the paper that you referenced, you want to see it, or?
Is that, well, if it's in the review article,
Yeah.
yeah, there's a lot of papers in there, and as I said, I probably read pretty close to half of those, but maybe close to two-thirds of them, but in passing, and some others I've studied it in detail. But
The-
Buckingham, you mentioned, that name doesn't strike a bell, maybe a paper I haven't looked at.
Maybe you can read that in the plane on the way back.
Yes, sir.
Okay. And then obviously the event that causes the transfer is huge, right?
Yes.
Yeah, so for instance, in this paper, they talk about biological materials such as blood, saliva, and semen are often transferred during altercations, whether while fresh or at some time after it is dried.
And
So
that's-
that's a real strong indication of a transfer there, an altercation, right?
Yes, and that's intuitive.
And-
If you have an altercation, there's going to be a higher likelihood of a transfer, and if you got body fluids involved, there's going to be a higher rate of transfer.
Right, and so you kind of read my next thought here, but wet, liquid, biological sources have significantly higher transfer rates than when they're dry, right?
Yeah, and on top of that, you have to recognize that body fluids have typically a lot more DNA involved. So, and the transfer rate in a liquid form are going to be transferred much more readily than dry transfer.
There's a large difference in the quantity of DNA transferred too between wet and dry substances, isn't there?
And that's really what I'm talking about, is that the higher amount of cellular material in the liquids, if we're talking about liquids, not just water that's has no DNA in it, if there's just water involved, talking about actual liquids that are from body fluids, there are going to be more cells, more DNA in there, and just because it's liquid, it transfers more readily.
In fact, the Warshauer, Warshauer et al., found that there's a pretty distinct difference here, that the transfer between wet and dry substances is 44 to 100% versus less than 1%, respectively. Right?
It is a higher rate of transfer with body fluids and liquids, yes.
And it's important also to be aware of how quickly the material dries and the duration between the initial disposition and contact with another surface. So the timing of how long something's been there, that's pretty huge too, right?
The timing, the duration of the transfer, the humidity is going to affect it.
This previous study by Van Oorschot, Oorschot, showed that blood on a hard, non-porous substrate will dry within 30 to 60 minutes and sometimes quicker in warmer temperatures. Sound right?
It makes sense to me, and that is the most prolific author, and he's the lead author on the review.
Oh, good, we landed on him.
So he's citing his own work there.
Excellent. He also said, this foremost person on the subject, that the transfer rates of blood 5 minutes after deposition declines exponentially until the deposit is dry. That's, I mean, he's the guy, right? So
If he
that's-
says so, yeah, I would trust in that, depending on a lot of other factors, absolutely.
Going back to Gore again here. This is again in the same paper. DNA deposits by hand transfer at a different rate to blood and saliva. Such DNA deposits transfer at significantly lower rates than blood and saliva. Is that right?
Yeah, that's intuitive, and that's what I would agree with 100%.
Looks like the authors also talk about individuals who may be shedders. Is that right?
Yeah, it's a poorly defined concept, but it is known that some people do just give off more DNA, and this is where I was talking about the 2 million cells per minute from the average person, and it does vary quite a bit from one person to another. This has been seen in laboratories where some people have a real difficult time doing the lab work because their DNA keeps getting into their own samples. And no matter how good their technique is, and it might just be that those particular individuals give off more skin cells than others. We all give off skin cells. It's just the rates are going to be different from one person to another, and we have no idea why.
So another scientific factor that has to be taken into consideration, you would agree, is how some individuals shed more often.
And typically, we're not going to know who the shedders are within this room and who the shedders aren't, or really if there's that big a difference from the...
And that's weird, the saying shedder. Can't you guys think of some other way to...
I didn't come up with that stuff.
Well, another factor, too, is the manner of the handling. I think we talked about that as well. How contact is made with an object. You really kind of have to know that, too, to know whether transfer took place, right?
And that's the friction and the duration and what kind of material is being transferred.
Even the part of a hand is different. The fingertips are different than the palm, different than the back, right?
I would assume if you're very calloused there, you're not going to have as much transfer.
And when we talk about clothing, inner collar and wrist areas of a garment can include more DNA from the individual who's wearing it. And if you did find DNA in other parts of clothing, it'd be more likely to find the other individuals away from those areas, right?
Analysts have found that, and the collar areas, as you're saying, the wrist, the armpits on shirts, for example, are very good for transfer. And then other places that seem a little bit odd for your DNA to come off from wearing, that may be a transfer from somebody who came into contact with you, somebody who punched you or somebody who hugged you. There's no way of knowing.
So, I mean, they kind of wrap this up here and say that when you talk about the means of the use of handling items that are relevant, you have to have knowledge of the history of the item of interest, the contacts with the item relevant to the activity, the difference in transfer rates by parts of the hand. And these are all things that, in order to come to any kind of scientific opinion, you need to know, right?
I think it's challenging to understand if you don't know, for example, the history, and usually we don't. We don't know the history of how DNA came to be on an item. DNA typing, as elegant and sensitive as it is, can never tell us how the DNA got there or when it got there. The clues that we do have in some instances are body fluid tests. That can tell you a little bit about the how.
So if you don't have some of these factors present, you can't examine them, then you're just kind of in the realm of possibilities like you talked about, right?
Yeah, you have to discuss all the possible scenarios in order to do a proper interpretation of what might have been.
So let's kind of work with the theory here to discuss circumstances where you'd expect individuals' DNA to be other individuals' DNA to be found on another person. And in this case, we'll just use a hypothetical, a young girl who's murdered. Okay, so that night the young girl's murdered, let's say that young girl came into contact with numerous individuals that night. Individuals who talked to her, spent time with her, maybe gave her a hug, maybe gave her a handshake, sat down in the same area with her, could have gotten in and out of her car at some point in time. You'd expect to see those individuals, well, it's possible, I guess, at least you'd see their DNA.
There's always possibility. It depends on where you check for the DNA.
Right.
Too,
But
as well.
Those factors, though, that increases the likelihood of the individual's DNA being found on our young girl in that scenario, right?
It does depend on whether there was some kind of contact or some kind of vicinity of the two people being with each other, and whether they faced each other and talked was going to have an impact on that as well.
Like you said with the microphone here, which kind of leads me to believe we might need to clean it or something. But when you talk, yeah, your DNA, when you're close to somebody, that increases that likelihood, right? That
Exactly.
your DNA might end up with them. So you got a young girl in a situation where she's, talking to 15, 20 people, in close vicinity with them, sitting down with them, maybe even sharing food or beverage with them, you got a real good chance of finding potentially the DNA on her at a later date, right, or in her vicinity.
Yeah, I don't know if I'd say a real good chance. I'd just say that if you access the right areas, yes, there's a chance that you find somebody else's DNA there.
That's beyond just the realm of possibilities, though. That's a little bit more possible, isn't it?
The more contact, the more closeness between two people, yes, there's a higher and higher possibility that there would be some kind of transfer event of some mechanism.
So let's take another scenario here. And that scenario is that you have an individual who comes in more direct physical contact with her. Okay, so they're actually in the same car together, and let's say this individual is on top of her holding her down. You have a pretty good chance of having his DNA on her, right?
On various parts, I would be shocked if their DNA wasn't, at least in some places, yes.
And there's a struggle between this individual and her. You got a really good chance there. You got DNA flying everywhere, right?
And if you're talking about on the clothing items, the outer clothing items, it would be, as I said, shocking if you could check everywhere and they're nowhere on there. That would have to be a non-shedder.
Yeah, right, for that to happen. Let's say during the same scenario that the struggle turns into something more violent and a weapon is used where there's cuts to both individuals. I mean, that's a real good chance of having DNA there for that person, right?
Yes, for both. If there's cuts to both individuals, yes.
And especially if this is something where there's not one cut, but there's cuts over and over again that take place. You got a real good chance of having that person's DNA there, right?
The person who is the victim of all those cuts, their DNA is going to be in large amounts everywhere.
So you're not talking realm of possibilities. You're talking this is pretty darn well a fact at that
If you
point
want
in
to
time.
talk about an absolute certainty, yes.
Switching gears just a little bit here, you talked about crime scene, I think, a little bit, handling of evidence like that, but just so we kind of know the circumstances of your background, when you worked for the Indiana State Police Lab, you didn't work on crime scenes, right?
I never visited a single crime scene. I oversaw the collection of material from a vehicle once with the Indiana State Police and once as a consultant, but that's about as close as I got to a crime scene.
Okay. And so you had some testimony here earlier this morning that you believed, based on your experience, that it was improper to not separate items of evidence.
That's correct.
And in this case, you're probably aware that the items that were contained in the same package were all from Michelle, from the same person, right?
Yes.
Okay. And so your concern, what you're talking about, is you believe it's important to prevent contamination from any foreign sources, like from any foreign source of DNA that wouldn't have been on those clothes to begin with that somehow ended up on it.
Well,
Is that fair?
in part, foreign, if you're talking from outside of the package and into the package, that's always going to be a concern.
Always, yeah.
We're talking more about transfer from item to item.
Item. Okay. So you're not talking about having a concern about something that wasn't there originally that ended up there, but the transfer from item to item. That's what you're saying might be an
More
issue.
so with the commentary, the bundling things together. That's more about the transfer within the package between different items or different parts of the same item. That can happen. You can't avoid that. If we're talking about, let's just say the dress was packaged by itself, you can have transfer from one part of the dress to the other. And it's just impossible for people who are doing the handling to completely prevent that.
Also, maybe, I didn't see it on your CV, but I'm sure you dealt like with gunshot powder residue and stuff like that, or?
There were cases that involved that, but I have no expertise in that. If there was any kind of issue where maybe something needed to be tested for that, then there were people within my building who did that.
Well, I guess, for example, you wouldn't want gunshot powder examination to be done with items that have been mixed together, because then you couldn't find out where the gunshot was originally.
Well, I don't have the expertise in the gunshot powder residue, but my understanding is it's similar to DNA in that you need to be careful about mixing items.
You mentioned during your testimony cases where, or something along the lines of there being over the half the items in crime labs are from, have DNA from transfer events? Remember saying that?
Yeah, that they're at least, to maybe word that better, that more than half the items in crime labs that were discussed in that review article, more than half those items were designated as items presumed to be where they're looking for some type of handling or transfer event, as opposed to a body fluid.
Okay. And when you say that, when you talk about transfer event, that's primary or secondary?
Yes, any kind of primary, secondary, just not involving a body fluid.
Okay. For there to be any kind of secondary transfer, there has to be a primary transfer first, right?
Yes.
We looked at 9C1, I believe, State's Exhibit during your testimony. If we could just get that up really quick here. Yeah, that's okay right there. So, may I approach, Your Honor?
You may.
So if I've learned anything from this case, analysts have really bad handwriting. Do you?
I think mine's better.
Oh, okay. All right, we may test you on that, but if I could just, excuse me here a second. During the testimony here, you mentioned, or Mr. Spees did, that this said repack on 12/31/94, but we also had an exhibit that said 12/31/96. Now, it's not the best handwriting, but you don't know for sure whether that's a 4 or 6, do you?
Well, now that you mention that, because in the timeline, I believe 96 was the year, so it might just be a handwriting issue. And I want to just make sure, I can't see the date on this one. I can't remember if this was which date's at the top. It's kind of blocked off
This
there.
is the 2003 one.
Oh, it's right there.
Yeah.
Did you just move that?
We did, yeah. sorry.
Okay. I look back, okay. Yeah, that was August 9th, okay. It
Okay.
was the
So obviously
middle
that-
study. Okay.
Turn and talk over each other, okay?
Does that upset you? Sorry, Mary.
I can better word myself.
All right. And you talked a little bit about Linda Sawyer's, or Sauer's examination here in 2003. And if I heard you right, you said that you think that she did a really thorough examination, right?
Yes.
Didn't have any quarrel with the way she did that?
No.
Okay. And in 2005, the other report that you looked at, you were talking to Mr. Spees about how Linda ran a presumptive test on the evidence there in 2005, but you didn't see it in her notes. You remember that?
That's correct.
But then I think we pointed out that she mentioned it in her reports, right?
Yeah, and just to clarify, she mentions in her notes presumptive tests, but it's difficult to discern whether she's referring to the previous ones from the previous report, or she's saying that the items inventoried down below that were actually presumptively tested. When you look at the report, though, she actually gives the results.
Okay. So you have no reason to believe she didn't do presumptive tests in 2005, right?
No, I don't believe I do now.
And there was some testimony here about how there wasn't a marking done in the area of F5 to indicate where her cutting was taken. You remember that?
Yes.
Okay. And we have the dress here. Have you seen it, or?
Yes.
Okay, all right. Can I just get it out really quick to demonstrate something?
You may.
And I want to touch it, and I don't want to have to put on a glove for now, but see this area down here that's marked?
Yes, I see a marking.
Yeah, and is that in, if we could, now just,
When I say I see a marking, I'm talking about just a tape marker.
so down here, you see that area down there?
Yes.
Okay, and clearly there's a cut in the middle, and There's 4 around it. You see that?
I can't see it right now, but I've seen the photos of sort of the 5 cuttings, like on a die, is the way I describe them. If you roll a 5 on the dice, it's in that kind of pattern.
So there's no, I mean, you don't have any problem detecting in the picture, or if you were to look at this, where F5 was, right?
No, I can see at least where that area where the cuttings are.
And then there was some testimony about DNA International doing some additional cuttings. You probably saw that in the materials too, right?
Yes.
Okay. And is it your understanding then that DNA Labs International did those cuttings after a flood took place in Cedar Rapids?
That's my understanding, is it was beyond the flood date, which was in, I believe, '08.
Yeah. And you may not have seen this part of the testimony, or, and obviously you don't have a lot of knowledge about the flood, but isn't it true that, obviously if a dress gets wet from a flood, that's a problem, right?
Yes,
DNA?
I've often testified that water is the arch enemy of DNA. For one thing, it can remove DNA. It may not when it comes into contact with DNA on a fabric, but there's a chance that it will wash it away, and there can also be some degradation caused by the moisture.
And wouldn't you agree that humidity can also be an enemy of DNA, or?
Yes, that's why you don't package items in plastic. You want to keep them in breathable paper sacks.
You testified earlier that blood is an extremely rich source of DNA. You stand by that, I take it?
Absolutely.
And with respect to F5, again, on Michelle's dress, as indicated in 2005, you concur with the finding that the major contributor to F5 was the male and not Michelle, right?
Yes.
If we could have, I think, Defense Exhibit T1 here. As that's coming up, you don't need to have a lot of blood to be able to develop a DNA profile from it, right?
You need very little. Almost an amount of blood, modern day, currently today, a speck that you might not even be able to see, like a period on a sentence, that amount of blood, you should be able to get a full type from that.
And with regard to Defense Exhibit T1 here, I think you told us that this amount here, that are indicated, .062 and whatever the other amount is here, that measures the concentration of the DNA, not the amount, right?
Correct.
So is it true then that State's Exhibit, or Defense Exhibit T1 doesn't really tell us anything about the amount of DNA?
No, it tells us a lot about the amount. It tells us the concentration, and lab analysts are typically going to have either a fraction of a drop or maybe a couple of drops of DNA, but usually it's going to be about 40 to 50 microliters. I don't know what the volume is. I don't believe I saw that in any of the documentation, what the exact volume is, but it's going to be in that ballpark. So the 3 nanograms could go a little bit higher, a little bit lower, depending on the volume. It's not a liter. You wouldn't have a liter of DNA liquid that you'd be working with. And it's not going to be a single microliter. You can barely see that.
In T1, is that meant to indicate the concentration from the area that they were able to develop the DNA?
Yes, and I should say it's an estimate of the concentration. I mentioned that our techniques are so much better now, and even today, the real-time PCR that's used can be, especially in the low levels, wildly inaccurate at times. These slot blots could be inaccurate as well.
But, so we're talking about the area where the DNA was able to be isolated and developed, but this doesn't tell us how much blood was there.
Oh, no, we're not dealing with blood determination here at all. This is just measuring how much DNA is not only in that sample, but the other samples in the list there.
You testified a little bit about whether you thought that this indicated blood from a cut, something like that. I'm not exactly sure what you said, but I guess I just want to be clear here. And you know, you don't have a medical background, right?
Medical related, but I was not a pre-med or anything like that as an undergraduate, no.
And you haven't been qualified to testify in terms of injuries or how injuries bleed?
Not at all, not at all.
Okay, all right. So you really can't tell how much blood may result from a cut, no matter how small or large?
That's only intuitive. My own experiences with cutting myself and skinning my knee, that kind of thing, cutting myself, shaving. That's where the experience begins and ends, and I have no expertise in that area, though.
Some cuts might be big, some cuts might be small, like a nick or a prick or something like that.
They might be shallow, they might be deep, and you're going to bleed more with deeper, bigger cuts. I think everybody knows that.
And maybe this comes from your common experience too, but if you were, well, I'm going to say this probably doesn't come from your common experience, but let's just bear with me here. If you're wearing a glove and you cut yourself on the inside of the glove, you know, from the outside, just barely get a cut in there, but you're cutting, you cut yourself. I mean, doesn't it make sense that a lot of the blood would pool inside of the glove or instead of being dripped out?
I think that's very intuitive. I would expect that as well.
And obviously, you know, if we end up having a hangnail or something like that and we pull on it and realize it right away, we may be able to cover it and prevent blood from continuing to ooze, drip, spurt, whatever. I mean, just our own methods can prevent that blood from gushing out more, right? Common experience.
That's common experience, yes.
In your testimony, you talked about how since 2005, there were no other efforts to determine a male source. But we also talked about the fact that in 2008, there was a flood that took place. So you did see, and you have testified here, that there was testing done on multiple items of clothing through 1997, 2002, and 2003 before 2005, right?
That is correct.
And this item was item F. So you may or may not have seen State's Exhibit 17H. Can I approach the witness, Your Honor?
You may.
This may be somewhat foreign to you because it's not your lab, but there's an indication on this chain of custody form that items A, B, C, D, and E were all sent to off to the laboratory for testing before F.
Yeah, I can't recall which items those are.
Now, as you know, we're not just dealing with a DNA profile of Mr. Burns on a dress. We also have had testimony and evidence of his profile from scrapings on a gear shift selector. You're aware of that, right?
Yeah, I don't think I'd characterize it as his profile. I'd say that it's a profile that is similarities to what was found on the dress.
Fair enough.
It's a partial profile. It was very weak, but what was there was consistent with Mr. You couldn't exclude him, and I agree with that.
Mm-hmm. And you testified something earlier I caught that I just wanted to follow up on. You said that YSTR testing was not an issue in this case?
Yeah, and I misspoke on that. That's
Okay.
true. Now that I've thought about it, there was some YSTR testing that was done on an outsource at a later time, but on the same area.
Mm-hmm. And you had a chance to review those findings, I take it?
Yes, I did.
Well, do you remember, ask you, test your memory about another one of your cases that you've worked on. This is 2013, so about 7 years ago. United States District Court, Eastern District of Arkansas, Little Rock Division. This is Kevin Jones versus Mark Frost, Gary Dunn, and James Bacon. That ring a bell?
Yes.
Good memory. All right. In that case, you filed an affidavit with the court where you did some calculations.
Yes.
Remember that? And so you said that based upon the Scientific Working Group on DNA Analysis, SWGDAM, guidelines for statistical interpretation of YSTR data, that you could use the product rule to combine probabilities to discover how many males would be excluded as potential contributors to a DNA profile at two different locations. Does that sound right?
I think I understand what you're saying, and I know what the issue is. Yeah, you can use the product rule as I understood it back then, and I think that, I don't know if that's changed. If you have some low-level STR typing, and you have YSTR typing, which is not anywhere near as good on identifying an individual. You can't identify a male specifically with YSTR typing, but
Well,
you can.
hang on, because you can identify the
Can we let
paternal.
the witness answer, please?
I'm sorry, it wasn't responsive, so I was trying to. Go ahead.
Okay.
Yeah, I was just trying to explain that you can identify consistencies with a paternal line, and that can give you a number, and typically those numbers are not as strong as STR, but as I understood it back then, and I don't think anything's changed, you can use the product rule on the determination from YSTR typing and STR typing combined. You can multiply them by each other, and I did in that instance. That was actually a civil case.
Yeah.
The criminal case was over, so it was a civil case related to a criminal prosecution.
So by doing that, in that case, you could take the statistical frequency data that you had of these two different locations, multiply them together, and then find out how many people could be excluded as contributors to both.
Yeah, you could generate an estimate of that. Yes, you can.
So in this case, you've seen the numbers, right?
Yes, I have.
Okay. And I don't want to ask you about necessarily your opinion on those numbers at this time, but using this product rule, you could take 1 in 1,773, which is a number from the YSTR profile, and combine it with the 1 in 100 billion number and get the number of randomly chosen males who were tested that could be excluded. Right?
Yeah, as I understand how you would do that kind of product rule from two different platforms of testing, that would be acceptable. I think a forensic mathematician could correct me on that if I'm incorrect, but I believe that I researched that properly, and you can.
Can you do that right now?
Can I do that? Well, I don't know if I need to. You can multiply that 700 some odd number. It's not going to have that much of an impact on the number that's already big in the billion range. So you're talking about from the gear shift.
Correct. 1,100, or it's 1,773, I think was.
Oh, okay, I'm sorry, I thought it was 700. Okay, 1,007. You can multiply those two together, and if you want me to get out a calculator, I happen to have my cell phone right here to do that. I could do that for you.
Go ahead.
Could you give me those numbers?
Yeah, sure.
$1,773,
73,
and the other number is?
100 billion. Maybe you can't do that on your calculator.
It's easier. It's easy enough to just do it and multiply it by 100, and now you got 177,300 billion. So that's a huge number. This is an estimate of as far as number of random people you'd have to look at to find that profile, especially considering that you do have YSTR data and you do have some very weak STR data, but the defendant can't be excluded from that area.
On your CV, do you have the reasons on You know, I'm not seeing it on here, but I thought I saw it on another one I got a hold of, but this is an article called If DNA, Then Guilty, Strategies for Overcoming Juror Assumptions About DNA Evidence in Criminal Trials. That's an article you contributed to, right?
Yes, it is.
The January/February 2015 issue of The Champion. That's what it was published in, right?
That's correct.
And The Champion is a publication from the National Criminal Defense Attorneys Association.
That's correct.
Do you remember in that article that you contributed to that it's stated, oh, sorry, again, it is in here. I apologize. I think you put that in there. Sorry about that. I just couldn't find it. You stated in that article that one of the suggestions that you have for kind of dealing with DNA evidence is to treat it like any other evidence, pull it from the realm of science and demystify it as much as possible, treat it as a set of facts that could be rationally described in an alternate context. Does that sound like something you wrote?
That might have been a sentence I wrote or my co-author, but I think I remember reading that in there.
And that the defense team should effectively identify and present a plausible explanation for the DNA evidence and then use that to support the alternate hypothesis.
Yes, that's a possibility you can do, is look at not just one alternate, but any of the many alternate explanations for what the evidence is showing us and present that as a possibility to the jury. Yes.
And that's pretty much, I mean, what you're doing here with the realm of possibilities of transfer DNA, right?
Yeah, there is a realm of possibilities as to how DNA can get moved from a person to an item or from an item to an item.
And that's, would be following along the lines of the recommendation to try to offer some plausible explanation. Is that right?
Yes.
On your CV here, you talk about the number of cases you worked on in the crime lab, right?
Yes.
Yeah, I think we clarified here today that you don't currently work in a crime lab, right?
No, I do not.
Unless you have one in the basement of your house.
No.
You ever thought about that?
I don't have a basement.
Oh, must be a New Mexico thing, huh?
Yeah.
Yeah, okay. So, also, you don't actually even have a current certification to do lab work, right?
No, there's no certifying body for independent forensic DNA consultants.
And so it's been a long time since you've done what I think you've referred to before as the wet work, right?
Yes, it's been 12 years since I've done any hands-on work with DNA or any kind of typing, body fluid identifying, anything like that.
And you've testified in a total of 135 criminal proceedings?
Yes, this would be 136 today.
No, congratulations. And that the first 16 you did for the prosecution, but the rest of them you've done for the defense, right?
That's correct.
And you also do some presentations at conferences for various defense attorney and public defender groups, is that right?
Yes.
Is that kind of like marketing? Like what I can do for you? Or?
I'd call it's CLEs. It's continuing education for them, and to a degree it's marketing. That's, as I mentioned in direct, the only people who've called me so far have been defense lawyers, public defenders, or sometimes private citizens, never prosecutors. But I could educate prosecutors if they asked me to.
Appreciate that.
What'd you say?
I said appreciate that. Right. So most of your work, I mean, it sounds like it's done for criminal defense attorneys, though, obviously, right?
Well, since they're the only ones who call, yes.
And you can correct me if I'm wrong with this, but you're more of a document review guy and less of a hands-on guy, right?
I'd say I'm not at all a hands-on guy. There's no hands-on work involved except for handling the documents.
Nothing further at this time, Your Honor.
Redirect Mr. Spies.
Yes, thank you. Dr. Spence, you were asked about providing plausible explanations. You don't just get on the stand and make stuff up, do you?
Oh, absolutely not.
I mean, the explanations that you've given the men and women of the jury in this case, and you would in any case, is based on the evidence that you understand is present in that case.
In part, the evidence that's in the case, but also the scientific reviews on transfer events, for example, and real cases where there are transfer events.
Could you give us an example of a transfer event that's a real case?
Yes, I can. I know of a case that's in my book chapter that is a California man who was a victim of a homicide. There was a home invasion. The people who came in were masked, and they bound up a couple of victims, but one of the people who was bound up was a man who passed away from suffocation. He was bound up too much. They found on the fingernails of that victim a DNA profile, and they ran it through the CODIS database. This is a database for searching for if that person's out there, and there was. There was a person who pretty much resided downtown in California, in San Jose, who was an alcoholic, homeless, and who was on the CODIS database. He's there on the fingernails of a murder victim, so they charged him with being part of that group that broke in. The defense looked at the case and realized that the night of that break-in, this person had drank too much, like he often did, passed out in a convenience store, and was taken by paramedics into a hospital and was there the whole night. And it was all during the whole time that the home invasion occurred, which was in the home of a millionaire who lived 10 miles away. So they knew there was no, unless there was something wrong with the record keeping, there's no way he could have been there, and they verified all that. And it wasn't until a prosecution's investigator looked more closely at the case and realized that the two paramedics who delivered this homeless man into the hospital were the same two paramedics who 3 hours later were called out to the crime scene to tend to somebody that they had no chance of resuscitating. They handled him, put him on a gurney, and took him out. So they handled the same homicide victim as the person who was accused, but there's no way that person could have been at the crime scene.
And the DNA of the homeless person was found on the hands of the crime victim?
On the fingernails, yes. A full profile that was qualified for CODIS searches and identified him in that way.
So taking into account all of the factors about which you've been questioned that affect the transfer of DNA from one location to another, from one person to another, friction, duration, type of surface, the type of event, whether it's liquid or dry, humid or not, whether the person is a shedder or not, is it, Dr. Spence, a plausible explanation that the DNA of Jerry Burns found on the dress or on the gear shift could have come about by a transfer?
Objection, Your Honor, that is speculation. There's no evidence in the record to suggest that, and no foundation to make that opinion, expert or otherwise.
Any response to the objection?
This is directly related to the questioning during cross-examination.
The witness will be permitted to respond, answer the question, the hypothetical question. And ladies and gentlemen of the jury, you will be instructed that with an expert witness, as with any other witness you've heard from, it's up to you to assess the weight and credibility for any testimony that you hear. But the witness will be permitted to answer the question, if you can remember.
Probably not. If you could please give me the question again, Your Honor.
Just 1 second.
If our court reporter could assist, please.
Okay. Yeah, go ahead.
Question, so taking into account all the factors about which you've been questioned that affect the transfer of DNA from one location to another, from one person to another, friction, duration, type of surface, the type of event, whether it's liquid or dry, humid or not, whether the person is a shedder or not, is it, Dr. Spence, a plausible explanation that the DNA of Jerry Burns found on the dress or on the gear shift could have come about by a transfer?
Yes, that's a distinct possibility.
Now, you've told us that you can't always know the sequence of events that precede the snapshot about which you've testified, which is oftentimes all that the forensic scientist has left is that snapshot, right?
That's always what they have, is the snapshot of what's there at the time that they take their cuttings and they look at what's there.
And you've identified for the men and women of the jury and for us the danger of transfer, especially when items are bundled up. An item can be transferred within an item, between items. It's always a risk, isn't it?
That's a distinct possibility as well.
Even though you were not a crime scene technician, nonetheless, did you have to be informed about and most of all professionally sensitive to what happens at a crime scene to know about how well an item was retrieved, cataloged, preserved, handled?
Yes, very much so. The communication there is extremely important, and I was looking at the items that they did collect from the crime scene. That's typically what I was going to be doing, is looking at the more movable items that you can handle on a bench top.
And finally, Dr. Spence, the questions you were asked about the .062 concentration that Linda Sauer found in 2005 on item F5, you said that it tells you a lot about the amount of DNA that she was able to isolate and test. Am I right?
Yes, I did.
And were you able to deduce from that amount of DNA the likelihood of the male profile coming from blood versus some other biological source?
Well, I'd say it's less likely, only because it would have to be such an incredibly tiny amount of blood that was drawn up into that extraction off that cutting. As I stated, I think earlier, it would come down to about 1/800th of a single drop of blood.
And of the many articles about which you were questioned this morning, Dr. Spence, do any of those articles, the research that you're familiar with, shake the confidence with which you testified today?
Not at all.
Thank you.
Additional cross-examination, Mr. Maybanks.
Yes, Your Honor. Dr. Spence, when you were asked the question by Mr. Spies whether an explanation was plausible, you said it was a distinct possibility, didn't you?
Yes, I did.
Okay. Which means it's in the realm of possibilities we talk about when we talk about transfer of DNA, right?
Yes.
But you're not opining, again, in this case, that you believe that a transfer of DNA from Jerry Burns to Michelle Martinko took place in some sort of secondary, tertiary fashion.
I don't believe that the transfer did happen, or I don't believe that the transfer didn't happen. It's impossible to tell from that snapshot and all the information we've talked about here in the last couple of hours.
And that was a really fascinating and interesting story that you told about what happened in California. It's a good thing that the steps were retraced in that case. In this case, would you agree that based upon your analysis of the case that you didn't find any evidence whatsoever putting Jerry Burns in a position to transfer DNA other than speculating or creating events that took place?
Yeah, well, I refuse to speculate up here, and it would be incredibly difficult to do so, especially with a 40-year-old crime.
Thank you. Nothing further.
Additional examination for Dr. Spence.
No, Doctor, I think you answered the question. It's extraordinarily difficult to reconstruct what happened 40 years ago, isn't it?
Absolutely.
Thank you.
Okay. Anything further, Mr. Maybanks?
None necessary, Your Honor.
Okay, very good. Thank you, Dr. Spence. You may step down.
Thank you.
Defendant may call his next witness.
Your Honor, we have a matter we'd like to take up with the court
Okay,
outside the presence of the jury.
okay, very good. Ladies and gentlemen, we will adjourn for lunch, and we'll have you come back at 1:30.
All right, so that concludes Dr. Spence's testimony. So we picked up with cross of Dr. Spence, and all I got out of that hour was basically Dr. Spence solidifying the case against Jerry Burns. He talked about the transfer of less than 1%. Friction and duration play into transfer. He was shocked that DNA wouldn't be visible if the struggle that what is being told happened. He said there was a real good chance for DNA if the suspect is cut. He said there was absolutely certain he was absolutely certain that DNA would be present, in this kind of attack. And again, it's like he's talking about transfer of DNA, and I'm like, was Michelle like, there was male DNA found. So it was Jerry's DNA. So where did they make that connection? As a defense, how can you argue it's Jerry's DNA? They've established that beyond reasonable doubt. And then they get this expert saying it has to be, friction, it's a transfer, duration. How else is this DNA supposed to be on her? And then the gear shift. I mean, it's just not, I didn't get this. I didn't get the point of this at all. Yeah, then he makes him do the calculation. That was good. He made him pull out his calculator, or his cell phone made him do a calculation. He wrote an article, If DNA, Then Guilty, basically. But then I think it was more like to how to talk to a jury and say that's not necessarily the case. Although, come on, I mean, it's DNA. How can you fight DNA? Redirect, you don't just get on the stand and make things up, do you? So this was defense coming back. He said, no evidence of the case and signs on transfer events. Talked about this California man who was a victim. I thought that was pretty interesting, though. So this guy was a victim. He got tied up, and then the EMTs dealt with some homeless man, and then they came over and they had DNA was transferred onto that guy. So I thought that was kind of interesting. Jerry's DNA transferred to the dress and gear shift is a distinct possibility. I mean, again, and that was the defense asking their own witness. Was it a distinct possibility that that's Jerry's DNA? And he's like, yes. He can't determine what preceded events before a snapshot is taken. And then Cross came back up, Maybach. It's impossible to tell where or when the transfer happened. And then he's like, fascinating story you told there. And I thought that was a little bit snarky. All right, so this next one is only a minute. So something happened. So let's just check this out real quick. Something happened. And then we'll go to day 8. But something happened because this is only a minute long. So I don't think Mr. Spees was able to pull up. All right, here we go. All right, again, this is only a minute, so it's going to be quick.
The record should show that the jury has rejoined counsel and Mr. Burns in open court after the noon recess. At the conclusion, we had just finished a witness for the defense. Mr. Spees, do you wish to call any additional witnesses?
Your Honor, the defense rests.
Okay. Based upon the evidence has been submitted at this point. The state has an opportunity to present any evidence they feel is necessary to present in terms of a rebuttal. And in order to give them an opportunity to make that determination, ladies and gentlemen, we are going to adjourn for the day. I apologize for sending you out for lunch and then having you come back. We can't always forecast how these things are going to proceed. But we will adjourn, and we will return tomorrow at 9 o'clock. And You are free for the rest of the day, but please, again, bear in mind that admonition that prohibits you from discussing the case amongst yourselves, with friends or family members, from looking at any media coverage, should there be any. Don't make up your mind. Potentially you haven't heard all of the evidence. You may have, but you may not have, so stay tuned. But we'll see you back tomorrow morning at 9 o'clock. Okay, thank you, folks.
Please rise for the jury. You can leave your notebooks on your chairs.
Well, that's why it was only a minute, because the defense rests. Did not see that one coming. Holy smokes. Wait, I just saw somebody in the chat. Please tell me, Seinfeld started it? Hello. Please respond to that. Seinfeld started it. That's really funny. Are you guys all from RA? Is that where this is all coming in from? That's hilarious. All right, so defense rests. Wow. All right, so then rebuttal is coming up. Defense rests. All right, let's get to rebuttal. Defense rests. Let's see, defense rests. All right, so this next clip, Sinbad's beef. I have laid back law on my TV. They're supposed to be honoring Jeff, but it's turned into a political argument. Yikes, glad I'm hearing. Oh, that's too bad. Yeah, politics, man. Oh, wow, I got to kill that son in a second. Politics are just keep it somewhere else. It's definitely not coming into this chat, just so you guys know. Just telling you that right here and now. All right, so we are going on to day 8, and this is state's rebuttal. So let's hear what they got. Oh, Rafa, what do you got there? All right, hold on.
Are you still on? Chris,
Yes,
your mic is still on.
I know it is. Okay, good boy. Yes, my mic is still on. Hot mic. All right. State's rebuttal. Got the old sun coming through here. All right. So this.
Good morning.
Oops. All right, hold on there. Do we have closed captioning? Yes, we have closed captioning. Okay, I'll see you guys on the other side. And thank you all you new people that have joined us. Jerry, what or Seinfeld? Seinfeld started it. I love it. Thanks for being here, guys. Appreciate it. And Red Pen's resentments. There was another good one. Oh, Sinbad's beefs. That you changed that one. I hope Erin's feeling better. Yeah, she's fine. I'm finally on the upside of the cold. Aw, I'm glad you're feeling better, Red Pen. All right, see you guys on the other side.
Good morning, members of the jury. Happy Friday. We have, you heard yesterday that the defendant has rested his case, and at this point, Mr. Maybanks or Mr. Harris, does the state wish to present any rebuttal evidence?
Yes, Your Honor. The state calls Paul Bush.
Okay. You're headed right across over here to the chair with the red seat. Before you take that witness chair, please pause and raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead and be seated. There are just a couple of expectations in the courtroom, Mr. Bush. I'll just remind you. It's important that you allow the attorneys to finish a question, even if you have an idea where the question is headed. Please let them finish, so that the idea is that only one voice speaks at a time. I will ask them to give you the same courtesy of waiting until you have finished your answer before they ask the next question. Also be aware of that microphone. We have that there so that we can hear you. And please tell us your full name and spell your first and last names.
My name is Paul J. Bush, spelled P-A-U-L, Bush, B-U-S-H.
Thank you. You may conduct your examination, Mr. Maybanks.
Thank you, Your Honor. Paul, what is your current occupation?
My current occupation is a criminalist supervisor with the Iowa Division of Criminal Investigation in the State Crime Laboratory.
I want to ask you a little bit about your background. First of all, can you tell us your educational background?
My formal education consists of a Bachelor of Science degree with double majors in chemistry and biology from Morningside College in Sioux City. With that, I also possess a secondary education teaching certificate and coaching endorsements. I also possess a Master of Arts degree in biology from Drake University. That master's degree was a thesis-based program.
Now, I want to ask you a little bit about your the background, your employment background. How long have you been with the DCI Crime Laboratory?
I've been with the DCI almost 38 years.
And you told us just a bit ago that your position was criminalist supervisor, is that right?
That's correct.
Okay. Can you tell us about that position and what your current duties are?
As far as that position is concerned, I've been the criminalist supervisor for almost 10 years. That position involves the overseeing of 20 DNA members or staff members in that section, which includes 16 DNA criminalists and 4 forensic science technicians.
What other positions have you held with the DCI Criminalistics Laboratory?
Prior to that 10 years, I spent a previous 10 years as the DNA technical leader of the DNA section of the laboratory.
And what is that involved?
That technical leader position is a position that oversees the actual day-to-day operations of the DNA testing. So you must monitor all the different procedures and policies that are in place when doing DNA testing. And if there are any problems or situations, the DNA technical leader's responsibility is to resolve them.
Does that encompass, I guess, what some of us would understand as a quality control type of position?
Yes, that is a major function of that DNA technical leader's position, is to monitor or see that the quality control measures are in place.
So you're currently the criminalist supervisor, and previous to that, you were the DNA technical leader. What other positions have you held with the DCI Criminalistics Laboratory over that 38 years?
During those 38 years, I also served as a crime scene analyst in the laboratory for at least 25 years. I did what was called crime scene investigations around the state.
Can you tell us what that involved?
Our crime scene investigation in the crime laboratory involves the analysis and collection of physical evidence at crime scenes. Typically, for the DCI to be involved, we have to be invited by a local law enforcement agency to assist them, typically with a death investigation. And again, typically we don't do, say, Davenport or Waterloo or Sioux City, the large law enforcement agencies. We usually help the smaller law enforcement agencies that would not have the staff and the expertise to perform those types of analyses. So when you would be at a crime scene, you would be collecting physical evidence in the case, documenting that crime scene through photographs, sketches, and then collecting any types of physical evidence that you deem necessary to help solve that crime.
I'll take you back in time to 1982, and when you first came to the DCI laboratory. Tell us, if you would, kind of how the use of DNA developed and, maybe what preceded that.
Again, DNA really did not come into play in the Iowa DCI crime lab till the mid-1990s. In the 80s, what we did was called conventional serology. And what we were doing at that time was trying to identify stains using what would be known as the ABO typing system. That was one of the major ones. So you can be, most of you know about your ABO type A, type B, type AB, or type O, and we would attempt to type individual blood stains based on their ABO type.
And then you said that DNA came into play in the mid-'90s, is that right?
That's correct. Research was going on in the late 80s, early 90s. That was actually my thesis program, was developing some procedures in that arena. But again, our crime laboratory did not come online till the mid-90s.
And what kind of DNA forensic analysis did the crime laboratory start performing in the mid-'90s?
In the mid-'90s, we were doing techniques called the HLA, DQ alpha, polymarker, and D1SAD DNA tests.
That was a lot of words there. What is, I mean, can you describe for us in a nutshell what that encompassed?
When we first started out, we were doing a procedure, again, that is different than what we are doing today, but it was the technology that was available at the time. It was using what was called a PCR, or polymerase chain reaction-based technology, which actually was really the, I'd say, the breakthrough in DNA molecular biology, in that you theoretically can start with a single copy of DNA and can make additional copies. So you would start out with one, go through this thermal cycler. It's just like a photocopier. So you go 1 to 2 to 4 to 8 to 16, and by the time you have run that through 30 cycles, you've got between 1 million and 1 billion times more DNA than you started with. So that was the start of that technology. We used at that time this polymarker system, or DQ alpha system, where had DNA actually probes and things that were actually on little strips of nylon paper, and then you actually put the extracted DNA on those strips. Very rudimentary, but that's what we started out with back in the mid-'90s.
And then we've heard in this case that that technology substantially improved even by the early 2000s when the evidence was tested in this case.
Yes, that's correct.
So, Paul, can you give us an idea of what kind of specialized training, just some highlights of what kind of specialized training you received in DNA forensic analysis then that led through those developments and whatnot?
I've had numerous courses around the country, many from the FBI Academy in Quantico, Virginia, on DNA analysis methods, quality control methods, auditing procedures for DNA. I've had coursework from what's called CEDAS Corporation out in Emeryville, California, on DNA analysis. I've been to dozens of workshops and presentations on DNA analysis throughout the country through either the American Academy of Forensic Scientists, the Midwest Association of Forensic Scientists, and then, again, specialized courses that I've taken throughout the country over the last, again, 30-plus years.
What kind of certifications, if any, do you have in the area of DNA forensics?
I am currently a diplomat with the American Board of Criminalistics. This is a national accrediting or certification organization that accredits people in different areas of forensic science.
And are you proficiency tested?
Yes, I am also proficiency tested twice per year in the areas of forensic DNA analysis and what we would call database DNA analysis.
What kind of specialized training have you had in the area of crime scene investigation?
As far as crime scene investigation, I had coursework through the Iowa Law Enforcement Academy out in Johnston, Iowa, on crime scene investigation. I worked many years with a senior member of the staff who had dozens of years of experience as a crime scene investigator. They were actually special agents. And then just my knowledge and expertise that I learned throughout the laboratory in doing, at that time, serological testing and DNA testing.
Paul, would you be able to give us an estimate of approximately how many crime scenes you have personally worked on or in the past 25 years?
As far as crime scenes, I would guess I did in excess of 200 crime scenes cases during my tenure.
Have you qualified as an expert in crime scene investigation in court?
Yes.
Through that experience and that training, did you also receive training and experience in the proper care, handling, and collection of items of evidence at crime scenes to submit to the laboratory?
Yes.
What kind of training did you receive in that area?
So that training, again, involves collection and preservation of evidence. Packaging is obviously very important in collecting crime scene evidence, that you don't either cross-contaminate items or allow external evidence or external materials to come in contact with your crime scene pieces. So packaging is very important, so you don't allow, again, transfer from material outside the crime scene onto that evidence or between items of evidence.
In your career, how many cases do you believe that you have worked with that included the examination of items of evidence for the presence of DNA?
I would guess approximately 900 cases that I would have tested over my career for DNA analysis.
And do you also conduct review of your, through the course of your career, of your peers and now the persons that you supervise in their work?
Yes, I also perform technical reviews of, actually I have thousands of cases over my career. One of the requirements of DNA testing and reports is that every DNA report be technically reviewed by another qualified DNA analyst. So that is, again, one of my other additional duties as supervisor.
And throughout your career, have you performed DNA analysis in a variety of criminal investigations?
Yes.
Are the analysis methods that have been used over the course of time with the DCI Criminalistics Laboratory and the ones currently used generally accepted and used by other forensic DNA laboratories across the nation?
Yes.
And have you testified before as an expert in forensic DNA analysis?
Yes.
Can you go over with us the current certifications that the Iowa DCI lab has?
Currently, our laboratory is accredited through what's called ANAB, and I gotta get that acronym, what that stands for, which is the American National Standards Institute National Accreditation Board. So one of the things about any forensic laboratory is that today you should be, or actually for a state crime laboratory like us, you have to be nationally accredited by an accrediting agency if you are going to maintain DNA samples and upload DNA samples to what's called the CODIS database. So they require that our laboratory be accredited and follow national accreditation standards.
May I approach the witness, Your Honor?
You may.
Be handing the witness what's being marked as State's Exhibit CV5. Paul, can you tell us what that is?
Yes, this is called a Statement of Qualifications document that I have to maintain in the laboratory that has all my education and I want to say all my experience and training that I have had throughout my career with the DCI Crime Laboratory. It's basically like a scientific resume.
And does that contain a fair and accurate and current update and rundown of your qualifications to testify as an expert, both in DNA analysis and in crime scene investigations?
Yes.
Move to enter State CV5, Your Honor.
Without objection.
CV5 will be received and made part of the record.
And where on this CV, Paul, would we be able to find reference to some of the various trainings that you've had in DNA forensic analysis and crime scene investigation?
So after you go past the first half of the first page, there are 1, 2. There are 4 pages listing kind of chronologically of all the courses specific to forensic science that I have taken over the years.
Does the statement of qualifications there in CV5 also have a rundown of various courses or trainings you've had in crime scene investigation?
Yes, it should have it included also.
Paul, have you had an opportunity to review the entire case file of DCI number 85-6117, a homicide that was investigated by the Cedar Rapids Police Department in which the victim was Michelle Martinko?
Yes.
I want to ask you some questions about some of the testimony that was received yesterday by a Dr. Spence. Yesterday, we heard about the scientific theory of secondary transfer of DNA and what Dr. Spence referred to as the realm of possibilities for secondary transfer to occur. As a career criminalist, having spent your entire career working in some capacity for our state laboratory, from a scientific standpoint, to come to any conclusion as to whether secondary transfer took place, what do you need to know?
Typically, in order to make that assessment, you typically need a scenario as to what happened or what took place. So if I don't have a scenario like, someone was stabbed or someone was shot and where it happened and the circumstances surrounding the case, it would be very difficult to come up with possibilities for secondary transfer. It could be, anything. So typically what I would want to do if I'm going to make that attempt to determine if secondary transfer could have taken place is I would typically want a scenario as to if we said this, this, and this happened, where could you have possible secondary transfer? Otherwise, it could be anything.
Would that scenario also need to include what factors were present that would allow transfer to take place?
Yes, that's correct.
We heard about in court yesterday, Dr. Spence acknowledged in an article that he used to prepare for his testimony that there are numerous factors that could contribute to the manner in which DNA could be transferred that are important. Is that your understanding of the literature too?
Yes, that's correct.
And otherwise, if you don't have that stuff, would you really be put in a position as a scientist to just make a guess?
Yeah, otherwise, yes, you would just be guessing as to the possibilities of secondary transfer. And so we try and use, factual information or scientific logic when attempting to make these determinations. And if I don't have any scientific information to draw a conclusion, it becomes very difficult.
In your experience and according to your expertise, Paul, with all the cases you've worked on over the years, how common is it in what's reported to you as a stabbing incident where the victim sustained multiple stab wounds and there was evidence of a struggle that the assailant also sustains an injury that leads to active bleeding?
I would say it is not uncommon for a suspect in a stabbing case to actually injure or cut themselves if the victim is fighting back. It's, again, not uncommon for that to happen. We many times will detect the suspect or assailant's DNA, say, on the handle of the weapon.
In the situations in which you've worked, do you also detect, or the situations where you also detect the suspect's DNA on other areas of the crime scene, including the area where the crime took place or the victim's clothing?
Again, that can also happen, again, if there's a struggle and there is a struggle taking place between victim and suspect. If the suspect injures themselves, there can be that transfer of suspect's DNA onto the victim's clothing or to the crime scene.
Paul, based upon the findings in this case that you familiarized yourself with in your vast experience with our crime lab, what is your opinion as the most scientifically supported theory as to how the blood of Jerry Burns ended up on this dress?
Excuse me, I object to that question. That foundation is inaccurate. There's been no testimony that the blood of Jerry Burns is found anywhere at this crime scene. So the hypothesis for the foundation of this question is inaccurate. It's false, and I object on the foundation grounds, and is additionally calling for an opinion and conclusion that's not properly the subject of an expert opinion testimony in this case. Additionally, it's prohibited by Rule 5.403.
Response to the objection, Mr. Maybanks.
I beg to differ, Your Honor. There is ample and overwhelming evidence, given the state's presentation of testimony in this case, that Jerry Burns' blood was at the crime scene on Michelle Martinko's dress. We dispute that, obviously. In lieu of the testimony that was elicited by the defense yesterday as to directly, I believe Dr. Spence was asked if it was his opinion that Jerry Burns' DNA or suspect DNA that was located was on Michelle's dress from a cutting incident. He offered the opinion that he didn't believe that was possible, and offered his reasons thereof. This is a proper area of expert testimony, a very proper area of expert testimony, because it's directed at what would be a scientifically supported theory based upon this witness's review of the file. And the rules of evidence, I think it's in 5.700, I don't have the exact one now, but allows an expert to testify to an ultimate issue if foundation's laid.
Five point 704,
Thank you, Your
counsel.
Honor.
Further argument, Mr. Spees.
Your Honor, I can respond in detail about this. The testimony in this case has been from Linda Sawyer, that she could not say that the source of the spotted F5 came from blood. The same testimony came from Mike Schmidt, a criminalist from the Iowa Division of Criminal Investigation, who was under the supervision of this witness. Dr. Spence said that the DNA profile based on the extraction made by Linda Sawyer was not sufficient to say that it was blood. So to have this witness characterize it as blood, or the prosecution to characterize it as blood, is highly prejudicial.
Further argument, Mr. Maybanks.
Your Honor, just to state that that certainly is the defense's take on the evidence and what they were able to garner in terms of a concession by the witnesses, but no witness here has said that based on the screening test indicated for the presence of blood and their DNA analysis that wasn't Jerry Burns' blood. In fact, all the evidence points to that.
Mr. Maybanks, I'm going to ask you to rephrase the hypothetical, framing it in terms of Mr. Burns, or a profile that's consistent with Mr. Burns' DNA.
Okay.
Your Honor,
Oh,
may I have a ruling on my objection, please?
the specific ruling as to whether this is an appropriate subject matter for Mr. Bush to testify, to give an opinion?
I objected on foundation grounds. I objected on another proper subject of opinion testimony, and because it mischaracterized the evidence.
Okay.
And I have to insist on a ruling on the objection, Your Honor.
Okay. Based upon the questions put to Mr. Bush, the fact that he has reviewed the case file, and given the work that he has done as a DNA, or in DNA analysis, as well as a supervising criminalist at the DCI, I find that there has been a proper foundation in terms of the items that he has reviewed in formulating an opinion with regard to the subject matter, given the testimony that members of the jury that we all heard yesterday from Dr. Spence in terms of a secondary transfer as being an explanation for DNA material found at the F5 location on State's Exhibit 7A, or on the dress, if I don't have the exact exhibit number, that the subject matter is appropriate. And I apologize, the third ground, Mr. Spees, foundation subject matter.
Yeah, and I said it mischaracterized the evidence in this case, characterizing what was found on F5 as the blood of Jerry Burns, and that was precisely how the question was phrased to the witness.
And I have asked Mr. Maybanks to rephrase that hypothetical using the terminology that has been used throughout the trial by the various experts in terms of a DNA profile that is consistent with and that cannot exclude Mr. Burns as a contributor rather than characterizing it as Mr. Burns' blood. Is that inadequate? Do you feel that that's an adequate
Well,
ruling?
am I taking it, Your Honor, then that you're overruling my objection?
Correct. Yes.
Then I'd like to be heard outside the presence of the jury, please.
Okay. Ladies and gentlemen, we are going to be in recess. I can't tell you, I can't think it's going to be more than 20 minutes, but we will be in recess. Please bear in mind that admonition.
That was funny. All right, so so the objection was foundation, subject matter, mischaracterization of what was found, and she's like, "Does that adequately address your objection, Mr. Spees?" And he's like, "So what was the ruling? Are you overruling?" Correct. All right. So Paul Bush has come in. He's the criminalist supervisor. Let me move off of Michelle. She doesn't deserve to have me over her. So he basically, he's quality control. So he monitors, makes sure quality control measures are in place. He's a DNA tech leader. He was talking about the realm of possibilities of the transfer. From a scientific standpoint, you need a scenario as to what took place and the circumstances surrounding the case. Common sense, obviously. You can't just come in and say, "Oh, this happened." You have to know what, who, what, where, why, when, and all that stuff. It's not uncommon for a suspect to be cut in a stabbing case. DNA, they find DNA on the handle of a weapon. Think about that, of course. Again, common sense. Transfer could happen to clothing or a crime scene during a struggle. Again, this is all leading towards Jerry's DNA was found. I just don't see how they're going to get out of this. And then the objection, foundation, subject matter, mischaracterization of what was found. And then she overruled. So this next bit is a minute. So, well, it's like a minute 57 seconds. So I'm not going to talk here. And then the next one is 56 minutes. So I won't talk. After that. So we'll do this quickly.
Please be.
Okay, so again, this is only like 2 minutes. I'll see you, I'll not see you on the end of this, then I'll play the next one, which is 56 minutes.
Please be seated, everyone. The record will reflect that counsel, Mr. Burns, as well as the jury have returned to the courtroom after a brief recess. We have heard the rebuttal case from the state of Iowa. Mr. Spees, does Mr. Burns wish to present a surrebuttal case?
We do not, Your Honor.
Okay. At this point, ladies and gentlemen, the evidence has been submitted to you. There are matters.
Okay, sorry guys, I got that out of order. So that was out of order. That was out of order. You're out of order. Squeegee, you're out of order. Okay, let's get to this. So I played that out of order. Squeegee is out of order. Okay, I will see you on the other side of this.
Please be seated. The record should show that members of the jury have rejoined us in open court. Ladies and gentlemen, as we proceed with testimony from this witness, I am instructing you to disregard the phraseology used, the specific language used in the initial question put to Mr. Bush, in that it called for an opinion regarding how the defendant's blood came to be located on a piece of evidence. My recollection from the testimony we've heard, and you will certainly rely on your recollection of the evidence, is that none of the experts could definitively say that the material found on certain items of evidence came from blood. They could not exclude the possibility that it arrived at its location, and they could not exclude the possibility that it was caused by saliva, sweat, skin cells, or semen. So I've asked Mr. Maybanks to rephrase the question for Mr. Bush. You are the judges of the facts. It will be up to you to determine the facts of the case that you find to be credible in rendering a verdict in this case. So I would ask you to rely on your recollection and the notes that you've taken. And Mr. Maybanks, if you would please rephrase and repose a question to your witness.
Yes, Your Honor. Paul, based upon the findings in this case, what is the most scientifically supported theory as to how a DNA profile consistent with that of Jerry Burns to a probability of less than 1 out of 100 billion unrelated individuals would be expected to have the same profile found at F5 location that tested positive upon screening for the presence of blood, how that ended up on Michelle's dress?
Again-
I object to the form of the question, Your Honor. There's no foundation established to show that this witness has been informed about all the characteristics, the factors that could lead to that possible conclusion. It's not properly the subject of an opinion, either lay or expert in this case.
Mr. Maybanks, response to the objection.
This witness has testified that he's reviewed the entire DCI lab case file, and that he has had access to that, and that his opinion in this case is based upon his review of the file, as I posed in the question, based upon the findings of this case. Therefore, based upon his qualifications that he's testified to here this morning that are undisputed as to his being able to offer an expert opinion on the science behind this, and then again, as in direct response to opinions offered by Dr. Spence, that he certainly has the foundation to be able to answer this question.
Your Honor, if I may,
You may.
I would also urge that the question calls for an opinion that is properly reserved to the jury. It invades the province of the jury, calling for an explanation that is an indirect supposition about the guilt or innocence of the accused. So it's not properly the subject of an opinion.
Any further record, Mr. Maybanks?
No, Your Honor.
Based upon the expert testimony that we heard from Dr. Spence yesterday, it is proper for this expert to give his opinion regarding the presence of DNA material consistent with a profile developed attributable to the defendant. Given the fact that we heard testimony about the possibility of transfer being an explanation for that DNA, the presence of that DNA. So that portion of the objection will be overruled. Given the fact that Mr. Bush has had an opportunity to review the case file and all of the documentation submitted with not only the physical evidence, but the reports submitted to the DCI for processing the physical evidence in this case, I find that there is a proper foundation for the expert to give his opinion. And finally, under Iowa Rule of Evidence 5.704, an expert is able to give an opinion even regarding the ultimate issue. I'm not making a finding that any opinion about the presence of genetic material at the location we're discussing at this point is the ultimate question of guilt or innocence. I'm not making that determination, but given the testimony that this jury and this courtroom heard from Dr. Spence regarding possible explanation of that genetic material in that location, it is appropriate for this expert to give his opinion in the state's rebuttal case. So those three, the foundation is overruled. I'm finding that there isn't an invasion of the province of the jury if this witness is able to give his opinion. And lastly, that it is proper for Mr. Bush to give an opinion as an expert in the state's rebuttal case, given the evidence that we heard from Mr. Burns' expert yesterday, Dr. Spence. And again, ladies and gentlemen of the jury, I've reminded you a couple of times, and I will instruct you when we get to that portion of the trial, that you are the finders of the facts. You are the judges of the facts. I will give you the law that applies in this case, but you are the judges of the facts to make the determination what facts you find to be credible and on which you will rely to deliver your verdict in this case. So those objections will be overruled. And if you can remember the question, Mr. Bush, you can answer it. Otherwise, we can have it read back, or if...
It's up to Paul.
I believe I can answer.
Okay.
Based on the facts of the information that I had relative to this case, that Michelle Martinko was stabbed to death in a vehicle, that it appeared that there had been a struggle based on defense wounds, that again, the fact that if there is a struggle, that an individual could injure themselves, the assailant could injure themselves, especially in a stabbing case, that again, that screening tests indicated the presence of blood on stain F5, which is on the back of that dress. A DNA profile, a major male DNA profile, was developed on the back of that dress from F5. That profile, again, was consistent with the known DNA profile of Jerry Burns. A likely explanation would be, again, that we had a single source, a major male profile on that stain F5, that a likely explanation would be that it would have come from blood. Again, I want to reiterate that our laboratory did not test for any other biological fluids in this case, so did not test for saliva, did not test for skin cells, which we can't anyhow do, did not test for semen. But again, based on the information that I have, that would be a likely scenario as to how Mr. Burns, or how that profile that matched Mr. Burns was detected on that stain F5.
Paul, so obviously, as suggested by some of the evidence in this case and questioning in this case, as you just referred to, there's been suggestions that the areas that tested positive for blood on F5 could contain actually other bodily fluids. But to be clear, do the results that you reviewed in this case affirmatively show that there was blood at these locations?
Again, we can't say that exactly confirm that there was blood. The screening tests indicated the presence of blood on stain F5. And again, the major profile developed was a male profile.
And was there any evidence that confirmed the presence of any other bodily fluid?
Again, there was no other testing that was performed that would have indicated any other biological fluid.
So at this point in time, there's no evidence that confirms, because of the lack of testing, but there's no evidence that confirms there's any other fluid there.
Correct. There was no other evidence to indicate other biological fluids.
Paul, we also heard a statistic, you could call it, by Dr. Spence yesterday, that half of the items at crime labs around the country, or half of the items at certain crime labs, currently have transferred DNA on it. Putting aside for a moment where that came from, my question is, isn't any event that results in DNA being found on an item of evidence a transfer event?
I would say, again, almost every situation where we are testing DNA on items of physical evidence, there is a transfer that has taken place, whether it be victims' DNA transferring to suspects' clothing or suspects' DNA transferring to victims' bed sheets, or suspects' DNA being left at a crime scene. It's typically is some sort of transfer is taking place. They're leaving their DNA somewhere from their body to some other place.
Paul, changing topics here to the packaging and submission of items of evidence for analysis. Your testimony earlier, I think, was that you've worked on over 200 crime scenes. Is that right?
Yes.
Did you participate in the collection and packaging of items of evidence at the crime scenes?
Have I, or excuse me, are you talking specifically or in general terms, or?
Have you specifically done that?
Yes, I have done that many, many times.
And what sort of schools and trainings did you attend that would relate to the collection of items of evidence at crime scenes?
Again, there would have been a Iowa Law Enforcement Academy class that I took on crime scene investigation. I've had coursework through the FBI over the years, some on fingerprints, different types of evidence collection, been to other workshops, and then just training by senior members of the laboratory staff.
Paul, when you actually worked these crime scenes, did you package some items together?
Yes.
And what kind of items would you package together at crime scenes at times?
So sometimes, and again, what we have to realize, and I've done this since 1982, prior to DNA analysis, and then again, post-DNA analysis, but sometimes you would package all victims' clothing together because they were all worn at a certain point in time. This may be done by the state medical examiner's office because they're removing all the clothing at autopsy. So many times they would put all the victims' clothing together. Suspects' clothing, again, could be all put together because they were all worn by the suspect at one point in time. A lot of times, investigators will put together the bedding of a victim in, say, a sexual assault case. They took the fitted sheet, the flat sheet, the pillowcases, and all would put them together in one package.
And at the DCI lab, over the years you've been there, has the lab received items of evidence outside of this case that have been collected and packaged together at crime scenes and provided to you for analysis?
Yes.
And does that also include, for example, victims' clothing or suspect clothing?
Yes. Again, they're not packaged together, but victims' clothing would all be in one package. Suspects' clothing would all be in one package.
You know, for what reasons are these items submitted to the DCI laboratory?
Typically, again, physical evidence such as clothing is submitted to the laboratory to help us solve the case. So typically I would be looking for possibly suspects' DNA on victims' clothing, or vice versa, looking for victims' DNA on suspects' clothing, or on bedding in a sexual assault case, suspects' semen on victims' bed sheets. So again, pieces of evidence that we can test and do DNA analysis to help resolve what happened in the case. There's typically, again, going to be a scenario or facts in the case, and we want to either corroborate or refute a possible story and or put a certain individual at a certain place based on DNA.
So in the event that items are submitted, packaged together of the nature that you just described, is it safe to say the DCI lab does not turn away those items even today?
No, we do not.
And at times do those items also not only come from law enforcement, but from sexual assault nurse examinations?
Yes.
In your experience and based upon your knowledge of the protocol at the DCI lab, would or do analysts ever repackage items submitted to them that were submitted together separately to send them back to law enforcement departments?
Again, the laboratory policy is that we return the items of evidence in the packaging that they were received to us from. So the only time that we would repackage evidence would be if the original package, say, has torn open and we can't get it all back in and get it sealed to a point where there could not be contamination or, again, the garment or evidence would fall out of the package. So if you had a big grocery sack and it rips down the side and things are falling out, we would not want that to go out that way. So we would repackage it. So again, we don't have a possibility of cross-contamination or loss of evidence from that item of evidence.
So what, if any, real concerns exist? Or what, if any issues may occur by packaging items together as far as the transfer of DNA?
So again, with that, what you could have is, say, so you've got underwear, dress, bras, you could have some transfer of materials between those items. But again, as long as they're packaged together and in a proper package seal, you would not have transfer of evidence from outside. So, sack to sack transfer, item to item transfer, or something where, I don't know, it's law enforcement agencies bringing it to the laboratory and it's in the trunk of the vehicle. So as long as the items are packaged properly, you should not have a transfer of physical evidence into that package.
In this case, based upon your review of the file, did the packaging of the items of Michelle Martinko's clothing together prevent the DCI lab from finding a profile consistent with the defendant on Michelle's dress?
No.
And the goal as originally, or the request as originally conveyed to the laboratory to attempt to find the presence of suspect's DNA on Michelle's clothes, in the clothes being packaged together, did you see any evidence of an outside transfer that took place?
Again, as far as the testing that was performed, no other foreign DNA profiles were developed except for profiles that, again, match the DNA, well, I would say the deduced known profile of Michelle Martinko, which was on the dress to begin with, and the only other profile that was developed was a male profile that was consistent with the profile of Jerry Burns.
So you observed no circumstances that showed the introduction of any other foreign DNA into these items?
Again, no other foreign DNA besides these two profiles were detected.
In testimony yesterday, we heard from Dr. Spence that swabbing an area of evidence can sometimes remove bodily fluid from it, but could leave behind DNA. And we saw Defense's Exhibit T1. And so if we could get that available here, and I'll see if I can find it in the exhibits. Can I go to the exhibits in the witness room?
You may.
Well, this is exhibit, Defense Exhibit T1. You see that?
Yes, I do.
Maybe publish that again, Ron?
You may.
And so on this exhibit here published, there's highlighted the portion that refers to F5. And Dr. Spence yesterday, by virtue of his testimony, characterized the amount of DNA present at F5 as, I believe he said, incredibly small or small, and in that it should be bigger in order to find or confirm that the DNA at that location would come from Mr. Burns' blood. Do you agree with that assessment?
As far as F5 is concerned, our analysts did a quantitation determining the amount of DNA that was present on this stain F5. And based on the results that we have here, there was sufficient DNA for us to perform a DNA analysis. What I would say as far as DNA quantitation versus correlation with blood, there really can't be a correlation because different blood stains can have different amounts of DNA. So in background information, the only portion of blood that has DNA in it is your white blood cells, and that is a very small fraction. I'm thinking around 3% or so of the total volume of blood. And so, again, depending on how the blood, again, now we're just talking hypotheticals, how blood is deposited can sometimes vary in the amount of DNA that would be present. So if you have like an injury where it's starting to clot, you're going to have white blood cells that are going to concentrate there because it's helping in that clot and fighting, infection and things. And so you could have more DNA in a small stain that could be actually kind of, I want to say, not so red because there's not as many red blood cells. But again, that can vary dramatically versus you've got like a major cut and say you've cut your wrist and your hand and it's bleeding profusely. That's likely to have a more uniform volume of those white blood cells. But again, it's just going to vary from situation to situation as to how many white blood cells are present in that stain. Also, again, you could have DNA coming from other materials, but it's just going to vary. So basing DNA quantitation on the amount of blood, I say there's not a great, we can't necessarily correlate that as far as based on how much DNA I have present versus how much blood could be present from a stain.
So is this, based upon your testimony then, is this, this number here and this quantitation of DNA meant to indicate at all the amount of blood that would have been present?
No. This, again, information here on F5 is for our analysts to determine how much DNA they need to move forward to perform our DNA STR analysis.
Did you observe, based upon your review of Linda Sauer's work, that there was a need for her to take a larger cutting at that location?
Again, that was not needed. Again, the amount of DNA that was present in her quantitation results here indicated that she had sufficient DNA to move forward with DNA STR analysis.
Based upon that testimony, Paul, and some testimony we heard yesterday about other items that were tested for blood, analyzed for DNA that showed the presence of blood. Is it unusual that some testing of items of DNA where blood was indicated to be present would not result in detecting DNA?
Again, just because you have our screening tests indicate the presence of blood doesn't necessarily mean there's going to be enough of that sample to allow us to get DNA testing. It just varies, again, dramatically on how much of the blood was left or deposited there, the environmental insults that could have taken place. Has it been exposed to high heat, humidity, sunlight, got rained on, or some if it was outside? A lot of factors would go into place here as far as determining whether or not you can get a DNA profile from a sample that you screened positive for blood.
Paul, over your career, have you processed other cases involving evidence from crime scenes that are over 20 or 30 years old?
I would say I have reviewed some cases that are at least 20 to 30 years old. I don't know that I have specifically tested any samples 20 plus years old.
So have you reviewed findings where analysts have been able to develop DNA profiles from that evidence?
Yes.
In order for findings to be developed, such as what was done in this case, resulting in DNA profiles being developed from the evidence, in this case after approximately 26 years, what kind of storage conditions would need to exist for that evidence to be preserved?
As far as this case or any case, in order for us to perform DNA analysis on old evidence, say up to 26 years old, as long as it was collected properly, packaged properly, and stored properly, we can get results on DNA that's decades old. Again, we've done cases over 30 years old. DNA testing can be performed on, mummies and stuff from Egypt. The testing is that sensitive. So as long as it's stored, say, out of sunlight, direct sunlight, away from high heat and humidity, so again, stored, say, at room temperature in a room, it should be stable for future DNA analysis.
Dr. Spence said yesterday that a snapshot of events explains or can explain the presence of DNA, but you can't be sure of the circumstances of how it got there. My question to you first is on how many different areas of Exhibit F, Michelle's dress, did the DCI find areas that indicated the presence of blood?
Based on the information I have from these reports, there were 9 areas where screening tests indicated the presence of blood.
And from those 9 areas, how many female profiles were developed?
Of those 9 areas, 8 of those areas developed female DNA profiles.
And did all of those 8 areas, were they consistent with each other and determined based upon the investigation to be that of Michelle Martinko?
Again, they were all consistent with each other. One of those was initially collected as what we would call a deduced known of Michelle Martinko, since we did not have her known DNA to test. But again, all of those matched our initial F stain from the dress that was used as a deduced known sample.
And from these 9 areas, you testify that 8 of those areas were found to contain one female profile believed to be Michelle Martinko. How many male profiles were developed?
Just one male profile was developed.
And based upon, again, those findings, was that profile developed found to be consistent to the random match probability numbers that we talked about to Mr. Burns?
Yes, that stain, again, F5, the random match probability, again, was consistent with Mr. Jerry Burns' known DNA profile.
And did the DCI lab in this case find DNA from any other person or did they find any other profile in the dress besides these 2 people?
As far as the results, we have no other foreign DNA profiles were detected.
Nothing further, Your Honor.
Cross-examination for Mr. Bush. Mr. Spees.
Yes, Your Honor, thank you. Mr. Bush, you weren't involved in the crime scene investigation of this case, were you?
No, I was not.
And how old were you back in 1979?
Oh, my goodness. I would have been 21 years old.
And you joined the Iowa Division of Criminal Investigation Laboratory in 1982, 3 years later, right?
Yes, that's correct.
And from 1982 until today, how many times have you personally been involved in the analysis, the review of any of the evidence in this case?
Excuse me, could you repeat the question, please?
Sure. From the start of your work in 1982 until today, how many times have you been personally involved in the review of any of the evidence analyzed at the DCI lab in this case?
I would say approximately a dozen times where I have had conversations with investigators in this case and with our analysts.
And over the course of the years in which you become familiar with this case, how many times was the evidence consisting of Michelle Martinko's clothing packaged and repackaged?
I cannot tell you unless I do not have all my evidence notes here to see how many times it was packaged and repackaged.
Do you know how it was handled by the Cedar Rapids Police Department before it even found its way to the Division of Criminal Investigation?
No, I do not.
Do you have any information about how it was labeled by the Cedar Rapids Police Department?
No, I do not.
You didn't do any testing yourself in this case, did you?
No, I did not.
And we've heard testimony from retired DCI criminalist Linda Sauer about the way in which she examined the dress. And you're familiar with that testimony?
I'm familiar with the reports that were generated by Ms. Sauer.
And you're familiar with the efforts that she made at area F5 on Exhibit 7A to, first of all, screen for the presence of blood at F5, right?
Yes,
And she used 2 presumptive tests.
that's correct.
And she was able, as we know, to extract some DNA from F5.
Yes, that's correct.
Would you agree, Mr. Bush, with the testimony of Linda Sauer, the testimony of Mike Schmidt, that it cannot be said whether the male profile at F5 came from blood or sweat or urine or some other biologic source?
That is correct.
So you don't mean to convey to the men and women of the jury that the male profile at F5 coming from Jerry Burns came from blood?
Again, when I testified earlier, I said that would be a likely explanation, but I cannot positively state that.
It's a possible explanation, isn't it?
Yes.
So in your experience in handling crime scenes and in your experience in analyzing and testing evidence that comes to you from law enforcement agencies across the state of Iowa, it is important, isn't it, Mr. Bush, to know how that evidence was packaged before it arrives to you?
Yes, again, the crime scene personnel, whoever submits evidence to us, hopefully have packaged it and collected it in a proper manner.
In fact, we've heard testimony earlier in this trial from at least 2, maybe 3 different witnesses who said that the bundling together or the bunching together of clothing is not good practice. Would you agree with that?
I would say it depends upon the situation of the case. Sometimes, depending on what type of evidence you're looking for.
Well, here we're talking about some very, very important evidence, aren't we?
Yes,
And you've told us that when items are packaged together, there is a risk of cross-contamination between items bundled together, isn't there?
that's correct, between the items that have come in contact with each other that are in that package.
And you were asked questions about the possibility of contamination from outside the packaging, and you didn't see any evidence of that,
That's correct?
so far as you know.
That's correct.
But you would agree, wouldn't you, that when items are packaged together, there's a risk of biologic material falling off one item of clothing and finding its way onto another item of clothing?
Yes, that's quite possible.
You told us that there was no other male profile found in the, on the clothing, is that right?
That's correct. I did not see any other male profiles developed on the dress.
But you've also testified that the only items, the only areas that were screened for the presence of either a male or a female profile were the 9 blood spots found on the dress?
That's correct.
So let me ask you this question, Mr. Bush. Are you familiar with the autopsy findings?
I did not see the autopsy results.
Did you see how Ms. Martinko's body was clothed when it was examined by the medical examiner?
I did not.
Do you know what she had around her neck?
No, I did not.
Did you know that she was wearing a scarf?
I know that there was a scarf submitted with the evidence.
And how many times was that scarf tested?
At this time, I do not know.
Well, it wasn't tested, was it?
I do not see that in the report or the notes.
So you've got a microphone there in front of you. Is your DNA on that microphone right now?
I would say it's quite possible that my DNA is on this microphone.
Well, you were asked by government counsel whether a conclusion can be drawn about the appearance of DNA at various sites at the crime scene, and it's not uncommon, as you said, for a killer to stab himself or herself in a knifing incident. Do you know whether or not a killer looming over Ms. Martinko would have imparted DNA on the front of her dress?
I would say that's possible.
Well, if the killer was breathing heavily or coughing or yelling, would you expect the killer's DNA to be on the front of her dress?
I would say that's possible.
Would you expect male DNA to be on the scarf around the neck of Ms. Martinko?
Again, depends on the scenario or situation.
But we don't know because that scarf was never tested, was it?
That's correct.
And the front of Ms. Martinko's dress was only tested for the presence of blood.
Yes, I believe so.
It was not screened for any other form of biologic material to your knowledge.
That's correct.
Do you know whether the seat of Ms. Martinko's car was screened for the presence of male DNA?
I don't believe it was screened for the, well, just a minute. Where again are you asking about from the vehicle?
Yeah, the seat.
I do not see that evidence was submitted from the seat. I see items submitted from the headliner and the visors, but do not see anything on the seat.
Mr. Bush, you were asked about the presence of DNA in blood, and you gave the men and women of the jury different scenarios about whether the blood was clotted blood, indicating a wound that was healing, and the different configurations of how much red blood cells versus how many white blood cells would be found in a specimen of blood. You recall that?
Yes.
So assuming this scenario, assuming someone had just freshly cut himself or herself, you would expect there would be white blood cells in that blood?
Again, there could be. Again, it could just vary, but yes, I would expect some white blood cells to be present.
So how many white blood cells would you expect to be present in one drop of blood?
Again, I can't tell you that right off the top of my head. I'd have to go back and look at my journals or my human physiology book to see what, again, a drop of blood, what is that volume, and then I would have to back calculate, but I can't tell you at this time.
Well, there would be white blood cells in a drop of fresh blood, wouldn't there?
Yes.
And each one of those white blood cells had DNA.
Yes.
And the more white blood cells, the more DNA.
Correct.
Well, we grant you that there was enough DNA at F5 for Ms. Sauer to develop a partial male profile. Was she able to determine a complete male profile from that site?
No.
Finally, Mr. Bush, you were asked about an article to which Dr. Spence referred yesterday. I think you have that article in front of you, don't you?
Yes, I do.
Okay. Mr. Maybanks asked you if Dr. Spence had testified yesterday that this report confirms that half of the specimens being examined by crime laboratories in the United States consist of evidence from transfer. Do you remember him asking you about that?
Yes.
In fact, Dr. Spence testified that half of the specimens coming into crime laboratories are from dry transfer. Isn't that accurate?
He stated that, or the article stated that?
That the article referred to half of the items occurring in crime labs come from dry transfer.
Again, there's several paragraphs here where it talks about this, but I'm just going to read the last sentence or so here. It says, this discovery of the ability to generate profiles. Sorry. Okay, sorry. This discovery of the ability to generate profiles from touched objects was initially met with disbelief by many within the forensic community, but once verified became a welcome tool for law enforcement agencies. Within several jurisdictions, samples collected from touched objects now represent more than half of the total number of samples processed for DNA profiling. So this refers to just several jurisdictions or several agencies. So they're drawing or extrapolating a conclusion here based on several jurisdictions.
But the reference was to dry transfer, right?
Yes, I believe so.
Thank you. So you've told the men and women of the jury and us that it's impossible to, or it's difficult to make conclusions if you don't know the factors and you don't know the background into how, in this case, DNA got into the car, how DNA got onto Ms. Martinko's dress, right?
That's correct.
So this happened 40 years ago, and we're dealing with the best facts we can, aren't we?
Yes.
And you know, both from your experience and from the work that other criminalists in your lab have performed, that DNA can be found on door handles,
Yes.
can be found on benches,
Yes.
benches in malls,
Yes.
chairs and counters at restaurants,
Yes.
saliva from coughing and yelling.
Yes.
We deal with the best we can in facts like this, don't we?
That's correct.
Thank you.
Redirect Mr. Maybanks.
Thank you, Your Honor. And Paul, as you just answered from Mr. Spies here, indeed, if we had a set of circumstances that could be confirmed for us in front of us, we could say that if somebody touches or ends up on a bench in a mall and transfers DNA somehow in a known way, we could then confirm that, right?
Yes, again, if you have maybe video that shows a person sat there or somebody coughed at this spot, then again, likely it would help corroborate your conclusion that, you know, we have someone's DNA present because we saw the video of them there and they coughed on, I don't know, this bench or something at a mall.
And because you're sitting here right in front of us right now, Paul, and you're talking into that microphone, these questions about whether your DNA might be on there, everybody here could say, well, yeah, Paul's right there, right? So we know that, right?
Correct.
Okay, so facts, data, history is important in order to confirm how someone's DNA gets on an object or a place, right?
Again, that's what we attempt to use is facts or information to help us elucidate what may or may not have happened in a case.
Otherwise, we're just guessing, right?
Pretty much so.
In the world of potential scenarios, in a given set of circumstances, when we have two areas on a crime scene, like in this case, where both areas indicated a positive test for the presence of blood, as scientists or as individuals, we can conclude that it's a very likely scenario that that individual bled not once but twice in that area.
Again, oops, sorry, apologize.
That's okay.
Sorry. So again, our screening tests indicated the presence of blood on numerous items. So we would believe that someone, based on those screening tests, or someone or more than someone bled on numerous items based on our screening tests. It helps us identify stains that we're going to look at in order to attempt to do DNA analysis to see if we can elucidate additional information.
In DNA being great, but as you said, at the same point in time, when it comes to blood, in some circumstances, you're not always going to find DNA. Is that right?
Correct.
Like in this case, for instance, the steering wheel was tested, and is it your recollection that although indicating the presence of blood, there was no DNA that was able to be developed from that area?
That's correct.
So it's not out of the ordinary that some areas where you can say, yeah, our tests show that's blood, we still can't say, well, we were able to get DNA there.
Correct. Just because something screens for the presence of blood doesn't necessarily guarantee that we can get DNA results from that.
As you were asked about on cross-examination, believe it was if a killer was above the victim, as in, well, as could be the case here, given the circumstances, that you might expect to find blood or, I guess, DNA, the killer's DNA on the front of her dress, right?
That's possible.
And also in those circumstances, if during this struggle there was events where the killer was tugging at a dress or touching a dress after cutting himself, you could expect, or you could find DNA in blood on the back of that dress too.
Again, depending upon the circumstances, that's a likely explanation.
And this dress was, it wasn't submitted just once for analysis, was it?
No.
It was submitted in 1997, right?
Yes?
And again in 2002,
Yes.
again in 2003,
Yes, I believe so.
okay, and again in 2005.
Yes.
Now, that's quite a few times for the same area of evidence to be examined, isn't it?
Yes.
Once, and I'll just ask you about your familiarity with practice at the laboratory in cases such as this. After numerous attempts have been made to locate a suspect profile or a potential suspect profile on a dress, once a profile is developed, is it regular practice for the lab to continue to test items of evidence for the same profile or another one?
Again, if it's a foreign profile, then typically, if that is significant evidence in the case, then typically the laboratory would stop performing analysis. If we're just testing this item over and over and we're getting the victim's DNA on the victim's clothing, again, requests may be made to look for additional stains or add additional items in the case to help, again, solve the case. So if, again, we would find a significant foreign profile that would help with the investigation, typically we're going to stop at that point. One of the things we have to balance is, again, working these cold cases versus, again, testing about 1,500 to 1,800 cases a year for DNA testing. I can't just, as the supervisor, just allow us to spend all our time and all our resources just on 1 or maybe 5 cases for the whole year. We've got 15 to 1,800 cases coming in, so we have to try and balance our resources with looking at these cold cases versus looking at new additional cases coming in.
And your laboratory works on a lot of these cold cases, doesn't it?
We have over the years, yes.
Okay. Based upon your review of this file and given the amount of testing that was done on Michelle's dress and various other items through the course of this case and investigation, was the finding of a male profile that was sufficient for comparison at the amount of alleles that you were able to identify, was that a pretty big break in the case?
Again, I would assume that that was a significant break or an investigative lead in the case.
A break that, in your experience, would require some follow-up and investigation before, and maybe get some answers before moving on.
Correct.
I think we've covered pretty extensively that the areas at F5 and in the blood from the shift selector indicated the presence of blood. Did any other testing of the dress, like the areas where it was presumed to be Michelle's blood was found, indicate the presence of any other fluids besides blood?
Again, no other testing for other biological fluids, or, excuse me, no other screening was performed to make that determination.
Based upon your testimony today and your experience, you've indicated to us that facts are important in interpreting the evidence. Right?
Yes, again, we try and use facts in a case to help us elucidate or determine what may or may not have happened, and that would help us point our analysts in the direction of where we want to be looking for DNA evidence.
Did you see in this investigation any facts at all that indicated that your laboratory should be looking for the presence of saliva or semen in this case?
Again, based on the facts that we have in this case, we did not choose to do any of those other biological screenings.
I mean, you didn't have any facts that the killer spit on Michelle or anything like that, right?
Again, we did not have those facts.
She had numerous stab wounds and blood all over, right?
Correct.
So would that be a practice of the laboratory in a factual scenario like that to look for saliva?
Again, it depends on, it's a case situation basis. So based on the information we have, we attempt to focus in on the types of evidence that we believe can help us solve the crime or help the investigators move forward with their investigation based on our DNA testing that we do.
And I think you mentioned, or Mr. Spies mentioned in his questioning, this term cross-contamination, which sounds a little eerie, but in this case is the only real risk of any kind of contamination, if you want to call it that, maybe call it transfer, is the only real risk here is the transfer between the same victim's clothing?
So I would tell you, within our laboratory, we go to great pains to not allow what we would call secondary or alternate transfer between different items of evidence, especially between different cases, because we have like a new piece of butcher paper put out each time. We use bleaching to clean down our countertops and things, but we try and be very careful that we don't cross-contaminate items. So in this case, I think it was the victim's clothing. There was dress, I know there was underwear, there was a scarf, I can't remember what else, but they were all packaged together, so we would look at those holistically as far as foreign material that may be present on those items. We, again, hope, and I believe that happened is that the people that packaged this followed proper procedures in sealing these items, or this single package back up as far as evidence-wise.
Paul, with regard to this article again here that we've been talking about, you said within several jurisdictions they are now submitting items for DNA analysis that may involve touch DNA. Is that kind of what you read from that?
Yes.
Okay. Is it a fair characterization of that statement that these law enforcement departments or these jurisdictions are now trying to solve more crimes by searching for this evidence?
I believe that's the gist of this paragraph here.
Nothing further, Your Honor.
Additional cross-examination, Mr. Spies.
Yes. Mr. Bush, it goes without saying, although I'm going to say it, that you can't find what you don't look for.
That's correct.
And you've already told the men and women of the jury that there were no other tests for other biologic sources of DNA other than blood on the victim's dress.
Yes, that's correct.
And the other sources we've already heard about could be saliva, could be hair, could be mucus, could be sweat.
Yes, those are possibilities.
Yeah. And again, because you didn't look for them, you don't know that they're there.
That is correct.
And particularly, as you've already told us, you didn't look on the scarf, you didn't look on the front of the dress for any other biologic material other than blood.
What I can say is only the blood was detected on this dress as far as a biological fluid.
Because nothing else was looked for.
Correct.
And while I know that the Division of Criminal Investigation Laboratory takes great steps to avoid cross-contamination when your analysts are examining the evidence, you don't know what happened the 26 years before 2005 when F5 was found and isolated.
No, I do not.
Or how many times other people handled that evidence,
No, I do not.
except when it was at the DCI laboratory.
That's correct. That's where we would have had control over those items, or that item.
Okay. Thank you. I have no other questions.
Redirect Mr. Maybanks.
So, Paul, your testimony is that only blood was detected on this dress.
As far as our screening tests are concerned, the screening tests indicated the presence of blood on this dress.
Nothing further, Your Honor.
Anything further, Mr. Spees?
Nothing else.
Okay. Thank you, Mr. Bush. You're excused. You can stay right there.
Oh, yeah,
Thank
yeah,
you, sir.
like that. Thanks, Paul.
Any additional rebuttal evidence from the state?
No, Your Honor.
Mr. Spees,
If I could have a moment, Your Honor, just for a brief recess.
you may. We will stand in recess for 15 minutes. As always, members of the jury, please bear in mind that admonition. Please be seated, everyone. The record will reflect that counsel, Mr. Burns, as well as the jury have returned to the courtroom after a brief recess. We have heard the rebuttal case from the state of Iowa. Mr. Spees, does Mr. Burns wish to present a surrebuttal case?
We do not, Your Honor.
Okay. At this point, ladies and gentlemen, the evidence has been submitted to you. There are matters, again, that the attorneys and I need to take up before we can embark on the next stage of these proceedings. So at this point, I am going to adjourn this court until 9 o'clock on Monday morning. And at that point, you will hear the instructions from the court and final arguments from the attorneys. But again, although the evidence has been submitted to you, it is not. I'm going to adjourn this court until 9 o'clock on Monday morning. And at that point, you will hear the instructions from the court and final arguments from the attorneys. But again, although the evidence has been submitted to you, it is not appropriate for you to make up your mind as individuals, to discuss the case amongst yourselves, to discuss the case with anyone else. Please continue to avoid any media coverage of the case. On Monday, as I indicated, you will receive instructions from me, and then you will have an opportunity to deliberate as a group. That is when it's appropriate for you to discuss the case and move on. But until then, please bear in mind that admonition that I speak of every time we part ways. It is important that you adhere to that oath that you took at the start of this case. So at this point, we will bid you farewell for the weekend. I hope that you enjoy some time away. It sounds like the weather's going to be quite nice, so maybe you can enjoy the weekend. But we will plan to see you back at 9 o'clock on Monday.
Please rise to the jury. You can leave your notebooks on your chair.
Okay, I just wanted to jump in there. So I showed that a little bit of out of order, but I think now we're kind of caught up. So I just want to go back through Paul Bush's testimony there. So they talked about the most scientifically supported theory as to how Jerry's blood got on F5. And this is the first time we heard that F5 was on the back. So they tested all the blood stains on the front, and that's the only thing they tested for. They didn't test for anything else. But based on the facts provided, there appeared to be a struggle based on defense wounds. Screening test revealed a male DNA profile was developed from the back of Michelle's dress, F5, and it was consistent with Jerry Burns. We're definitely going to listen to jury instructions. Yeah, we're not going to miss anything. Don't worry. So then cross was the scarf was not tested. He kept going on the scarf. I mean, does it matter? I don't get it. It's quite possible that your DNA is on the mic in front of you. DNA should have been on the front of Michelle's dress. Okay, so if there's this huge struggle going on, and I guess he's he's making the inference that, just by talking, touching somebody, that DNA is going to be transferred, right? So that's why defense was saying, well, they didn't test for DNA on the front. Why didn't they test for DNA on the front? All right, that's valid. The front dress was tested for blood only. They checked did they check the visors, the headliner? Oh, they checked the visors and the headliner, but they did not test the seat. Interesting. And then I guess this is the theory. DNA could be on chairs, benches, saliva, coughing, yelling. Well, Jerry's DNA was found on the dress, so on the back of the dress. So I kind of see where defense is going with this. That if the struggle obviously was intense, probably lasted 5 minutes or so, and there should have been DNA all over Michelle. If he's holding her down, however he's holding her down, sitting on her, holding her down, she should have had DNA all over her, but they only tested the back of her dress. But they also tested the gear shift, so they got DNA from there and blood from there as well. I don't know. Jerry said he wasn't at the mall, so how did his DNA get on the back of her dress? I don't know. You tell me. What do you guys think? Brad Colwell, I think he thinks someone else's DNA could have been on the scarf. Sure. Could have been 30 people's DNA on the scarves, and they tested like 128. They had 161 suspects, and they tested 128 DNA, and the only ones that came back were the Burns brothers, and it was Jerry. So the only DNA that came back was Jerry's. So I don't know. Thank you, Julie. Either way, his DNA was there. Yeah. All right, so we're going to get into jury instructions. It's only 26 minutes, so take that for what it is, and then we get into closing arguments. So for those planning your evening, it's 5:30 now, so we got 2 hours, 3 hours, about 3 to 3.5 hours. So we're looking at 8:30 to 9. We'll be finished. So if you're planning your evenings, that's where we're gonna end. All right, we ride north.
Mrs.
Uh-oh, I'm afraid there might be a buzz here. We're gonna have to check this out. There may be a buzz here, guys. All right, let's listen to it. See what happens. All right, I'll check on the other side.
Ms. Larson, if you'd please have the jury join us. Please rise for the jury.
Rise for the jury.
Please be seated, everyone. Good morning, jury members. We're very, very happy to have all of you here in your places. Hope you enjoyed the nice weekend, and we were able to get some rest. We are about to begin. We're in the final stretch, folks, and I had some computer problems this morning. I apologize for making you wait. I had made some edits over the weekend, and then my computer took about 3 starts before it was going to come play this morning. So, but we're all good. As I said, there will be instructions that I will give you. Throughout this process, you have served as the judges of the facts. And when you begin your deliberations, you will be determining the facts that you find to be credible and base your decision based on those facts. The law, the instructions that I will read you this morning is the law that applies in this case. And so don't feel that you have to write down anything that seems important. You will have copies, written copies of the instructions that I will read. We will provide enough copies of those instructions that you will be able to look onto a copy so that everyone will be able to look at those instructions. Don't feel like you have to take notes on what I'm going to tell you this morning. I'm going to read a portion of those instructions to you, and then the attorneys will have an opportunity to give closing arguments. And then there will be a few more instructions that I give you, and then we will allow you to retire to the jury room to begin your deliberation process. I just have a couple of, well, I won't make those remarks at this point. We will go ahead and get started with the reading of the jury instructions. State of Iowa plaintiff versus Jerry Lynn Burns, Lynn County cause number FECR 129718. Statement of the issues and instructions of the court. Ladies and gentlemen of the jury, the state of Iowa in this case accuses the defendant, Jerry Lynn Burns, of the crime of murder in the first degree when he willfully, deliberately, and with premeditation killed Michelle Martinko. This occurred on or about December 19, 1979, at 2400 Edgewood Road Southwest, Cedar Rapids, Lynn County, Iowa, in violation of Iowa Code Sections 707.1 and 707.2, subsection 1. To this charge and all lesser included offenses, the defendant entered a plea of not guilty. Upon the issues thus made, you are instructed as follows. Instruction number 1. The trial information charges the defendant, Jerry Lynn Burns, with the crime of murder in the first degree. Murder in the first degree includes the lesser and included offenses of murder in the second degree, voluntary manslaughter, involuntary manslaughter public offense, and involuntary manslaughter reckless conduct. Instruction number 2. The trial information is the document that formally charges the defendant with a crime. It is merely the method by which the defendant is brought into court for trial. It is not evidence. Instruction number 3. Jerry Burns has entered a plea of not guilty. The plea of not guilty is a complete denial of the charge and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you that the state must prove something, it must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. Instruction number 4. Jerry Burns is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, the charge, or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. Instruction number 5. Jerry Burns is presumed innocent and not guilty. The presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of the defendant. The presumption of innocence can be overcome only if the prosecution proved during the trial, beyond a reasonable doubt, each element of the crimes charged. Instruction number 6. You must determine whether the defendant is guilty or not guilty from the evidence and the law in these instructions. My duty is to tell you what the law is. Your duty is to accept and apply this law and to decide all fact questions. You must determine the defendant's guilt or innocence from the evidence and the law in these instructions. You must consider all the instructions together. No one instruction includes all the applicable law. Instruction number 7. The duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Instruction number 8. Nothing I have said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be. Instruction number 9. The burden is on the state to prove Jerry Burns guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence in the case or lack or failure of evidence produced by the state. A reasonable doubt is a doubt based upon reason and common sense, not the mere possibility of innocence. A reasonable doubt is the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt, therefore, must be proof of such convincing character that a reasonable person would not hesitate to rely and act upon it. However, proof beyond a reasonable doubt does not mean proof of all possible doubt. If, after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt, and you should find the defendant guilty. But if, after a full and fair consideration of all of the evidence in the case, or from the lack or failure of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt, and you should find the defendant not guilty. Instruction number 10. If there is a reasonable doubt as to the degree of the crime, the defendant shall only be convicted of the degree for which there is no reasonable doubt. Instruction number 11. You shall base your verdict only upon the evidence and these instructions. Evidence is, number 1, testimony in person or by telephone. Testimony in person or by deposition. Number 2, exhibits received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. Number 3, stipulations which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to which were not offered and received into evidence are not available to you. The following are not evidence: statements, arguments, questions, and comments by the lawyers. Number 2, objections and rulings on objections. Number 3, any testimony I told you to disregard. Number 4, anything you saw or heard about this case outside the courtroom. Instruction number 12. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, you will accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, number 1, whether the testimony is reasonable and consistent with other evidence you believe. Number 2, whether a witness has made inconsistent statements. Number 3, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts. And the witness's interest in the trial, their motive, candor, bias, and prejudice. Instruction number 13. In considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Number 14, where there are two or more alternative theories. Let me begin again. Instruction number 14. Where two or more alternative theories are presented, or where two or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based. Number 15. You have heard testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case. Number 16, the witness, Michael Allison, has admitted he was convicted of a crime. You may use that evidence only to help you decide whether to believe the witness and how much weight to give his testimony. Number 17, you have heard in this case, this is instruction that has been numbered as 18, but it will be number 17. In this case, the defendant has decided not to testify. The defendant is not required to testify, and no inference of guilt shall be drawn from that fact. The burden of proof remains upon the state to prove the guilt of the defendant. Evidence has been offered to show that the defendant made statements at an earlier time and place. If you find any of the statements were made, you may then consider them as part of the evidence. Instruction number 20 in the packet. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person knows the act is against the law, it is necessary that the person was aware he was doing the act and that he did it voluntarily, not by mistake or accident. You may, but are not required to, conclude a person intends the natural results of his acts. Specific intent means not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what he was thinking when an act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may, but are not required to, conclude a person intends the natural results of his acts. Instruction number 21. The state has charged the defendant with murder in the first degree. The state must prove all of the following elements as set forth below. On or about the 19th day of December 1979, Jerry Burns stabbed Michelle Martinko. Number 2, Michelle Martinko died as a result of being stabbed. Number 3, Jerry Burns acted with malice aforethought. Number 4, Jerry Burns acted willfully, deliberately, premeditatedly, and with a specific intent to kill Michelle Martinko. If the state has proved all of the elements, the defendant is guilty of murder in the first degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the first degree. You will then consider the charge of murder in the second degree as explained in instruction number 29. Instruction number 22. Concerning element number 2 of instruction number 21, wounds inflicted by the defendant resulted in the death of Michelle Martinko if they caused or directly contributed to her death. Concerning element number 4 of instruction number 21, willful means intentional or by fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. Deliberation and premeditation need not exist for any particular length of time, but must exist before and at the time of the act resulting in death. Instruction number 24. Concerning element number 3 of instruction number 21, malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences, as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another, which exists before and at the time the act is committed. It does not have to exist for any particular length of time. Instruction number 25. If a person has the opportunity to deliberate and uses a dangerous weapon against another, resulting in death, you may, but are not required to, infer that the weapon was used with malice, premeditation, and a specific intent to kill. Instruction number 26. Malice aforethought may be inferred from the defendant's use of a dangerous weapon. Instruction number 27. A dangerous weapon is any device or instrument designed primarily for the use in inflicting death or injury, and when used in its designed manner is capable of inflicting death. It is also any sort of instrument or device which is actually used in such a way as to indicate the user intended to inflict death or serious injury, and when so used is capable of inflicting death. Instruction number 28. Deliberation and premeditation need not exist for any particular length of time, but must exist before and at the time of the act resulting in death. Instruction number 29. The state must prove all of the following elements of murder in the second degree. Number 1, on or about the 19th day of December, 1979, Jerry Burns stabbed Michelle Martinko. Number 2, Michelle Martinko died as a result of being stabbed. Number 3, Jerry Burns acted with malice aforethought. If the state has proved all of the elements, the defendant is guilty of murder in the second degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you will then consider the charge of voluntary manslaughter. Murder in the second degree does not require a specific intent to kill another person. The state must prove all of the following elements of voluntary manslaughter. On or about the 19th day of December, 1979, Jerry Burns intentionally stabbed Michelle Martinko. Number 2, Michelle Martinko died as a result of being stabbed. Number 3, the stabbing was done solely as the result of a sudden, violent, and irresistible passion resulting from serious provocation. If the state has proved all of the elements, the defendant is guilty of voluntary manslaughter. If the state has failed to prove any of the elements, the defendant is not guilty of voluntary manslaughter, and you will then consider the charge of involuntary manslaughter public offense, as explained later. Concerning element number 3 in the marshalling instruction for voluntary manslaughter, a serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. Passion is not sudden, violent, and irresistible if there is an interval of time during which a reasonable person would, under the circumstances, have time to reflect and bring his or her passion under control and suppress the impulse to kill. Words alone, however abusive or insulting, cannot be serious provocation. Regarding the offense of involuntary manslaughter public offense, the state must prove both of the following elements. On or about the 19th day of December 1979, the defendant recklessly committed the crime of assault. Number 2, when the defendant committed the crime, the defendant unintentionally caused the death of Michelle Martinko. If the state has proved both the elements, the defendant is guilty of involuntary manslaughter, public offense. If the state has failed to prove either of the elements, the defendant is not guilty of involuntary manslaughter, public offense, and you will then consider the charge of involuntary manslaughter, reckless conduct. Concerning element number 1 in the marshalling instruction for involuntary manslaughter, public offense, an assault is committed when a person does an act which is meant to cause pain or injury, result in physical contact which will be insulting or offensive, place another in fear of immediate physical contact which will be painful, injurious, insulting, or offensive to another person when coupled with the apparent ability to do the act, or a person intentionally points a firearm toward another or intentionally displays a dangerous weapon in a threatening manner toward another. Regarding the offense of involuntary manslaughter, reckless conduct, the state must prove all of the following. Number 1, on or about the 19th day of December 1979, the defendant recklessly stabbed Michelle Martinko. Number 2, the defendant did the act in a manner likely to cause death or serious injury. Number 3, by doing the act, the defendant unintentionally caused the death of Michelle Martinko. If the state has proved all of the elements, the defendant is guilty of involuntary manslaughter, reckless conduct. If the state has failed to prove any one of the elements, the defendant is not guilty. A person is reckless or acts recklessly when he willfully disregards the safety of persons or property. It is more than a lack of reasonable care which may cause unintentional injury. Recklessness is conduct which is consciously done with willful disregard of the consequences. For recklessness to exist, the act must be highly dangerous. In addition, the danger must be so obvious that the actor knows or should reasonably foresee that harm will more likely than not result from the act. Though recklessness is willful, it is not intentional in the sense that a harm is intended to result. At this time, ladies and gentlemen, it is the place in the trial, the time in the trial for each of the parties to present what's called a closing argument. Closing arguments, along with the opening statements, are not evidence, but this is an opportunity. Over the last 7-8 days, you received a tremendous amount of information and evidence. And the closing arguments are an opportunity for each side to put that evidence into an order and to argue to you what each party believes that the evidence that's presented means and its significance. As you noticed throughout the trial, there was a pattern. The state goes first, and the state will continue to go first. They will give an initial closing argument, followed by a summation by Mr. Spies on behalf of Mr. Burns. And then because the state has the burden of proof, the state will have an opportunity to again address you in what's called a rebuttal closing argument. I would ask you to give the attorneys, as you have all week, your attention, and I want you to know that as I indicated, the attorneys are trying to give you a framework again and present to you their best belief of what the evidence shows. They are not at any time trying to mislead you. Obviously, as the judges of the facts, it will be up to you to determine what facts you deem credible and the facts on which you will base your determination and your verdict in this case. But the summations that you will hear over the next couple of hours are the understanding of the evidence by each of the sides, and you should continue to give them your close attention.
Okay, real quick, just to surmise that? Wrap that up, whatever. Murder in the first degree, plead not guilty. That's all I got out of that. Let's move on. Now we move on to the prosecution, closing arguments. Okay. I will see you on the other side of this. This is an hour and 22 minutes, just so you guys can plan. This is prosecution. Then we go to defense. So this is prosecution, hour, 22 minutes.
At this time, ladies and gentlemen, it is the place in the trial, the time in the trial for each of the parties to present what's called a closing argument. Closing arguments, along with the opening statements, are not evidence, but this is an opportunity. Over the last 7-8 days, you received a tremendous amount of information and evidence. And the closing arguments are an opportunity for each side to put that evidence into an order and to argue to you what each party believes that the evidence that's presented means and its significance. As you noticed throughout the trial, there was a pattern. The state goes first, and the state will continue to go first. They will give an initial closing argument, followed by a summation by Mr. Spies on behalf of Mr. Burns. And then because the state has the burden of proof, the state will have an opportunity to again address you in what's called a rebuttal closing argument. I would ask you to give the attorneys, as you have all week, your attention, and I want you to know that as I indicated, the attorneys are trying to give you a framework again and present to you their best belief of what the evidence shows. They are not at any time trying to mislead you. Obviously, as the judges of the facts, it will be up to you to determine what facts you deem credible and the facts on which you will base your determination and your verdict in this case. But the summations that you will hear over the next couple of hours are the understanding of the evidence by each of the sides, and you should continue to give them your close attention. Mr. Maybanks, do you wish to give a closing argument on behalf of the state?
Yes, I do, Your Honor. May it please the court. Thank you, Mr. Steves. Gentlemen. Ladies and gentlemen of the jury, good morning. I know you're all anxious to begin your deliberations, but please indulge the state this morning over the course of the next hour or so while we summarize what we believe the evidence has shown in this case. Ladies and gentlemen, over the course of the last 2 weeks, you have now heard and seen the evidence in this case. This is the opportunity for the state and the defense to contend to you what we believe the evidence has shown. What we believe are the reasonable inferences and conclusions that can be drawn from the evidence. You will make the ultimate decision. We contend the evidence shows the defendant's guilty of murder in the first degree. On December 19th, 1979, the world was Michelle Martinko's for the taking. Instead, she was taken from the world. The state has demonstrated to you, by evidence beyond a reasonable doubt, how she was killed and who killed her. The evidence has shown he was a young man back then. Just a kid. Wished he could go back there and talk some sense into that kid. Out on his own for the night. Liked to drink a lot back then. It was close to Christmas, and he went to Westdale Mall to do some shopping, away from his young family for the night. She was a teenager, almost halfway through her senior year at Kennedy High School. A twirler, a concert choir performer, a thespian, a friend, a girlfriend, a sister, a daughter. She loved to dress up. She was popular with many different people in her class, from different ages and different age groups. She had her close friends and she had acquaintances. She would stop and talk to anyone who would say hi to her. She was friendly to everyone, sweet, kind, funny, and smart. In a few months, she looked forward to moving on from high school to study interior design. That night was an ordinary night in her life, the life of a high school student. She went to a choir concert banquet. She saw one of her closest friends, Jane, who was there and hoped to hang out with her for a bit. But Jane had to do some homework. So Jane went home and she said hello to Jeff White in the parking lot and continued on to Westdale Mall. When he got there, he found that the new mall was rife with activity and young people, including young women. Some were in groups and some were alone. When she got to the mall, she saw some friends, Marty Miller, Tracy Price, and Todd Bergen. She talked to them about how she was looking for a coat for her mom, that her mom picked out for her. They noticed she had some money on her and a purse. They offered her a dime to call her mom. She was alone. She then ran into Merlin Winkler and Andy Seidel. Andy had been her boyfriend at one point in time, and they were still close. Andy was there to pick out a fiber optic light for her that she wanted. The interaction was brief, and then they went on their separate ways. He noticed her alone. It was obvious, because she was everywhere in the mall that night, on every level, on all sides, sometimes talking to people, but clearly she was alone. She continued on and saw an old friend of hers she hadn't seen for a while, Kurt Thomas, who was working at the Chess King. She hung out for a bit, accompanied him on his break. They walked together to the Orange Julius, where the two of them sat together in close proximity and talked. As with the others with which she interacted, she stood in close proximity to him the entire time. Kurt walked her to the door, believing she was going to leave for the night, and gave him what he tearfully recalled as that goodbye smile. The evidence shows that Kurt Thomas was the last person to talk to Michelle Martinko before she was killed. As he left her, she was alone again. But we heard that she did not exit from that particular door where Kurt walked her from, and two. She left through another exit where she was spotted by Cheryl Anders, who was in the parking lot. Cheryl recognized her from a distance because of her distinct look. Again, she was alone as she left. He saw her leaving and he followed her. He didn't have much time, so he descended quickly upon her as she got to the car. He put on gloves to protect his identity. Doesn't want to leave his fingerprints behind. But he would lament many years later that DNA wasn't a thing in 1979. She was walking in the direction where she parked her parents' car. She was carrying a shopping bag in her purse. She gets to her car, unlocks the back door, and places the shopping bag in the back seat, driver's side, giving just enough time for the killer to approach her from a distance more quickly. She puts her bag away, gives him more time to approach as she gets into the car and begins to start it. Unbeknownst to her, the killer's approaching more quickly at that time. She's getting ready to drive away. He's coming at her more quickly now before she drives away. Opens the car door using his gloves and leaving the imprint on the car door button. When he opens the door, he has to act fast. He needs to incapacitate her so she won't fight, so he can get what he wants. He has a knife with him to intimidate her, to get her to bend to his demands. All of a sudden, the door opens to the car, and she sees there's a man there. The man attacks her. He strikes her with the butt of the handle of the knife in the head, leaving a large bruise that caused internal bleeding. She feels the strike to her head and causes her to fall back on the car seat. She's taken entirely by surprise, but she knows that she has to fight to the extent that she can. He sees she's not immediately incapacitated. He displays the knife and struggles with her to hold her down on her back to get her to submit and stop fighting. He struggles to subdue her, but while doing so, realizes that she's seen him now. She is not submitting. She continues to fight, despite the knife that he has presented and brought to intimidate her. She's on her back now, and she's hurt. Her internal desire to live kicks in, and she begins to fight, but he's stronger than her. She can now see this man, and she does not know him. Her fear and terror intensifies, and her adrenaline kicks in. She must fight. As she struggles with this unknown attacker that she has not seen before, and that she now has seen, he becomes more aggressive. He has a knife, and desperate to stop her struggle, he now has seen this has gone too far already. He drives a knife into her chest, not once, not twice, but multiple times. He knows he now must eliminate her because she can identify him. She fights all she can, but she feels the sharp-edged, blunt force of the knife being driven into her chest. This has gone too far now to stop. It's not just about incapacitating her to get what he wanted anymore. Now he must end what he started. He has a wife and family. He can't get caught. He can't be identified. Can't be arrested. Now he must kill her. Meanwhile, she's losing the ability to fight. But her pure will to survive kicks in, and she continues to struggle, swinging her hands in front of her, turning her body to avoid the constant stabs and slices. Her blood is flying everywhere. She's weakening. As her blood spills outside of her body and inside of her body, causing 2/3 of the capacity of her blood to leave. Lost to the surrounding environment in the car and lost to her lungs. She's been stabbed 11 times in the face, the neck, and the chest. And he's inflicted a total of 29 wounds. He continues to stab her until she's motionless. She can no longer fight. She's dying. As a result of the fight and the attack, he realizes that he has cut himself and he now must attend to his wounds. Unbeknownst to him and the struggle, with her, she has tossed and turned, and he has tugged at her and stabbed her that he bled on the back of her dress. As he looks upon her in the mess in the car, he realizes he now must act in order to avoid detection. And the young lady who just moments ago was living the life of a normal high school girl, attending the choir banquet, shopping at the mall, talking to her friends, was now lifeless and motionless, lying in her blood in her parents' car in a cold parking lot at Westdale Mall. with a complete stranger, dying from her wounds. He considers driving the car from Westdale Mall to another location and briefly gains control of the operating system. But what's he going to do if he drives from that location? He'd driven there that night. He'd need to get back to the parking lot. And he's bleeding himself, and he needs to control his own wound. He drove himself to the mall, so if he drove away, he'd have to come back. They would be looking for the killer soon. If he were found walking in the area of the mall back to his car, he'd stand out glaringly as the suspect. No, he couldn't take the car. He had to leave. So he put the car back into park. And in doing so, he used the gear shift selector, smearing his blood and hers on the gear shift selector. He gets out of the front seat, pushes down the lock mechanism, and shuts the door, locking it, leaving blood on the outside of the door. As he shuts it, the back door through which Officer Kincaid was later able to access remains open, with no evidence of blood on it. He leaves hurriedly back to his car, holding his wound to prevent it from oozing and dripping, gets into his car and drives back to Manchester, where he lives. He's home within an hour, far away from where Michelle Martinko lay in the car, beaten, stabbed, and by that point in time, dead. Just an hour and a half later or so, after all the customers had left Westdale Mall for the night, and most of the employees had left as well, near 11 o'clock or so, Phoebe Smith leaves her job at Pier 1 Imports, drives to People's Bank to make the nightly deposit, and sees in the back area of the parking lot in the northeast corner a vehicle that she recognizes as Michelle Martinko's parents' car, the car that Michelle drove frequently, by itself. And unbeknownst to her at that time, inside of that vehicle lay Michelle's lifeless body, and along with it, 39 years of investigation and unanswered questions. Meanwhile, the killer would be able to go on with his life, raise his family, run a business, enjoy those years of his life. No doubt haunted by the prospect of one day receiving a knock on the door that would eventually come 39 years later. What choice would he have? He'd have to learn with what he did. He'd have to live with what he did. He would need to block out his memories. Michelle's body would later be discovered after approximately 4 o'clock a.m. in that same car, in that same parking lot. And you heard from Officer James Kincaid, a career police officer on patrol who served for many decades. He was called to the scene to check for her car, and he found her body inside. He was able to access the car through the driver's side back door that had been left open when Michelle put her shopping bag in there. He looked inside and he saw Michelle. It was obvious that she was dead. He contacted other officers to come to the scene and began the crime scene investigation and did not disturb the interior of the car in any way. You then heard that ID Officer Richard Dick White then arrived. And you heard from Dick, in this case, now 80 years old, testify to what he observed at the crime scene on December 19th, 1979, like he had just been there the day before. He conducted a comprehensive examination of the crime scene, which was limited to the vehicle. Michelle's body was removed through the passenger side seat by EMTs, who took careful precautions not to disturb or contaminate the rest of the vehicle. Notably, her body was taken out the passenger side seat area of the vehicle, assuring there was no contact between her dress and the gear shift selector. There was blood everywhere from this attack on Michelle. It was on the dash. It was on the steering wheel. It was on the passenger side door and seat. It was on Michelle. It was on her dress, on the gear shift selector, and even on the car keys. The car was seized and analyzed at the Cedar Rapids Police Department, and numerous items were taken for further examination, which included her clothing, the black dress, her pantyhose, her underwear, as well as the black scarf that was viewed as an accessory to the dress. Future examination of the dress would reveal numerous locations where blood would be found. Evidence also included scrapings and a tape lift that was taken from the gear shift selector, containing what was visibly identified and later confirmed to be the presence of blood. The evidence will show that these scrapings were taken and placed into evidence at the Cedar Rapids Police Department, where they remained until approximately December 31st of 1996, when ID Officer Dennis Murphy recovered and retained those items from evidence to take them to the DCI lab in Des Moines. The tape lift containing the blood from the gear shift selector was tested. Elaborate foundation and chain of custody was introduced in this trial to show that it, along with the dress, was properly preserved. The gear shift selector at the DCI lab, where it remained from the last time it was tested in 2002 until March of 2019, when it was shipped off to Bodie Labs. You heard from the pathologist in this case, Dr. Richard Feaster. From this testimony, you heard that she received numerous stab wounds. A stab wound that penetrated her right lung and two that penetrated her left lung. A wound identified as the fatal wound that penetrated her sternum and rib cage and pierced her aorta just above her heart. From his testimony, you learned that she also sustained a severe blow to her head that caused an approximate 3 to 3.5 inch bruise and correspondent internal bleeding. The evidence showed, as I stated earlier, that she lost 2/3 of her blood capacity to the surrounding environment and to her lungs. From his testimony, you learned that based upon the trajectory of the wounds that she sustained, the assailant was facing her at the time of the attack. You heard her wounds were consistent with being pushed on her back and being attacked from the front. You heard the assailant was on top of her and coming down on her. And you heard that the amount of force required to inflict these injuries was significant. From his testimony, you learned that the evidence of a struggle took place and that Michelle had sustained numerous defensive wounds as well to her hands. The evidence showed this was a brutal attack with 29 overall wounds, 11 stab wounds, and the remainder of them being slice wounds and defensive wounds. You heard from Dr. Feaster's extensive training and experience that the evidence shows this attack was done in a manner that made it likely that the suspect who did it cut himself with the knife he used to stab Michelle Martinko. Fortunately, the Cedar Rapids Police Department did take steps to preserve what they could for later analysis. As I stated, extensive chain of custody evidence was introduced at this trial that demonstrated that the clothing, including the dress, was kept properly in police, state, and FBI custody from the time it was collected in 1979 until it came to court for this trial. And that there was no chance of outside contamination on this dress. No circumstance in this case, no serious event or chain of events was introduced that would explain how the DNA of Jerry Burns would end up on Michelle Martinko's dress after it was taken into police custody. Any potential circumstance that could be offered to explain how Jerry Burns' DNA arrived upon Michelle Martinko's dress or the gear shift selector after it was taken from the crime scene is not logical, it's not reasonable, it's not founded in the evidence, and quite frankly, it's not even within the realm of possibilities. Whether or not there was a documentation error on an evidence card, whether or not the state could present evidence that for 26 years the dress was checked every day while it was at the Cedar Rapids Police Department in the Evidence Bureau is not pertinent and germane to the issues in this case. Because there's no possibility that Jerry Burns' DNA could arrive on these items of evidence after they were taken into police custody. Also, based upon the defense's own theory in this case that you heard, that somehow a secondary transfer event occurred prior to when Michelle was killed that ended up with Jerry Burns' DNA being on this dress, their own theory makes any chain of custody issue irrelevant. The evidence shows no other items were contained within the package besides her own clothing. And therefore, there was no possibility of transfer of any other items containing any other foreign DNA. Only pure conjecture would result in a different finding. Most importantly, no circumstance has been reasonably presented in this evidence indicating any way in which the DNA of Jerry Burns would end up on her dress or any of her items of clothing other than it was there to begin with in 1979 when he killed her. Even more importantly, no circumstances have been reasonably presented in the evidence in this case, other than by the state that he killed her, indicating how Jerry Burns' DNA also happened to end up on the gear shift selector that night. The search for the identity of the killer, Michelle Martinko, continued for decades. Once a DNA profile of a suspect was developed from the gear shift selector in the dress from the crime scene, approximately 161 individuals' DNA was collected and compared to the profiles. The profile was also compared to millions of individuals in the CODIS system. Once the DNA profiles of the suspects were developed on the items of evidence, it was a huge break in this case. Investigators and crime lab criminalists, after multiple attempts, now had a suspect profile, just one suspect profile, after years of searching. One suspect profile present at the crime scene on Michelle's dress then dictated that the investigation now required that this person be identified. And those efforts continued for the next decade or so. We saw in State's Exhibit 8 a number of individuals whose DNA was collected and compared to the crime scene DNA profile, and in the manner in which they were eliminated. All individuals except for Mr. Burns. In 2008, after the profiles from the crime scene evidence were developed, a flood overtook the Cedar River in Cedar Rapids, limiting the ability of the investigators to be able to develop further DNA evidence from the physical items of evidence. Future examinations of the dress, as what took place in 2016, revealed that they were not able to develop another profile from the dress. But it should be noted and emphasized that the flood in 2008 did not impact the evidence that had already been developed from the crime scene evidence. There's pictures the defense introduced. I believe they're B1, C1, and F1. You'll see when you go back to the jury for deliberations. And it should be noted, ladies and gentlemen, those photographs are post-flood photographs and do not represent the condition of any of the evidence at the time the profiles were developed. In 2016, the case was handed off from retired detective Doug Larison to Matt Denlinger. At first, the same investigative measures were undertaken. Develop suspects, compare their DNA, repeat, etc., etc., etc. Then, as you'll see in this stipulation that was agreed upon between the parties, Matt came up and upon a new service being offered by a lab out of Virginia called Parabon NanoLabs. And a reminder, this stipulation is only to be considered as evidence of how leads were developed in this case, not substantive evidence of guilt. Also, the manner in which this was done is not on trial. It's provided to show you how the investigators in this case connected the dots. We heard that individuals in GEDmatch, a public online DNA database, may not have known that their DNA was being used for law enforcement purposes. But we heard that DNA was publicly available for anyone to use. And again, ladies and gentlemen, whether or not permission was obtained is not an issue in this case. We heard on July 19th of 2019, Parabon issued a report to Matt. And as a result of that collaboration the Cedar Rapids Police Department had with Parabon, Parabon suggested and directed the Cedar Rapids Police Department direct their investigation towards 3 brothers who were living in Manchester at the time Michelle Martinko was murdered: Donald Burns, Kenneth Burns, and the defendant, Jerry Burns. You heard investigators then developed a plan to collect covert DNA from these individuals. And then on October 29th, 2018, investigator Denlinger collected a straw used by the defendant at the Pizza Ranch in Manchester, Iowa, and sent it to the DCI crime lab in Ankeny. The evidence showed that comparison of that straw used by the defendant to the suspect male DNA profile on Michelle's dress revealed an outstanding development in the case. For the first time in the investigation, a suspect could not be eliminated. In other words, the DNA found on this straw was found to be consistent with the DNA at the crime scene. Meanwhile, the covert DNA collected from the defendant's brothers resulted in those items being eliminated as suspects, like the previous more than 161 suspects who were compared. You heard that later known samples were collected from the defendant's brothers that were also eliminated as contributors to the profile. The evidence showed that a subsequent known buccal swab collected from the defendant himself was compared to the suspect male DNA profile, resulting in a finding that the suspect male DNA profile for Michelle's dress was consistent with the known DNA of the defendant. At every possible loci where results could be compared, the defendant's known DNA profile was found to be a match to the suspect DNA profile. And this is Exhibit 11C1. Match, 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 all the way down, where results could be compared. In other words, you heard the probability of finding this profile in a population of unrelated individuals chosen at random would be less than 1 out of 100 billion. In other words, ladies and gentlemen, and we'll touch upon this again in a little bit, the evidence overwhelmingly and irrefutably showed that the male DNA profile found on the dress of Michelle Martinko in an area that tested positive for blood was that of the defendant, Jerry Burns. In this case, we saw the defendant was approached and interviewed by the Cedar Rapids Police Department. Matt Denlinger and J.D. Smith on the 39th anniversary of Michelle Martinko's death. In a video shown to you that is now in evidence for you to review, you saw statements made by the defendant that further demonstrate his guilt. The defendant acknowledged he was familiar with the murder of Michelle Martinko and acknowledged that he knew it had happened in December of 1979. He remembered it was a big deal back then. Pointedly and pertinently, ladies and gentlemen, when he was asked about this, he did not recall, oh yeah, I was there that night. Something somebody would certainly remember. Or even he was there any time near the time this happened. The defendant acknowledged he lived in Manchester at the time and that he always have and has lived there. During the questioning that ensued during this interview, the defendant answered a series of questions that demonstrated that there is no support for the contention made in this case based upon what he said when he was first interviewed as to how his DNA somehow transferred to Michelle Martinko's dress or the gear shift selector. He told investigators he never worked in Cedar Rapids. He said in 1979 he had no reason to be in Cedar Rapids. Said he never worked at Westdale. Said he never did any jobs there. He was shown a picture of her, said he doesn't remember her. Doesn't remember seeing there, and that he said he wasn't there. He was then told investigators had found some DNA.
Was murdered out in the parking lot there. And so they followed up on it for almost 40 years now. Mm-hmm. And so they've been just, following up on people. And then more recently, we had some of the evidence processed and we found some DNA. Mm-hmm. And so from that, we've kind of been reaching out to all these people that are in the reports and just kind of comparing them to see if we can find a match. And just so far, we just have not found anyone in those reports that we matched with. So.
And you saw his reaction when he was told that DNA was found on the scene. Then Matt drops the bomb he hadn't heard yet, but he had to have feared for years.
I'm just thinking, we kind of know going in that this is probably going to be a match.
Oh, really?
Yeah.
Why would that be?
I'm just thinking. We kind of know already this is going to be a match. You didn't hear a response that one would expect from a person who was just implicated in a homicide. Oh, no way. Can't be me. You got to be kidding me. Is this a joke? Oh, really? Why would that be? Matt then states the reality is we are not here on a whim. We are here to confirm what we already know. We know it will be a match to the DNA on file. And to that response, we then heard another response that was also peculiar. Again, we didn't hear no way, not a chance, can't be me, not possible. We heard an inquiry instead that one would make if they were actually concerned their DNA would be a match.
Yes, she need. The reality is we're not here on a whim. We're here to confirm what we already know. I already collected some DNA from you that you got rid of before. And so I'm telling you, Jerry, I already know that your DNA is going to match the DNA that we have on file.
Just one there I got rid of.
Just what would I have got rid of? Not a chance, can't be me, not my DNA. What did I get rid of? We then heard Matt say, the reality is, we have it there, and we know you were there. We don't know why it happened. There might be an explanation that would make this not a terrible thing. And to that response, we then heard a response that was also peculiar. Again, didn't hear no way, not a chance, not me, not possible. I don't have a why because I didn't do it. Here's what we heard.
How would we get your DNA at the crime scene there, Jerry?
I don't know. Test it, see if it is.
No, we did. How would it be there, Jerry?
I don't know.
What happened that night?
Wait for the test to come back.
Asked for an explanation of why this happened. Again, not I don't have a why because I didn't do it. I don't know. How will we get it there? I don't know. Test it and see if it is. And then you heard a response of a man, knew he had been caught, but wanted to buy some time. Wait for the test to come back. Test it and see what happens. Through that question and the subsequent answers in that interview, investigators would then systematically eliminate any other potential scenarios that could explain an innocuous transfer or secondary transfer event that took place. Matt said, is it possible you were out there and ran into some girl? Defendant, not possible. Possible you ran into her and said hi? Not possible. Possible you ran into her at the Orange Julius and said hi? Get into the wrong car, accidentally run into a young girl, say hi to any young girls? No. Questioning continued. Did you go to any bars? Didn't go to bars. Not that I can think of that time in my life. No substance abuse problems, but drank a fair amount back then when he was younger. More directly, we heard Matt ask the defendant what happened that night, and the defendant responded with another peculiar response. One not indicative of someone who was positive that he had not killed a young girl that night.
Do you think that may have contributed to what happened that night?
I don't think anything happened that night.
I don't think anything happened that night. It's not a hard question. Then Matt confronted him with Michelle Martinko's picture, black and white version of this. So take a good look at this picture. Really make sure this is someone you don't know. Then Matt asked a very simple question with a very simple answer.
Did you murder someone that night, Jerry?
Test the DNA.
Jerry,
Test the DNA.
why did this happen, Jerry?
Folks, that's a yes or no. Did you murder someone that night? Test the DNA. Well, guess what? We did. And guess what? It's Jerry Burns' DNA. Then we saw the entire video of the transport of the defendant to the Cedar Rapids Police Department. And we saw that not one time during that conversation did the defendant deny killing Michelle Martinko. You watched the whole video, but the state contends to you that the pertinent interactions took place toward the beginning at approximately 11 minutes and 28 seconds into the video at the time of 1:29. When Matt asked the defendant to explain what was going on that night and what was in his mind. Matt said, help me understand what was going through your mind. Defendant said, I don't recollect. Do you think it's possible this happened and you don't remember any of it? That's kind of, defendant, I don't know. I'm sure something like that would be possible to block out. Yeah, I think that would be possible to black out. For somebody to block out. Matt says, what's that? Defendant says, block out. Matt said, you think you may have blacked out? Yeah, I don't think you probably blacked out either. Defendant said, no, I didn't say blackout. I said you blocked things out of your memories. Oh, you blocked things out. I got you. I'm with you now. How was everything going at that time? I don't know. I don't know. You're only 25. You're an old man. Whole world apart now, right? Yeah. Wish you could go back there and talk some sense into that kid. Huh? 2 young kids at home. Help me understand what was happening. Help me understand, Jerry. I don't know. Then we heard Matt brought this statement back up at the station and reminded the defendant what he had said during the transport. The defendant confirmed he said it and confirmed that there are some traumatic things you just block out. In this case, we heard from a man named Michael Allison. What did we learn about Mr. Allison? We learned he served our country overseas in uniform in Iraq. We learned that after 2 years of deployment, he returned to the United States, tried to start a life like many of us have, spouse, kids, job, but also like many people we know in our lives, he fell into the grips of substance abuse. Became involved in not only the consumption of illegal drugs, but the delivery and sale of drugs. And nobody up here on this table is defending anything that Mr. Allison did. Some pretty bad stuff. His path crossed that of the defendant, having been housed in the same cell block together. As we heard, and as we all saw when he testified in this case, the defendant viewed Mr. Allison as what Mr. Allison said. He described him as a normal guy, not like some of the others in jail. And so he became someone the defendant became close to and opened up to. Mr. Allison reported that he considered the defendant to be a father figure and thought he was a pretty calm guy at first, and the defendant would refer to him as son on occasion. Those interactions were steady at first, chatting while playing pinochle, discussing their life experiences. But as we heard one day, when Mr. Allison was speaking about the regrets that he had in his life, about becoming wrapped up in substance abuse and all the bad decisions he'd made, to that the defendant would tell Mr. Allison that his only regret, or his regret he had, was not cleaning up his mess. Not regret for killing a young girl, regret for not cleaning up his mess. The defendant told Mr. Allison that in 1979, DNA wasn't a thing. On January 11th, 2020, just a little over a month ago, having seen an article about this case in the newspaper, Mr. Allison asked the defendant in jest if he'd autograph it. Surprisingly, the defendant not only autographed it, but inscribed with a cryptic message, also indicating a sense of pride, "To my favorite son, Michael, signed Jerry Burns." Video evidence, not containing audio, but showing what transpired, was introduced and played at trial, showing this interaction take place. Mr. Allison reported to us at trial the defendant's rendition of his encounter with Matt Denlinger in the hallway during a previous court appearance, where the defendant said he knew they may have got him, but he wasn't going to bow down, and looked Matt right in the eye. And then we heard from Matt that he recalled this very same interaction take place, and that the look they exchanged was more than a passing glance. And for the record, there's evidence shows no prior collaboration between Matt and Mr. Allison. The state submits that this, like the video and the newspaper copy, supports Mr. Allison's testimony. Mr. Allison then testified he asked the defendant directly whether he did this, to which the defendant replied eerily, "I can't talk about it." When asked, Mr. Allison reported the defendant has never said, like he never said to Matt in the transport car, that he didn't do it. Mr. Allison reported to us when asked what the defendant indicated as to his feelings about the potential outcome of this case, the defendant provided a response that provides us some insight into his mind. The defendant reported no matter the outcome, he felt he had won because he got to raise his kids for the last 40 years. And then finally, Mr. Allison reported to us what the defendant said that led him to reach out through investigators and prosecutors to tell us what happened. He said while playing cards with the defendant, as they often did, Mr. Allison said he hit a hot streak. Began beating the defendant. And the defendant made a comment to him that further revealed the manner in which the defendant views the evidence of what he did 40 years ago. He said to Mr. Allison, if you keep beating me, I'm going to have to invite you to the mall. Mr. Allison reported he was disgusted enough by that comment. That was the final straw. So he reported what the defendant had been saying without a plea agreement, without any agreement as to reduction in sentence. This man took the stand, came forward, and told us what the defendant said to him. Now I want to summarize for you, if you'll please continue to indulge me further, what the experts said in this case. Starting with Michael Peterson, who in 1997 examined Michelle's dress. On Michelle's dress, a portion of an obvious stain near where she had been stabbed was extracted for DNA and a known sample of her blood was developed. He also examined Exhibit I, which was described as a tape lift from the blood observed on the shift selector. Presumptive testing showed this area contained blood, and no other presumptive tests were done, as we heard. The gear shift selector showed imbalances indicating a mixture of DNA from two sources. Then we heard from Linda Sauer, who said, it wasn't until DNA that we could establish identity. In 2002, we heard that criminalist Linda Sauer first examined Michelle's dress and was able to identify a complete result of what was determined to be her blood. And that subsequent examinations, including that one, would reveal 8 more locations that showed the presence of what was believed to be her blood on that dress. We heard that Sauer examined what was described as blood from the gear shift selector. Again, what was determined to be the tape lift from the gear shift selector where blood was observed. She noted what was described as blood from the gear shift selector was a smear, not a tight-held stain. She used a cotton tip swab moistened with distilled water and collected a sample, finding results at 9 of STR loci in the sexine locus. And screening tests again indicated the presence of blood at that location. The results showed the major contributor of that location was Michelle. She could conclude that the minor contributor at that location was a male. Of the loci that she was able to develop from that male minor contributor, the results found that they matched the same loci of the male profile she would later find on F5. In 2003, the dress was resubmitted to Linda, and more areas were found that tested positive for the presence of blood and were consistent with each other. She used a high-intensity light at different wavelengths. And we also heard that in 2003, she noted the presence of a few spermatozoa in her underwear. And folks, I want to make a couple points about that. One, there was no indication from this attack that Michelle Martinko ended up being sexually assaulted. The source of the sperm is not and has never been implied to be the person who killed her. Further speculation we submit to you of the source of this sperm can only reasonably conclude that at some point previous to her being killed, she may have had a sexual encounter with the male. Nothing else. Then in 2005, Linda examined the dress using the intense light beam to try to locate additional possible stains. She has selected stains from as wide an area as she possibly could, finding stains on the front, the side, and the back of the dress. All those areas tested positive for blood. And that's when she found what notoriously became known in this case as stain F5. As we heard repeatedly in this case, F5 did indicate positive for the presence of blood. And at F5, she found what her report revealed was a partial male profile with complete results at 11 loci and partial results at an additional 2 loci. She then reported, based on generally accepted standards for DNA profiling as recommended by the FBI for certified laboratories, that fewer than 1 in 100 billion unrelated individuals would have this same partial male profile. And this is a significant finding because, as she explained to all of you, if you have a result that is found in fewer than 1 in 100 billion individuals, and there's only about 8 million people on Earth, the probability of finding 2 is so small it can be discounted. And as she told us during trial, the importance of finding this profile is now investigators had a profile to compare to other individuals to find a suspect. She found that the results at F5 indicated a minor contributor whose DNA was mixed with the male major contributor, and that the minor contributor was consistent with the DNA of Michelle Martinko at 2 alleles, and that she could be the source. The gear shift selector sample was also compared to the partial male profile. Linda found that the donor of F5 could not be eliminated as the male contributor to the gear shift selector. Importantly, from her examination, a fact remained in this case that never changed. And that's that there was only 2 single source profiles developed from the evidence in this case. By single source, this means only 2 individual strands were detected. 2 individuals, 2 people. 1 female, Michelle Martinko, 1 male, later found to be Jerry Burns. We heard from criminalist Mike Schmidt, who's been with the DCI lab since 1998. He began working on this case in approximately January of 2017 and participated in the elimination of several suspects' DNA through profiling and comparison. We also heard that he was able to determine through his investigation the profile developed from the hair root that was found in Michelle's vehicle was found to be that, or consistent with that, of Mike Wyrick, Michelle's boyfriend at the time. He then became aware of Matt's efforts to collaborate with Parabon and went along with it. And on October 13th, 2018, he received a straw collected after immediately being used by Jerry Burns for analysis, and he told us his rendition or his response to the findings that he believed them at the time to be unbelievable. Investigators were able to find a person with the profile that could not be eliminated as a major contributor to F5. Again, at every location where results could be compared, the profile developed from the straw matched the profile from the major contributor from F5. In other words, they had their guy, but they needed a known sample. He also heard and received evidence that a straw used by Kenneth Burns was collected and submitted, as well as Kenneth Burns' known DNA. That was referred to as State's Exhibit 11B. However, having learned that a known sample is needed to eliminate a person or contributor, in the interest of expediency, that report was not discussed or introduced, but instead, you saw in State's Exhibit 11D, as in dog, that Kenneth Burns' known DNA was collected, and he was eliminated as a contributor to F5. You also learn from Schmidt's testimony, as well as State's Exhibit 11D, again as in dog, that Donald Burns' known DNA was collected and compared to F5, resulting in Donald Burns being eliminated as a contributor to F5. Finally, from Michael Schmidt, you heard that on December 19th, 2018, immediately after he was interviewed by investigators, the DNA of Jerry Burns was collected and submitted directly to the DCI lab. And on January 9th, 2019, as set forth in State's Exhibit 11C, Schmidt found that the partial DNA profile of the major contributor previously developed from stain F5 from the black dress was consistent with the known DNA profile of Jerry Burns. Again, with the probability of finding this profile in a population of unrelated individuals chosen at random to be less than 1 in 100 billion. Further elucidating the significance of these findings, Schmidt told us that he's only ever seen a profile of related individuals match at 6 or 7 alleles. Far, far less than what we see in these samples. He also told us that only identical twins share the same profile. There's obviously no evidence that Mr. Burns has an identical twin. And as we heard, his closest relatives, his brothers, were positively eliminated. So safely, we can conclude, and we should in this case, that this profile was not that of a relative of Mr. Burns, that it was indeed Mr. Burns. In other words, given the findings, the evidence showed that the DNA from the major contributor to F5 stain that tested positive for the presence of blood was that of Jerry Burns, the defendant. We also heard from Christina Nash. She's a senior DNA analyst at Bodie Lab. Lives in Lorton, Virginia, far, far away from Cedar Rapids and Davenport. No interest in this case other than science. And like the rest of the state's experts, she's also a certified forensic DNA analyst who actually works in the laboratory. As we heard, Bodie Technologies receives requests from agencies all around the country for all kinds of cases from both sides of the aisle, and that at times Ms. Nash even works on the Innocence Project. She conducted an analysis of the same extract that was taken from the gear shift selector, and she developed a profile from it. She received the known buccal swabs of the defendant and developed a profile from that as well. She conducted a different analysis that we learned about called a YSTR analysis, intended to focus upon the Y chromosome and develop a profile of the male contributor to the sample. And she only found one single source profile from the analysis, meaning one individual strand from one male. And as you saw in State's Exhibit number 12, she was able to develop and compare these profiles and compile some significant results. This is the allele table. Results are compiled at 23 different locations. And going locus by locus at every location, she found there to be a match between the profile developed on the gear shift and that of Mr. Burns. The statistical method she used, she referred to as the counting method. It's a little bit different than the random probability match, but significant nonetheless. She searched for the profile on the YSTR databases used by Bodie, and applying their confidence level, she was able to conclude at a 95% confidence level that we should expect to see this profile in only 1 in 1,773 U.S. males. In other words, 99.94% of individuals would be excluded from this profile. We also heard from defense expert Michael Spence. And here are some of his quotes. He said, "Transfer depends on contact and proximity. And boy, doesn't it." He said, when we presented the scenario of an individual, a killer hovering over the top of a victim, as in this case, that it would be a near absolute certainty that that person's DNA would end up on the victim. Then he said it was within the realm of possibilities that his DNA ended up there through an unknown secondary transfer event. We asked Dr. Spence, what's not within the realm of possibilities? He said, that's a good question. Then we shared a conversation about some of the deeper aspects of life and how we may all be living in a dream, something along those lines. Well, I think we all know this isn't a dream. This is reality. But you watch, folks. You watch. In a moment here, when you get to hear from the defense, you may hear about some endless possibilities. We submit to you those will not be based upon the evidence, but will be based upon the depths of imagination. He also said, as we noted, there's no question that the male DNA at F5 is clearly consistent with Jerry Burns. Their own expert said that. Then we heard a tale of a fingernail secondary transfer story, which, although riveting, was not at all comparable to this case. There exists no evidence in this case other than that Jerry Burns killed Michelle Martinko, of a situation where there could have been a secondary transfer like what was revealed or what was discussed in that story. In that story, there was an obvious link that was uncovered. In this case, there's zero evidence of any link besides the fact that he killed her. Indeed, we heard Michelle Martinko had close contact with all sorts of kids that night and other individuals at the banquet and at the mall. And not one spurious bit of DNA from any of those other individuals was found on Michelle's clothing. We heard Spence say and claim that it was best to repackage items separately after they were found packaged together in a laboratory. But then we heard from the director, the supervisor at the DCI labs, who again has actually worked in a lab over the last 38 years, disagree and say that we don't do that in our laboratory because we want to protect chain of custody. And then in a nod to some prior work that Dr. Spence did in a civil case, he introduced us to the product rule, where he could determine the random probability of finding the same profile in two locations at a crime scene, resulting in a pretty impressive number using the figures in this case, which was something along the lines of 1,773,100 billion, or something like that. But we, quite frankly, don't need that number to show you what we've proven in this case. We heard from Paul Bush, criminalist supervisor at the DCI lab. His resume is extensive and covers many areas, including DNA forensics and also crime scene analysis. He was a crime scene analyst for 25 years and worked over 200 cases of crime scenes. Dr. Spence told us he never worked a crime scene when he was working for the Indiana State Lab. He also spent 10 years as a DNA technical leader working in quality assurance, and told us that he performed technical review of over thousands of cases over his career. Paul said, science can put an individual at a certain place based on DNA. He told us that based on Linda's results on quantitation of the amount of DNA, there was more than enough there to perform an analysis and that no additional cuttings were necessary. He also told us that the size of the blood stain does not correlate to the amount of DNA in the stain. So inferences from the table that was produced in Defendant's Exhibit 10-1, Linda's document, should not be drawn from the concentration of DNA as to the size of the original blood stain. He told us, based upon this review of this case and his vast amount of experience, the most scientific explanation of how DNA consistent with that of Jerry Burns could have ended up on Michelle's dress was based upon information in the case. The victim was stabbed. There was evidence of a struggle and her fighting off the assailant. Screening tests on the area where the DNA was found indicated the presence of blood. The results we have are consistent with blood from a perpetrator bleeding on that dress, and the likely explanation of the presence of his blood would be that he bled from cutting himself during the stabbing. The major profile of the DNA developed from the likely blood source is consistent with Jerry Burns to an impressive degree. And finally, he confirmed from the review of all the findings in this case, blood was found on 9 areas of Michelle's dress. 1 female profile was developed. 8 of those areas were the same and were determined to be the blood of Michelle Martinko. And 1 male profile was developed that was found to be consistent with Jerry Burns. And the DNA from no other person was found on that dress. So, ladies and gentlemen, the evidence overwhelmingly demonstrates what we submit to you are 4 key facts in this case. And as a point, these are what we believe to be 4 key facts, but even without these 4 key facts, there's plenty of evidence to show that the defendant committed this offense. First one, the defendant's DNA was found at 2 locations at the crime scene. Second, we believe the evidence has shown the DNA found came from his blood. Third, the defendant bled from cutting himself when he repeatedly stabbed Michelle Martinko to death. He bled on Michelle Martinko and smeared his own blood on the gear shift selector. The defendant acted with deliberation, premeditation, the specific intent to kill, and malice aforethought. I want to take a moment here and talk about a few jury instructions. First, I believe this is instruction number 6. You must determine whether the defendant is guilty or not guilty from the evidence in the law. Next one, instruction number 9. A reasonable doubt is one that fairly and naturally arises from the evidence in this case, or lack or failure of evidence produced by the state. A reasonable doubt is a doubt based upon reason and common sense, and not the mere possibility of innocence. If, after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubts, and you should find the defendant guilty. You must base your verdict only upon the evidence. A theme develops throughout these instructions. Evidence is testimony in person, exhibits, stipulations, so on and so forth. Instruction number 12. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. And that's all we're asking you to do here, folks. Base your decision on your common sense and the evidence. The defendant's DNA was found at 2 locations at the crime scene. Look at the profiles. Look at how they match at every loci. Consider the random match probability statistics. Consider the testimony of all the experts, including Dr. Spence, and that there was no real dispute with the determination that the DNA found at F5 on Michelle's dress was indeed the DNA of Jerry Burns. And no real dispute that it was his DNA on the gear shift selector as well. The evidence overwhelmingly and indisputably shows this is his DNA. The DNA comes from the defendant's blood. Presumptive tests at both F5 and the gear shift selector showed the presence of blood. The presence of another fluid can only not be ruled out because no other tests were done. Not because there is evidence of other fluids there. Therefore, we submit to you there is no evidence beyond mere conjecture that his DNA originated from any other fluid at those locations. Conversely, all of the evidence in the surrounding circumstances in this case of Michelle's death, the defendant's statements he made during his interviews, or more so, his lack of denial, his statements to Mr. Allison, the evidence as a whole all support a finding that his DNA at the crime scene originated from blood. The most scientifically supported theory is that the defendant's DNA at the crime scene originated from his blood. The near absolute certainty that Dr. Spence offered us to explain the presence of suspect DNA at the crime scene involved this very scenario when we presented it to him, and supports his DNA being there as a result of blood. Conversely, Dr. Spence and the defense can only point to the realm of possibilities to explain that his DNA arrived there through some undefined secondary transfer event. Next, the defendant bled from cutting himself when he repeatedly stabbed Michelle Martinko to death. He bled on Michelle Martinko and smeared his own blood on the gear shift selector. There being no alternative theory to support or supported by the evidence as to how the defendant's DNA from his blood, or any fluid really, arrived at the crime scene, and given that Michelle's blood and DNA is mixed with his, the evidence shows this only could have happened because he cut himself when he repeatedly stabbed her, and that she bled from being stabbed, and that his DNA mixed with her blood after it shed from her body. and her blood was mixed with his DNA as he smeared it on the gear shift selector when he took control of the vehicle. The defendant acted with deliberation, premeditation, a specific intent to kill, and malice aforethought. I want to go over instruction number 14. Where two or more alternative theories are presented, or where two or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It's the verdict itself, which must be unanimous, not the theory or facts upon which it is based. Why am I bringing this up? At the beginning of my closing argument, I provided to you the scenario that we believe supports what occurred in this case. As you discuss this case and as you deliberate, there may be different ways in which you conclude happened or which you believe happened, but if they lead to the same result, the defendant's guilty, you don't have to agree on how it happened. You don't have to agree on the theory as long as you believe all the elements have been proven beyond a reasonable doubt. This is a long one. Malice, a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with evil or unlawful purpose. Malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. And it doesn't have to exist for any particular length of time. Willful means intentional or by fixed design or purpose, not accidental. Deliberate, weigh in one's mind, consider, contemplate, premeditate, think or ponder upon a matter before acting. And this is important. Deliberation and premeditation need not exist for any particular length of time, but must exist before and at the time of the act. We don't have to show that there was some kind of blueprint or plan drawn up for this. Just that at the time the act occurred, right before it or at the time the act occurred, that there was deliberation and premeditation and malice aforethought. If the person has the opportunity to deliberate and uses a dangerous weapon against another, resulting in death, you can infer that just by use of the dangerous weapon, malice, premeditation, and specific intent to kill. So folks, this is really kind of an easy one. The actions of repeatedly stabbing and attacking Michelle in this way can be construed in no other reasonable way than being done with malice. The specific intent to kill, deliberation, and premeditation, over and over and over again. Submit to you this will be the easiest element for you to find. So, we believe that we've proven to you the defendant is guilty of murder in the first degree. That on or about December 19th, 1979, the defendant stabbed Michelle Martinko. That Michelle Martinko died as a result of being stabbed. And that the defendant acted with malice aforethought, willfully, deliberately, premeditatedly, and with the specific intent to kill Michelle Martinko for all of the reasons that we've discussed here today. Now that we've proven that Jerry Burns killed Michelle Martinko, you may still wonder why. As we discussed when we first started this case during jury selection, the state is not required to prove motive. And that makes sense because it's a deep topic. As I'm sure the defense will remind you soon, we all live in a world with each other where we intersect on a daily basis. We all carry with us not only our unique and individual DNA, we also carry our story. Memories of joy, happiness that bring us back to the better times in life, and memories of sadness, tragedy, and trauma that haunt us and remind us how life can sometimes be cheerful and life can sometimes be tragic. Look around you and you realize you may not have a full comprehension of what those around you have been through and what defines them. Those around you may not be able to tell you what defines them. because of how complex their lives have been. The witnesses in this case carried their story with them for 40 years. You wouldn't know it if you saw them. They look like you and me, each other. Work, have spouses, have kids, maybe grandkids. We don't know a lot about them in passing. But undeniably, we all carry a story with us. Some of those stories you may never be able to predict. Some of those stories may be unbelievable just by looking at somebody. Some of those people have to live with the stories of their past and learn to cope with them, to cope with what happened. In the cases of the witnesses, in this case, civilian and law enforcement, criminalist, retired, active duty, they all live with the knowledge that they possess about this case. And in the case of Mr. Burns, we submit to you, they learned to live with what they did. So people learn to live with their past. They learn that they can either take those events and let them define them, or they can do the opposite. And sometimes the only way they can live with their past is to block it out. Point is, you never can tell by looking at somebody what's occurred in their life to bring them in front of you at that point in time when you interact with them. When you confront them, you can never be sure what people are capable of. That's the thing about human behavior. People are capable of the kindest, gentlest, most loving things. But people are also capable of the most evil and sordid. We make decisions every day that affect the lives of others around us. As a result of those decisions, many things can happen. And as a result of the more severe decisions, as in this case, some people live and some people die. But the ramifications of those decisions are always there. They may be immediate, they may be delayed. But the facts and circumstances that underlie them do not go away. They remain, as science has taught us, undetected and undiscovered until they're brought to light and can no longer be denied. Thank you.
Thank you, Mr. Maybanks. Ladies and gentlemen, I am going to give you a 10-minute recess. We will be back to hear the closing arguments on behalf of Mr. Burns given by Mr. Spies, but we will be in recess for 10 minutes.
Please rise for the jury. You can leave your notebooks on your chairs.
All right. That was long. It's an hour and 22 minutes. And I will recap as best as I can here. And Ken Rosenberg, I'm going to take what you posted. And you said he's taken the 3 things you want to do in a closing and separated them. Tell the story / theory, tie facts back to witnesses, be the first one to apply the facts to the elements. So, that was very well written. So I'm going to use that with full accreditation to Ken. All right, so I got questions for Mr. Mayflower. What's his name? I don't want to disrespect him like that. Sorry, it's getting late. Let me get his name. Sorry. Nick Maybacks. Okay, Nick. All right, we're going to go through this because we heard something that we had never heard before. We heard about the sperm, but didn't hear that she was active beforehand. All right, so it was Christmas time and he went shopping at the mall. Jerry was never Jerry, they never once in the entire trial said that Jerry was at the mall doing shopping. So right out of the gates, I'm like, what? How are you saying that he was at the mall? I mean, yes, his DNA is all over the place. We get, well, not all over, but is on the back of the dress. But how could you not have tied that in the trial during testimony or something? I don't know. So Michelle was popular and liked to dress up. She was friendly. She was friendly to everybody, sweet, kind, friendly, and smart. She went to the choir concert banquet. She hoped to hang out with Jane, but Jane had to go back to do her homework. Jerry noticed, see, now here's where it gets just complete. I mean, a fabrication, which I guess they can do, but no basis of fact whatsoever in the next couple lines. Jerry noticed Michelle alone. Jerry followed her. Kurt sees that goodbye smile, but she left through another exit, and that was corroborated by Cheryl Anders. Jerry saw her leaving and descended upon her. She was carrying a shopping bag and a purse. Okay, so I'm trying to visualize this as it's going on. So she opens the back door, puts the bag in the back, which we knew. She gets in the front and begins to drive away. He opens the car door and leaves an imprint on the door button. I guess that's the front door. Then he uses a knife and he hits her in the back of her left head. I understand that, but if she's driving away and the door opens, she's going to look at him and she's going to be like, what the hell? Isn't she going to like step on the gas? Or she's looking at him this way. How does he hit her on the back of the head? So at first I thought, oh, he opens the back door and he hits her on the back. Got some problems with the way May Banks told the story. I think it could have been put together a little bit better, because right now I have doubt. I mean, not that Jerry did it. I know Jerry did it, but I don't like the way I have trouble with the way he described this. All right, so let's continue on. So he opens the front door. She looks at him apparently. Anybody would look at, if you're driving away, door opens, you're going to look over. He brandishes the knife. He hits her on the back of the head. She falls back on the car seat. She's not immediately incapacitated. And again, what was the purpose? Was he there to essay her? Was he there to rob her? They never really make that clear. I guess they don't know what the motive was, other than just to offer. He struggles to subdue her, but she sees him now. She sees him and does not know him. Adrenaline kicks in and they struggle. He begins the attack, no longer incapacitating her to get what he wants, which we don't know what is that, because they never he never admits it, so we don't know if he was going to rob her or do something else. So now he must kill her. Wasn't he going to kill her to begin with? I don't know. I thought that he was going to kill her to begin with, but maybe not. Blood is flying everywhere. 2/3 of her blood is lost. 11 times in the face, neck, and chest. She has tossed and turned and bled on the back of her dress. He must act to avoid detection. She's lying in her blood. He considers driving the car somewhere else. Again, complete speculation. He would have to come back to the mall because he drove there. He put the car back into park and used the gear shifter selector. Gets out of the front seat and leaves blood on the front door handle. All right, that's pretty big. Drives back to Manchester. And then at 11, Phoebe Smith leaves Pier 1 Imports and she sees the car. So I guess the mall closes at 9, but Cheryl Anders saw her around 10, I think she said. So then between 10 and 11, so this happened between 9 and 11, I guess. But the car was askew. So if he got in the car, okay, so she's driving away, so she's not in a parking space anymore. She's driving away, the attack happens. He had to have driven the car somewhere because the car was askew in the parking slots, whatever you want to call those. So he had to drive the car somewhere. And I wish he had said that. Maybanks didn't say anything about that. Thank you, Ola. Speculation was a bit crazy. But he didn't say anything about the car being askew. So he definitely drove the car. I have no problem with him getting in the car. You know, the attack happens or whatever. Or he holds her at knife point, says, and drives away and goes somewhere, parks the car somewhere else, or he does it there. I mean, would he really do it right there? I mean, this is a violent attack. And if she's driving away, she's parked with a bunch of other cars. Everybody's coming out. I just do not see this happening the way he said it. I don't know. I'm not. I know Jerry's DNA was there. He's guilty in my mind, but I just do not like the way it was described how this happened. So Michelle was discovered at 4 a.m. They accessed the car through the back door. Police came to the crime scene. They removed Michelle from the passenger side seat. There was no contact from the dress or the gear shift selector because she went that way. She didn't come this way. There was blood on the wheel, the dash, the passenger side seat, keys, gear shift selector. So he did touch the key. So he did move the car. So I wish he had said something about that. I don't think he did. Yeah, Shirley, he mixed up the story. Or she was a crappy parker when the lot was full. I rescue barking dogs. Yeah, maybe. Scrapings remained until 1996. The blood was tested and all evidence was properly preserved until March 2019. Stab wounds in her lung pierced her aorta. Severe blow to her head, which caused internal bleeding. I'm not sure why he said that. Internal bleeding in her head? I don't remember them saying that. Assailant was facing Michelle. He pushed her on her back and he was stabbing her. There were 161 DNA samples. Compared to millions of suspects in CODIS, one suspect profile from Michelle's dress, which was male. So they narrowed it down to that. All individuals were eliminated except Burns. 2008 flood limited the ability to develop more profile, but they had enough. The flood did not impact what they already had produced. In 2016, the case was handed off to Matt. And then Parabon turned law enforcement on to the Burns brothers. The straw was collected from Jerry along with the garbage from the brothers, and they made the hit. They got the hit at that point. DNA was consistent from Jerry, matched to the dress. Let's see. Probability of finding this profile unrelated individuals is less than 1 out of 100 billion. And then they get to Jerry acknowledged that he heard about the murder. It was a big deal back then, but he said, I didn't recall. You know, I don't know. I wasn't there that night. I never worked in Cedar Rapids. There's no reason to be there. No jobs were there. He doesn't remember Michelle in that regard. And Jerry said when he was confronted with, this possibility, he's like, test the DNA. He never once said it wasn't me or oh my gosh, whatever. He just said test the DNA. And then Maybanks is like, guess what? We did test the DNA. Jerry never once denies offing Michelle. And then there was the whole blackout or blackout. And he says, I said I blocked things out. I didn't say I blacked out. So that was kind of a big moment. I remember that in testimony. And then we get to Michael Allison, who was the inmate. And he says, the only regret I had is when I told Michael Allison about not cleaning up his mess. The sperm, they talked about the sperm. There was no indication of SA, but then the source of the sperm is not from the person who attacked her. So this was huge. At some point, she had a sexual encounter with somebody. So at some point that evening, our dear Michelle had a sexual encounter with somebody, which isn't a big deal because we did hear that she had a couple boyfriends. She went to spend a weekend at a college with, I forget his name right now, her boyfriend. They went to go see, Kansas. They went to go see Kansas. She went to the prom with him, the spring prom. Who the heck was, what was his name? Dang it. Sorry. Oh, I should have this. Here he is. Mike Wyrick. Yeah, he went to the spring prom. Mike Wyrick. So, and she went to, she spent a weekend with him. So when I heard that, I'm like, ooh, okay. So I think they were trying to, defense was trying to go after that, where she may have gone to a bar, she may have picked up somebody that had happened, So she was sexually active. And she clearly had an encounter that night, or at some point that night. So January 9th, 2019, partial DNA profile from F5 was consistent with Jerry Burns. Christina Nash developed the DNA profile. And then he recapped Paul Bush's testimony, which we heard he was the last witness in the rebuttal. Andy was the other boy, Capri Law. Yeah, was that his name? Andy? Let's see. What was the other? So Kurt Thomas was the one who said goodbye to her. So who was in the chat? Somebody said that they thought Kurt was sus. Let's see. Jeff White. I don't think he was Andy. Oh, okay, yeah. Andy was with Merlin, and he knew. Okay, yeah, he knew Mike through Larry Zenick. Okay, yeah, you're right. Charles Andy Seidel. I'm sorry, you're right. Yep, Andy Seidel was her ex-boyfriend, and Mike Wyrick went to took her to the prom, and I think he's the one that he went to college, Iowa State, I believe. All right. 4 key facts. DNA found in 2 locations at the crime scene. DNA came from his blood. Blood came from him stabbing Michelle. Acting with premeditation. Guilty from all the evidence presented. I would say so. I just have issues with the way he presented the actual event because I really wanted to get that down. I think he could have done better with that. And the DNA was at the crime scene was generated from the blood. It wasn't skin cells. It wasn't saliva. It wasn't hair follicle. It wasn't anything else. It wasn't semen. It was from the blood. Okay. All right. So Ken, did he tell the story? He told the story. Have some issues with it, but he told the story. Did he tie the facts back to the witness? Absolutely. And was he the first one to apply the facts to the elements? I would say yes. All right. Let's see. Any questions, you guys? Curvio, pretty sure they know she died between 8 and 10. Yep, because of the time they found the body, they know the temp. Oh, and also Curvio, she had food in her system. The one, let me see, who was that? Where did our food? No. Undigested food in her esophagus. Meat was not digested. Died within 3 hours after she ate. So, and she was, they said, and then the other guy, okay, that was Dr. Richard Feister. He was the retired pathologist. I thought he's the one that gave the time that it happened. He did the autopsy, and he did it around 8:30, and she had been passed away for 6 to 10 hours. So if he did it at 8:30, 10 hours would have put it around, 10. So so that jives. So she, and then don't forget they saw Phoebe, who worked at Pier 1 and went to drop off the money at the bank. She saw the car at 11. So and Michelle left around 9. So it happened, between 9 and 10:30, I would say. All right. Yeah, she was so beautiful. She sure was. All right. Let's move on to defense closing. So this one is 51 minutes. This one is going to be 51 minutes. So set your schedules accordingly. It's not as long as state.
The record
Nope, don't want to do that.
should show.
Okay, let me go back to this. All right, I'll see you guys on the other side of this. Sorry, Michelle. Let me put myself down. Okay. Okay. See you on the other side.
The record should show that members of the jury have returned to open court. Counsel and Mr. Burns are present. We are ready at this time to hear any closing arguments from Mr. Spies on behalf of Mr. Burns.
Thank you, Your Honor. May it please the court, counsel, and Jerry Burns. I am pleased to be here to speak on behalf of Jerry Burns. When I had a chance to speak with you about 2 weeks ago, I talked about the encounters that we have day to day, people to people, people to objects, objects to people, and the exchanges of genetic information that we share every day, and how that genetic information tells us much about what we are, but not necessarily who we are or where we've been. Much of this case, as we've heard over the last 2 weeks, talks about the diligent efforts made by law enforcement over the past 40 years to try to uncover the secret about who killed Michelle Martinko. And there is no criticism about the diligence of that efforts. But importantly, as I mentioned to you again 2 weeks ago, it's our contention that the evidence shows how that path, that investigation took a divergent turn, and that turn has inevitably led wrongly to Jerry Burns, and why Jerry Burns is not guilty. Michelle Martinko was a vivacious, attractive, talented young woman in the bloom of life. And in 1979, when she went to the Sheraton Hotel in Cedar Rapids, Iowa for the choir banquet, and then either by boredom or in search of a coat that had been set aside for her by her mother to Westdale Mall, she had every expectation of a full and vibrant and enriching life. Now, we know from the evidence in this case that the investigators showed and were able to determine, and from the testimony of her friends, that she went to the Westdale Mall, she encountered a number of people that she knew, either from school or elsewhere. And during the course of that time, she spent 40 to 50 minutes with Kurt Thomas. And you remember Mr. Thomas talking about how he had left his job there at the Westdale Mall, that they walked around the mall together, went to the Orange Julius where Mr. Thomas had something to eat. We also know from Andy Seidel, Michelle's former boyfriend, that about 4 days before her death, she had expressed to him her fear and her concern about a grotesque or an ugly man who had been stalking her at her job at another mall. But as Kurt Thomas and Michelle walked around the Westdale Mall, went to the Orange Julius, sat down with Mr. Thomas eating, we know that they sat on a chair or they sat on a bench. Mr. Thomas, we know, had something to eat. We don't know whether Michelle had anything to eat, although the autopsy report showed that she had undigested food in her stomach and undigested food in her esophagus. As she walked throughout the mall, she encountered still more people. She saw benches, she saw chairs, she saw counters, she touched objects in stores, she touched objects throughout the mall. We also know from the evidence that as she left the mall, somewhere between 9:30 and 10 o'clock, the mall closing time, she would have walked up to an exit door, pushed that door to go out of the stores. She was not wearing gloves. We know that from the evidence and from the photographs of the crime scene. She had a scarf around her neck, knotted around her neck. As she went out to her car, there were no witnesses to what happened there. Hours later, when investigators came to the scene in search of where she might have been, they found her huddled in the lower part of the passenger side of the car, dead from multiple stab wounds. She was in her parents' car, a car that her mom and dad had driven. She, of course, had been brutally stabbed, and as we know from the autopsy report and the photographs, all of the stab wounds, except for a couple, were inflicted and penetrating open flesh, which is an important thing for us to remember as we go along in tracking what happened that day. We know also as well from Dr. Feaster and from the investigators that there was no evidence that this was a sexual assault. The investigation and the evidence that pursued the tracks and the trails that we're going to be following in the next several minutes all stem from the supposition that Michelle Martinko on December 19, 1979 was targeted. Her assailant had rubber gloves. He had a substantial knife, or she had a substantial knife. She had been followed. She had been stalked, and she was targeted. She was targeted. The evidence shows, and I'm not going to catalog it exhaustively because you've listened to it carefully, the investigators showed that whoever was equipped with these instruments of death was prepared and carried out a mission that had been accomplished only by preparation and planning. The wounds, in fact, aside from the wounds that were intended to kill her, were intended to disfigure her. Now, investigators found inside the car that the car interior was blood spattered. There was fur throughout the car from her rabbit fur coat. They also found that there was no trail of blood or blood drops around the car, no indication that someone had carried out blood outside the car or had left a trail of blood from a wound. We also know that in moving the car that night, investigators had to get inside the car, turn the ignition to on, turn the shifter to neutral so that the car could be towed to the Cedar Rapids Police Department. Now, throughout the investigation that ensued from that point on, the handling of the evidence, the integrity of the evidence is critically important. Because remember, we're dealing with a situation involving cells, involving genetic material, involving minute pieces of evidence. And all of that evidence has to be carefully handled and carefully considered throughout the course of the entire investigation. We know that at the autopsy that Michelle's clothes were taken off from her. They were turned over to investigators from the Cedar Rapids Police Department, where they were then taken to the Cedar Rapids Police Department to be dried and cataloged. The course of that evidence from that day forward is critically important to your consideration of both the integrity of the investigation, the integrity of the evidence, and the uses to which that evidence has been put in this case. Over the next few decades, we know from Investigator White, from Investigator Kincaid, from the criminalists who examined this evidence in Des Moines and Ankeny, that the evidence, specifically the clothing, was bundled together. Now, why is that important? We know from investigators who testified about their long experience as identification officers that bundling together of items like that is not proper police procedure. Why? Because it leads to the cross-contamination of items bundled together. Now, much has been made in this case about whether or not there was any outside influence or any outside contamination. And I don't believe that there probably is any evidence of any outside contamination. But within the bundles of clothing, as you heard from Dr. Spence, you heard from Mike Peterson, that there was a very real danger of the exchange and the distribution of genetic material, which is going to be important throughout the course of your consideration and your evaluation of this case. And it's because of this very real danger, as Mike Peterson described it, that we have urged you to be especially attentive to the way the evidence was handled and the uses to which that evidence has been put. Now, again, I'm not going to exhaustively catalog the evidence that you've heard throughout the course of this case. You've been studious and very attentive to the details and the importance of the details that you've heard from the testimony and from examining the witnesses. I do want to recall, as you all know, that we've heard from Dr. Spence, we've heard from a number of other witnesses that as we go about our day-to-day activities, that there is an exchange, possibilities of exchange of genetic material. We could probably go to this microphone and find the genetic fingerprints of everybody who's testified during the course of this case, on your bench rail, on your hands, on the chairs that you've been sitting in. We know from the testimony of Richard White, one of the first investigators on the scene and the one who kind of supervised the investigation, that when he gathered up the material and had it placed into storage in evidence of the Cedar Rapids Police Department, that care was taken to make sure that it was maintained in a proper stored facility, in proper stored conditions. But remember when Dick White looked at the tag from Exhibit 17K, looked at the packaging, he said that I never would have signed that D White, I would have signed it R White. We know from Dennis Murphy, the investigator who repackaged this material in 1996, that he couldn't understand why there was a discrepancy between the dates of December 1979 and December 1980. Murphy speculated that perhaps the material hadn't even been packaged during that entire year, and that was being packaged for the first time in 1980. Now, of course, we don't know that that's not the case, because we know that in early 1980, the dress was sent off to the FBI laboratory in Virginia for determination of whether the blood on the dress was human blood and what type it was. But somewhere between December of 1979 and December of 1980, this material had gone to the FBI laboratory, returned, but we don't know where and when it had been during that period of time. We also know from Mr. Murphy that in December of 1996, he repackaged the evidence. It was bundled together. He was uncertain about exactly where it had been during that period of time, but nonetheless, it had been bundled together. And again, as Mike Peterson said, and other witnesses have testified, that bundling together created a real danger of contamination within that package. In January of 1997, the evidence was sent to the Division of Criminal Investigations Laboratory in Des Moines, where Mike Peterson examined the dress, the pantyhose, and the panties. Again, it was sealed up in one big package, and Mr. Peterson testified that he looked through it. We also know from his testimony that in examining that material, he also looked at the shifter with the extract of the blood from the shifter, item I. In 2003, we know that Linda Sawyer also examined the same items. I'm not going to exhaustively catalog all the examinations that took place, but when she examined the material in 2003, again, she had seen it in 2002, she noticed that the scarf and the pantyhose at this point were back in that package. Importantly, she did not examine either the scarf or the pantyhose. We also know from testimony throughout the course of the trial that when she was looking at the panties, she found a few spermatozoa that were recovered from the crotch of the underwear. An effort was made to determine whether there was any genetic material available for testing, and at that time, in 2003, there wasn't enough there to determine a DNA profile. Through 2002, 2003, and on into 2005, this material was packaged and repackaged. And you remember, you hear, I believe, both Paul Bush, who came in on rebuttal, and from Dr. Spence, that the packaging and repackaging, especially if the material is dry inside, can cross-contaminate. It can become brittle, break off, relocate within the fabric of the material that it contains. All of those are important matters. Now, Dr. Spence talked about the handling and the repackaging, the transfer of genetic material between items bundled together. This is not just phony stuff or something that was made up. This is important scientific information that's invaluable and necessary for your critical appraisal of all of the evidence in this case. We're resting, remember, this case on cells, on genes, and based on the small, minute amounts of information that are being transmitted between items of clothing or between objects and clothing, between persons and objects, all of that minute detail is extremely, extremely important. We also know, as we narrow down here on the critical items of evidence, that in 2005, when Linda Sawyer examined, again, the dress, the pantyhose, and the panties, and once again, these items were bundled together. We know that she identified some additional spots, both on the front and the back of the dress, item 7A. She described in detail how she'd gone about doing that. She used what she described as an alternative light source to try to find difference in textures on the dress, and that's how she was able to spot the blood spot that we're going to be evaluating here in just a minute, item F5. We also know she described in detail that she had used a swab to presumptive test to try to find out if the spot that she had located was blood. Remember, she had used two different types of presumptive tests to identify that F5 was in fact blood. Then she took a cutting from that spot to try to get some genetic material from that spot. Item F5 is probably the most important spot in our determination of the integrity of the evidence, and most importantly, the conclusions that are drawn from that evidence. We know that this spot was not discovered until 26 years after the murder. In that 26 years, again, the dress had been packaged, repackaged, examined, re-examined, repackaged multiple times. We also know that in those years, not only had the material been packaged and repackaged, but it continued to be bundled together over and over again. The number of times that it was repackaged, we don't know for sure. We know that it was repackaged in going to and from the FBI in 1980. It was repackaged and being sent to the DCI lab in 1997, again in 2002, 2003, and again in 2005. And when Linda Sauer screened it positive for blood, we know that she used, as I said, a presumptive test, 2 presumptive tests, that even she could not conclude from the DNA material that she was able to get from that one tiny cutting whether that male profile DNA came from blood, or whether it came from saliva, or whether it came from mucus, or it came from sweat. Again, it's just not Dr. Spence's opinion about this. It was the same opinion reached by Ms. Sauer in her careful review in 2005. Now, importantly, the question has been whether or not that stain and the male profile, later determined to be Jerry Burns' profile, came from blood. Repeatedly, the prosecution has characterized it as blood. Dr. Spence, as he sat here and described it to you, noticed that the extraction note that Linda Sauer had used in identifying the amount of information that she was able to get from that small cutting on the back of the dress, the bottom of the back of the dress, said that there was 0.062 nanograms per microliter of DNA extracted from that spot. Importantly, he was not saying that that was blood or that was an indication of how much blood was present at that stain. But what he told you, as you recall, is that based on the amount of DNA that was extracted from that spot, he would have expected that there would be a lot more DNA if it had been blood. Not that that's an indication of how much blood was there, but merely an indication of how much DNA was in that specimen, and that there would have been a lot more DNA if that had been blood. The conclusion, the scientific conclusion, is that the spot there, the stain containing Jerry Burns' DNA, was not from blood. We also know this in part because in years afterwards, when 4 additional cuttings were made from around F5 by DNA labs, they were unable to find any DNA at all. Now, it may have been that in the course of the flood of 2008 that any humidity or moisture may have eradicated that DNA if there ever was any additional to be found there. But importantly, as Dr. Spence pointed out, when Linda Sawyer used those 2 presumptive wet swabs to test for blood, it may have been that in doing that, she eliminated any existing DNA at that spot. The importance of that is this. Whatever DNA was there was scant. There wasn't a huge blood stain from Jerry Burns at the back of the dress, and particularly in the very unusual spot where that spot was found. Whatever was there was something other than blood. And that's what the science tells us. Importantly, when Paul Bush came in on rebuttal with the big picture of the investigation that took place at the Iowa Division of Criminal Investigation Laboratory, even Paul Bush said that based on what was there at spot F5, not only could we not determine what biologic material that came from, but there was no other tests of the dress for any other biologic material that might reveal a male profile. And that's important, and you'll see why. We know that no other items were ever submitted to the Division of Criminal Investigation after F5 was determined and found by Linda Sauer. And that's important, again, from the instructions that the judge has just given you. We also know that item I, which is the extract of the gear shift, was another source of a male profile, and of course, presumably of Jerry Burns. In the examination of that gear shift, everyone who examined it, analyzed it, said that it was a mixture of the DNA. And the important information we learned from Ms. Sauer and from Paul Bush was that mixture, again, could not be determined to be a mixture of blood from one person and the blood of another person. That the partial male profile found at spot I, the extract from the gear shift, could again have arisen from sweat, from saliva, or from mucus. Or importantly, as Mike Peterson said, from skin cells that found their way onto the gear shift. Now, you'll recall that Linda Sauer was somewhat confused about whether she actually examined the gear shift itself or whether, as Mike Peterson did, she had the blood extract from that gear shift. But notwithstanding whether she looked at the gear shift itself or the extract from that gear shift, she too could not conclude whether or not it came from a biologic source other than blood. Finally, as we know from Mike Schmidt, the male profile on that, based on some errors in reporting, could no longer be reportable to the standards of the DCI. The integrity of that evidence has been called into question. Judge Hoover has told you that in considering the existence of whether or not the state has proved its case by evidence beyond a reasonable doubt, you can consider not only the evidence, but also the lack or the failure of evidence produced by the prosecution. And it's our belief that the lack and the failure of important items of evidence in this case are critical to your consideration of Jerry Burns and his guilt. We know from every witness who's testified that the scarf that was found around Michelle Martinko's neck was never, I repeat, never tested. Why is this important at all? We know that the scarf was knotted around her neck. Dr. Feaster testified about that. And we also know that that scarf was the closest item of clothing between Michelle Martinko and the knife that inflicted her wounds. It was the closest item of clothing between Michelle Martinko and the assailant who killed her. And yet that scarf, removed from her body by Dr. Feaster, submitted to the Cedar Rapids Police Department, packaged up at times, sometimes not packaged up, was never examined for the presence of any biologic material by any male or anyone other than Michelle Martinko. We also know that the steering wheel from the car, from which a tape lift was made by Richard White, the tape lift that was obtained from that steering wheel was insufficient to find any DNA whatsoever. And yet, as we know, the steering wheel was rich with blood. No further efforts were found to extract a blood sample for any male profile. Amazingly, not only was there no DNA found in the tape lift from that steering wheel, even Michelle Martinko's father's profile was presumably never found on that steering wheel. The panties that were examined by Dr. Feaster said that during his autopsy, a pap smear was done. There was no evidence of spermatozoa or semen found on Michelle Martinko's body or in her body. And yet the panties were examined by Linda Sauer in 2003 and found to contain spermatozoa. This isn't just something that we phonied up to create an inference of doubt. But importantly, even though that sperm was identified in the panties, in 2003, there was no identifiable male profile found based on technology at that time. But we know from all the witnesses who've testified about the evolution of genetic analysis, the evolution of investigations involving genetic material, those items could have been re-examined, but they were never retested. There is, in fact, evidence of another male at this crime scene.
The dress about which we've heard so much and the evidence that was extracted from that dress, we know from both Paul Bush and from Dr. Spence that there was no further testing done front or back for anything other than blood. It's been exhaustively established, men and women of the jury, that saliva, that mucus, that sweat contains genetic material. And all of that genetic material carried answers to the question of who killed Michelle Martinko. That evidence could have been found in the front of her dress from the exertion of her assailant, from yelling or screaming or sweating. It could be found on the front of her dress, it could be found in her scarf. It was never looked for. As Paul Bush candidly said, you can't find what you don't look for. And that evidence was not looked for. So the concentration of the focus of this case has been on F5 and on the extract from the shifter, item I. Based on what was found in those locations, that's where the concentration of this case has gone. And it's our belief that it was the diversion based on that that led to a path to Jerry Burns, but not the path. We've heard impressive statistics about the match, the likelihood of a coincidence, 1 in 100 billion. We also heard from the Ms. Nash at Bodie Technologies about the inference that can be drawn from the profile found when they re-examined the extract from item I. But again, these statistics are based on an assumption, and that assumption is that F5 is the spot of the killer, that I is the spot of the killer, and that there are no other plausible explanations for where the genetic material that may be on this dress that had never been located, where those statistics might go wrong. We also know that based on the investigation that Investigator Dendlinger pursued, that he contacted Parabon NanoLabs. Parabon NanoLabs constructed a likeness that was used to try to generate additional leads. And again, we find no fault with that course of investigation. It was creative, it was resourceful, important, but in the end, based on the assumption that F5 and I were the genetic material of the killer. We also know that Parabon was again recruited to develop a family tree, and that the family tree was in turn used to identify and locate the Burns brothers. From the Burns brothers, a straw was obtained from Jerry Burns. That straw was used to develop a profile from his genetic material, and that genetic material was then focused on him. So what about Jerry Burns? Well, we know from the investigation done by the Cedar Rapids Police Department and from his own interview that in 1979, he was a young father, married with, at that time, 2 young children, living in Manchester, Iowa. Manchester, Iowa, the county seat of Delaware County, is about an hour away from this Westdale Mall. We also know from the testimony of Investigator Dendlinger and from Jerry's own interview that he was working in Elkader, which is north of Manchester. He worked in Elkader as working for a feed supply company as a salesman. Again, a significant distance away from Westdale Mall and Cedar Rapids, Iowa. The scenario that has been developed by the prosecution in this case is that Jerry Burns, on December 19, 1979, drove from either Manchester, Iowa or Elkader, Iowa to the Westdale Mall, that he was bent on the destruction of Michelle Martinko. Not only was he bent on her destruction, he had planned to have rubber gloves and a knife to inflict the fatal wounds that killed Michelle Martinko. Now, we do know, of course, that Jerry and his family had shopped at the Westdale Mall. He said as much in his interview.
'79, did you ever have reason to be in Cedar Rapids or anything like that?
Not really.
Did you go to Westdale Mall?
Oh, yeah, we've gone to Westdale Mall.
Sure.
So, when you were at Westdale, when you know when you would have gone out there for
Christmas shopping or, different times of the years.
Christmas?
Sure. Did you ever go there? Oh, I'm sorry, go ahead. Did you ever go there by yourself, without your family?
Not that I know of.
Okay.
So, no surprise, Jerry Burns and his family had been to Westdale Mall. Now, again, it should come as no surprise that he didn't know exactly where he was on December 19th, 1979. I venture to say that those of you who were around in 1979 couldn't say where you were on that date. Now, much has been made about Jerry's appearance and his candor and his demeanor during the course of this interview. And I challenge anyone to say how you would react or how I would react when faced with information from strangers coming to your office or to your home for the first time. Not only do we know that Jerry and his family had shopped at Westdale Mall and had gone there as a family, I think he said that they also had gone to some movies there. So it's not a surprise that he would know about Westdale Mall, had been there, and told Investigator Dendlinger that he had been there as fact. Much has been made about whether or not Jerry, in being questioned by Investigator Dendlinger, denied that he had killed Michelle Martinko. There's no question that he denied that he had killed Michelle Martinko. And as you see from the interview and as you saw with your own eyes, he repeatedly said that he had not.
I drank a fair amount when I was younger, but
Sure. Do you think that may have contributed to what happened that night?
I don't think anything happened that night.
Any reason anyone would have written down your plate, your license plate? That particular
No, I
night?
wasn't there.
Yeah, well, I think we've already established you were there.
I don't think so.
We just haven't. Do you know what today is?
19th of December.
Did you murder someone that night, Jerry?
Test the DNA.
Jerry,
Test the DNA.
why did this happen, Jerry?
Test the DNA.
What happened?
I don't know.
You
I was
don't
not there that night.
You don't know why this happened?
I was not there that night.
I was not there that night. And as Investigator Dendlinger told you, not only did Jerry say he was not there that night, but he said it was not possible that his DNA was at this crime scene because he wasn't there. Jerry said repeatedly there wasn't any possibility his DNA would be there or traced to the crime. He also said repeatedly, I was not there that night. Nothing happened that night. And as I said, a note about his demeanor. How are we to know how Jerry Burns would react or how any one of us would react? We can try to put ourselves in his shoes, but the important issue is how did Jerry react and did his repeated denials establish that he did not admit, he in fact denied that he killed Michelle Martinko. We also know in the transport between Manchester when he was arrested and in Cedar Rapids, Iowa, that he was asked a number of questions, a number of which have been identified by the prosecution as incriminating. Now, we know that the audio in this interview is very difficult to pick up. We're going to listen to just a smidgen of it, and then we'll talk about some of the important words and how they were spoken.
blackout either.
No, I didn't say blackout, I said things, you block things out of your memories.
Oh, you block things out. I gotcha. I'm with you now. Oh, we understand, Jerry. You don't know what's going through your mind. I don't know what's happening. Does that make you think about what's going on, Jerry? Somewhat. Okay. What do you can do about it?
So Investigator Denlinger said, help me understand what was going through your mind. And Jerry said, I don't recollect. Is it possible this happened and you don't remember any of it? I don't know. I'm sure something like that would be possible to block out, for somebody to block out. Denlinger asked, help me understand what was happening. Help me understand. Jerry says, I don't know. You don't know what was going through your mind? Jerry says, I don't know what's happening. I'm confused about everything. So again, the state scenario here is that Jerry Burns, a married man with 2 young children at home, leaves, drives to Cedar Rapids, Iowa in the night, leaving his wife and children behind, armed with a knife, armed with rubber gloves, goes to a Westdale Mall on the chance that he's going to encounter Michelle Martinko, designs to kill her, kills her, muddies up the evidence the best he can, and then leaves and drives back home. Drives back home splattered with blood, with rabbit fur on his coat, presumably with a knife wound in his hand, for which we know he got no medical attention. That's the scenario the government wants you to believe. So to bolster this scenario, we have Michael Allison. Michael Allison, we know, is an informed consumer of federal criminal law. He's been convicted of conspiracy to commit mail fraud. He's been convicted of drug trafficking multiple times. He's been convicted of human trafficking, bringing illegal undocumented workers from Mexico to the United States. He's spent multiple times in federal prison. Not only has he been in federal prison, but when released from federal prison under supervision, violated the conditions imposed by the courts and his probation officers, sent back to prison, been in prison in Mexico for we don't know how long, but finds himself housed, by coincidence, at the Lynn County Jail in Cedar Rapids, Iowa. And this, as you remember, is the photograph that Lieutenant Steenblock brought to us, showing the housing situation where Jerry and Mr. Allison were housed. We know that Jerry was in the bunk in the upper right, and right next to his bunk was Mr. Allison's bunk to the left. In between the 2 bunks was a box, and on that box were envelopes containing what are described as discovery materials. And as you know from the testimony we received from Investigator Denlinger and from Mr. Allison as well, discovery materials are the investigative reports, witness statements, other material that detail the state's investigation. Now in state court, individual defendants are allowed to have those discovery materials with them at the jail. In federal court, the federal inmates are not allowed to have that information at the jail. So in between those 2 bunks was the box with the envelopes containing the investigative reports and other material that Mr. Burns was permitted to have with him to assist in his representation and assist in his preparation for trial. Now, we also know from the evidence introduced by the prosecution that the 2 cell reports, the bunk reports for Mr. Allison and Mr. Burns, that they were housed in the same unit. And as you go through these documents, you'll be able to see the dates and times during which Jerry was in the cell unit, the times during which Mr. Allison was in his cell unit. And as you compare them together, you'll be able to see that between the beginning of December and the end of January, when Mr. Allison met with Mr. Maybanks and Investigator Denlinger, that there were multiple times during those times when Jerry was not in his cell and when Mr. Allison was in his cell. In other words, Mr. Allison had access to Jerry Burns' discovery materials. He also had access to the media accounts about Jerry's case on television and in the Cedar Rapids Gazette. Importantly, you'll be able to see that over the course of the period of time between December 8th and January 28th or 29th, that Allison was in the cell while Jerry was not for more than 25 hours. Now, the Michael Allison saga also requires us to look a little bit at the chronology involving his prosecution in federal court. We know that on November 21st, Mr. Allison signed what's called a plea agreement. This plea agreement is a letter between the United States attorney prosecuting him and Mr. Allison's lawyer. And in this plea agreement, it talks about not only the consequences that Mr. Allison was facing as a federal, indicted in a federal case, but also the agreement that had been reached about the disposition of the case, how it might resolve, and importantly, the facts that supported Mr. Allison's decision at that time to plead guilty. And as you look through Defendant's Exhibit H1, which is the plea agreement, you remember Mr. Allison admitted that at the time when he initialed every one of the paragraphs in that exhibit, he agreed with the factual accuracy of each one of those paragraphs. And in that plea agreement, you're going to see the extent to which Mr. Allison is a master manipulator. He has been, in the facts of that case, been able to hoodwink his own co-conspirators, steal money from his own co-conspirators, and in fact, take money in exchange for drugs that he failed to deliver. Not only that, he preyed upon another co-conspirator in that case who was just getting out of drug treatment, persuaded that person, after they got out of drug treatment, to get back involved in the drug trade. He's a master manipulator. Now, we know on December 4th, as he told you, that he agreed to plead guilty to this federal indictment charging him with conspiracy. And in part of the agreement, he and the United States Attorney agreed that he should get a sentence lower than what the federal sentencing guidelines said he would ordinarily be subject to. This agreement, called an 11C1C agreement based on a provision of the federal criminal rules, says that a judge has to agree to that sentence, and if the judge refuses to agree to the sentence, then the defendant can withdraw his guilty plea. We know that on December 6th, he met before a district court judge reviewed the plea agreement and said, I'm going to reject it. I'm going to reject it. So at this point, the judge on January 6th scheduled a hearing on January 15th to decide whether or not to allow Mr. Allison to withdraw his guilty plea and try to renegotiate another one, presumably much less favorable. January 6th. On January 11th, we know this is the date on which Mr. Allison obtained his notorious autograph from Jerry Burns. Here's a short excerpt from the video clip about that interaction on January 11th. Pointing and nodding with approval. This, men and women of the jury, was a setup. Michael Allison told his probation officer early on in a federal criminal case in California that he had lied about having a mental illness so he could get into a treatment unit in a federal prison, and that he'd used his mental illness as a bargaining chip. On January 23, just a week and a half after this autograph was obtained from Jerry Burns, Mr. Allison goes to his lawyer and tells his lawyer that he's got information on Jerry Burns. On January 28th, Mr. Allison met with Mr. Maybanks and Mr. Denlinger and told this story about what he had learned from Jerry in the jail. Just as Mr. Allison was a master manipulator throughout his criminal career, he had developed another bargaining chip using Jerry Burns. It is a concoction. Judge Hoover, in her instructions to you, has told you that in your consideration of whether or not the government's case has been proven beyond a reasonable doubt, that you must consider not only the evidence but also the lack or the failure of evidence in this case. And I suggest that there are two important things that have not been proven and cannot be proven in this case. First, we cannot conclude that Jerry Burns's blood is the source of the DNA on the dress at spot F5 or the gear shift selector, item I. It cannot be determined based on the testimony from Ms. Sauer, from Mike Peterson, from Mike Schmidt, from Paul Bush, Mike Spence. They're all in agreement that it cannot be said that that is Jerry Burns's blood. We also know that it can't be said how that DNA arrived on F5 or at item I. We know from what we've seen time and time again that the people that we touch, the things that we touch, the things that touch us are transmitters of DNA. All the expert witnesses said they cannot determine when that DNA was arrived on the dress or on the shifter. They can't say how. In the absence of those two big things, there's been a lack and a failure of evidence produced by the prosecution. The judge has instructed you about reasonable doubt. And the judge has said that reasonable doubt can arise from the evidence or the lack or the failure of evidence produced by the prosecution. It's the kind that would cause a reasonable person to hesitate to act. And additionally, the evidence presented to you by the prosecution must be so convincing that you would not hesitate to rely on it and act on it. We're talking here about scintillas of evidence. And reasonable doubt, ladies and gentlemen, is more than just an instruction. Reasonable doubt is a living embodiment of what justice is all about. Reasonable doubt is an embodiment of the fact that we all know that even good people, by virtue of coincidence, by virtue of their race, by virtue of their circumstance, can find themselves unjustly connected to a bad event. We know that, and that's why any evidence has to be convincing beyond any reasonable doubt. We're talking here about evidence from a cell, from saliva, a cell that contains a partial amount of Jerry Burns's DNA. The evidence in this case must be so convincing that you would not hesitate. Not only hesitate, but you would not hesitate to act. Your allegiance, as the judge has told you, is to the law and to the facts. Your solemn obligation as jurors is to the law and the facts. Based on the uncertainty, based on the handling of the evidence, the real danger of cross-contamination, the fact that Michelle Martinko navigated throughout the Westdale Mall, areas where the Burns family had shopped, it cannot be said, with your allegiance to the law and the facts, that Jerry Burns is guilty beyond a reasonable doubt. Your verdict must be not guilty.
Thank you, Mr. Spies.
All right, guys, let me recap that real quick. And I'll get to, there's Mandy. I thought the defense had Burns' interview still playing. It was you and your kitty. Oh. Just that you could always ask Mabe Banks if he'd be willing to interview. Oh, it's been a few years. He might agree. Yeah, that's a great idea because I have questions for him. All right. Before we get to that, I just want to thank a few people for the cups of coffee. You guys are so nice. I really appreciate it. So we had, let's see, Kathy Smith bought some cups of coffee. Green-eyed cat. I was going to say green-eyed candy. Green-eyed cat bought cups of coffee. Mandy, thank you. Thank you so much. Unbalanced equation, thank you. Thank you guys for the cups of coffee. Polly. Oy. All right. It's getting late here at the old trial TV. All right. To recap, Mr. Spies, she spent 40 to 50 minutes with Kurt Thomas. They walked around the mall together. Andy Seidel, 4 days before she was off, she talked about an ugly or grotesque man stalking her at the mall because she worked there as well. They sat on a chair or bench as they ate. She left the mall around 9:30 or 10. She was not wearing gloves. She had a scarf around her neck. She went to the car, but there were no witnesses that saw her do that. She was huddled in the car, brutally stabbed. Yeah, they found the initial patrol said that she was slouched over, and initially he thought it was somebody who was drunk, but then they said she was on her back. So there was little weird inconsistencies there. I agree with some testimony there. The wounds were open. He said that was important as we go along. No evidence of SA. He thinks that she was targeted. So whoever was equipped with these instruments of death was prepared and planned. The wounds were intended to disfigure her, so that's interesting. He said there was fur throughout the car, but no blood drops outside, no trail of blood. We knew about that. And they tried to poke holes in the law enforcement's packaging and cross-contamination. He's been doing that the entire trial. He talks about Linda Sawyer's 2005 extraction notes. Expected to have more DNA if there had been blood. Yeah, so they were talking about there was such a small amount of blood that they expected to find more DNA there. But Sawyer and Bush said the mixture of DNA could have been sweat, saliva, or skin cells on the gear shift. Pretty sure that it was blood, but that's what he said. DNA was never looked for on the scarf or front of the dress, which I thought, yeah, I'm surprised that they didn't. But they wouldn't know where to look, I guess. Yeah, because you have to cut it out and then put it through this process, so I guess they went with, the entry wounds. That's what they were going for. So they tested the DNA 3 times. Then he shows the... oh, I'm sorry. Yeah, so when he was being interviewed, he said, test the DNA, test the DNA, test the DNA. When he was being asked, when Jerry was being asked, did you do this? He's like, test the DNA. He says, I was not there that night. So, okay, sure, we're just going to take your word for that. And then he says, the state would have you believe that a married man with two small children, a 26-year-old, would leave in the middle of the night. Well, it really wasn't the middle of the night, but it's more like drives an hour on the chance he's going to find Michelle. Fair point. Drives back home, splattered in blood and rabbit fur all over him with a hand wound. Could have stopped and stopped at the gym and cleaned up, or stopped anywhere, you know. So that's what the state wants you to believe. Then he talks about Michael Allison, and I thought this was a good jab. He's an informed consumer of criminal law, who had access to newspapers and TV news. And he talks about his plea deal. I don't know. I agree. I don't think they should have brought him in, or they didn't really need to. Maybe not should have, but I don't think they needed to bring in Michael Allison. I think that the DNA was enough for me, but they brought him in anyway. And then he talked about the cross-contamination in the packaging. You know, that's been his whole thing the entire time. All right, guys, we've got one more. Now, here's the rebuttal. This is going to be 28 minutes. So this is going to take us to 9 o'clock, and then we get to the jury charge and then the verdict. So another half hour and then another like 10 minutes. So we're close to calling this a night. So let's move on. I'll put a poll up after this rebuttal. Well, we did a poll once, but I'll do another poll. We'll see. It'll be interesting to see how it's changed or not. All right, hold on there, Mr. Maybanks. All right. CC is on. Full screen. We'll see you guys on the other side. Sorry, Michelle. All right, see you on the other side.
Here, I promise. I got one more chance here to address some of the things that Mr. Spees said. Maybe, possibly, shopping at Westdale Mall at some point in time, maybe possibly within 1979, maybe possibly around Christmas, maybe in that year, and maybe there being some kind of event that involves some sort of transfer, maybe possibly, is not reasonable doubt. It's within the realm of possibilities. But what isn't? Defense says that there are a couple things that we can't show, that the state hasn't shown. We can't conclude that that's Jerry Burns' blood on F5 or the shift selector. I explained to you during the closing argument how we did, and I'll touch on that again here in a moment. But that's not an element of murder in the first degree. They said we can't conclude how it arrived on the gear shift or on the dress. We did. I talked about that in our closing argument. I'll hit on that again really quick too. But that's not an element of murder in the first degree. When you were shown the definition of reasonable doubt just moments ago, and you were led down that definition, it kept going back to one description of a person in a court, a juror who makes a decision. A reasonable person. What causes a reasonable person to hesitate to act? What evidence would convince a reasonable person of the defendant's guilt? And folks, looking around here, you look like some reasonable people to me. Within that definition of the jury instructions I mentioned before, it requires you look at evidence, not possibilities. I sat here and watched the defense give their closing argument, made some good points. That's to be expected. But nowhere in there did we hear any, to use their word, scintilla or minuscule amount of reasonable doubt in this case from the evidence. And you can use that word all you want, scintilla, minutia. That's still more reasonable doubt than has been created in this case. Defense says DNA can tell us what we are. Yes, that's true. But they can't tell us who we are. That's probably true too. But I disagree with the fact, with the assertion that DNA can't tell us where we've been. In fact, that's the defense's whole case. So when they say that to you, that's just not true. It can tell us where we've been. And the DNA in this case showed where Mr. Burns was. In a car where Michelle Martinko was murdered. Not once, but twice. We disagree that the evidence in this case took some kind of divergent turn that has led wrongly to the defendant. The evidence in this case points and is directed in one path, through one path that's not divergent at all and never diverges from the conclusion based on the evidence that the defendant is guilty of this crime of murder in the first degree. State gets a rebuttal because we have the burden of proof. And that's what we want. That's the way the system works. We embrace that burden of proof. So what I'm about to say in no way is intended to diminish that responsibility that's so sacred that's put on, as Mr. Spees referred to, the government in this case. The government of the people. But as you heard, there's two sides to every case. You heard ours. And having listened to the defense present their case, I'm thinking of the old Wendy's commercial. The old lady who opens up her hamburger and says, "Where's the beef?" But in this case, where's the evidence? Where's the evidence of this transfer event? Somehow, possibly, at some point in time, he was there with his family? That's nonsense. Nonsense. People were going in and out of that mall every day. It was Christmas. And the only DNA found on her dress and in that vehicle on another occasion was the DNA of Jerry Burns. Are you kidding me? A transfer event? Folks, we're reasonable people. We need to have evidence to show things, and there's no evidence of a transfer event in this case. Defense points out there's no witnesses here, so somehow we have to speculate about what happened. Well, Michelle Martinko is dead. I think we know what happened. I think we know where the evidence points as well. The tracks and the trails and the divergent paths all lead, no matter how you phrase it, all lead to one area. A 1972 Buick in a coal parking lot at Westdale Mall on December 19th, 1979, where only two people's DNA was found. And the crime scene tells us all we need to know. Michelle Martinko's DNA and the DNA of the defendant, not in one, but two locations. Yes, this involves minute evidence. DNA is small. But as you heard, and as we now know in the society we live in, DNA possesses enormous information. And you have to get down small enough to be able to find it, but it's there. It's there in blood on this crime scene. I want to talk a little bit about the items being bundled together, packaged together, those type of things. I talked about that during our closing argument. But folks, again, as reasonable people, what do we learn about the fact that these items are bundled together? It shows us nothing but the clothing that was on Michelle Martinko's murdered body stayed together. And I agree with the defense. One of the things they said. There's no evidence of outside contamination. Did you hear Mr. Spees say that? I'm over here like, that's great. What are we doing here then? No evidence of outside contamination means that there's two individuals' DNA that have been on Michelle Martinko's clothing for 40 years, or 26 till the time this was developed. We looked at 17K, Exhibit 17K. Again, that's the evidence card. It looks like it contains some kind of clerical error on it or something like that. It's not an issue in this case. Again, no evidence of outside contamination. Couldn't agree more. The real point here, folks, is there's no indication that this evidence ever left police custody, law enforcement custody, state custody. So again, there's no scenario whatsoever where the DNA of Jerry Burns would come in and contaminate that clothing because it was there the whole time. No evidence presented, no scenario from that. So it remained in police custody. The crime scene in this case remained in police custody. Items were packaged together, and you heard Michael Peterson, the former director of the DCI lab. You heard Linda Sauer, her years of experience. You heard Michael Schmidt, his years of experience. You heard Paul Bush, the boss, come in. They all said, items packaged together, they're all on her. We're not concerned about any contamination, but we heard that word thrown out, that scary word, contamination. Her clothes can't contaminate each other. The only person we heard come in here and say that that was some kind of scary scenario was the paid defense expert, the one who doesn't work in a lab, the one who writes papers on how to create reasonable doubt. There's no evidence in this case that the scarf that was on Michelle Martinko, which the pictures clearly show, is indicative of the dress she wore as part of the outfit that she wore. There's no indication that scarf ever left police custody either, or that it ever left the items it was packaged with, given its obvious indication that it's part of what she was wearing that night. There's no indication that the scarf was anywhere else besides where the rest of the clothing was, and that was on Michelle's dead body. And where the DNA was found in this case, on her dress, on the gear shift selector. It's not some random place where you might find if there was this cross-contamination taking place. It's in very precise locations. On the dress she was wearing while she was stabbed to death. Not on the inside of the dress, not on some odd location, not on the inside of the pantyhose or on the toe of the pantyhose, or on the dress where she bled and where the perpetrator, who we've shown as Mr. Burns, bled. Precise location. It's on the gear shift selector, folks. Could it get more precise than that? Smeared on the gear shift selector. It's not some kind of accidental event. That's a purposeful, dare I say, transfer, not secondary, direct. Item F, F5, spot F5 on the dress from Exhibit F. It's been 26 years in government custody. 26 years. Spot was there the entire time until it was found in 2005 in a package that contained Michelle Martinko's clothing. And again, there's no evidence that Jerry Burns' DNA got there other than in 1979. And ladies and gentlemen, the state has proven beyond a reasonable doubt, even though it's not necessarily an element of this case, but we contend we've proven beyond a reasonable doubt that that DNA on the dress came from the defendant's blood. Even if the defendant's DNA on her dress came from his saliva, skin cells, something like that, if it's not blood, it's still mixed with hers. That area is presumptive for blood. We know there's blood there. Let's say it's not his. Well, it's hers. His DNA is mixed with hers, and the only way that could happen is after she shed blood on her dress, his DNA ended up with it. So you can call it whatever you want, but that's his DNA mixed in the blood from her murder. We contend it's his blood, though. For 40 years, everyone involved in this case knew that Michelle Martinko died and was killed, knew how she was killed. Common sense and intuition now allow us to connect the dots. During this trial, evidence comes in as it's described. Sometimes questions have to be rephrased but during closing arguments, we're now free, and during deliberations, you're now free to make the reasonable conclusions from the evidence. So I'm going to go ahead and acknowledge it's undisputed in this case that F5 wasn't tested for anything but blood. But also, what's undisputed is it was tested twice for blood, and it was twice positive for blood. So yes, other substances can't be ruled out, but the only substance confirmed by the physical evidence, by the test that was done on the physical evidence, by the surrounding circumstances, and what's most supported by scientific findings in this case, as Paul Bush told us, was that it was blood. During his interview at the business and again in the transport car, the defendant never gave any circumstances that would indicate that his DNA on that dress was there from saliva or touch or any other form of DNA. So yes, none of the experts could definitively say the defendant's DNA at the crime scene originated from blood, but let's realize and acknowledge what that really means. Again, area F5 tested not once but twice. It's blood. Because DNA is present in all substances, and all these substances, there's no way to tell from the DNA itself where it originated from. But this doesn't mean you can't find it didn't come from blood. In fact, as I stated over and over, that's the only reasonable conclusion from the evidence in this case. When we talked about burden of proof during jury selection, and again here when we're talking about jury instructions, we all agreed that the proof the state is held to is proof beyond a reasonable doubt, not proof beyond all doubt, not proof beyond all possibilities. That is a hill that nobody can climb and nobody should have to, and that's not the way this all works. Decisions are based on evidence. We're not going to be able to prove beyond the realm of possibilities. We want to base it on the evidence. And where is the evidence of anybody else's DNA at this crime scene? Of the DNA on her dress or on the gear shift selector coming from any other source other than blood? By presenting a realm of possibilities, a world of an imagination, the defense wants you to rewrite the history of this case. And the state says, you shouldn't have to do that. You shouldn't have to rewrite the history based on guessing what happened when the evidence is right in front of you and shows what happened. The infinite, undocumented realm of possibilities is a super topic for philosophy class, but that's not where we are right now. We're in a court of law. The only reasonable explanation is that the defendant's DNA on this dress and on the gear shift selector is it's there from blood. The only scenario that will result in his blood and his DNA being on Michelle Martinko's dress is that he killed her. With respect to Defense Exhibit T1, Dr. Spence again said he would expect that there would be more blood, but also conceded in his own testimony that that chart and that number is not indicative of how much actual blood was present in that case. So that was a trick. Take a tiny number, make it seem really, really tiny, and let you folks think that there's some kind of minuscule amount there, but that T1 does not say that. T1 is not meant for that. And remember, still when we're analyzing this, at Area F5, the major contributor to that profile there was the male, was Mr. Burns, with only 2 alleles being present from Michelle. So are you telling me, is the defense telling you But you should conclude that we know there's blood there, and it's from Michelle's blood only. When she's the minor contributor, it doesn't make any sense. As for the gear shift selector, we disagree with the interpretation provided by the defense. Consistently, as the gear shift selector has been analyzed in this case, there was blood found from 2 sources, or there was DNA from 2 sources, and it consistently pointed to the defendant, matching up at the loci to F5 from Linda Sauer's examination, and again at Bodie Labs. And the fact that nothing was found on the steering wheel, we heard, is not unusual. There wasn't much there, and you need about 3% of the blood to find an actual DNA on it. So that's not an unusual finding. It's not unusual, the DNA wasn't found in other locations. So as they're talking about how other places weren't looked for blood, they're also talking about all the places where it wasn't found too, which is interesting. This crime scene was extensively examined, but when it got to a point where a known profile was found for comparison, it would be negligent to not identify who that person was and figure out why their DNA is there. And that's exactly what investigators ended up doing. And when they got to that person, they didn't find an explanation. We heard Jerry Burns was far from his home, and his work was even farther away. So how could this have happened? Well, in saying that, in presenting that scenario, doesn't that make this idea of transfer DNA even more unlikely? How would you act? How would you act if the police showed up? Strangers showed up, the police showed up. How would you act if somebody came and said your DNA was on the crime scene, started implying you in a murder? Well, you know what I'd do? I'd say I didn't do it. You got the wrong guy. Not, I don't know. I don't think anything happened. I don't think so. Test the DNA. Let's wait for the test to come back. Give me a break. Sure, we can't guess how people could act, but we know how somebody would act when they're being accused of a murder they didn't do. And after a couple of those questions, I was not there that night. Really? How did that secondary transfer occur then? It's not a credible answer. I don't want to spend more time on Mr. Allison because we talked about him, but what I do want to say is this master manipulator, this career criminal, this person you can't trust, this person that would say anything to get himself a better deal or to give him a bargaining chip. Well, if that was the case, wouldn't Mr. Allison have came here and gave us a really good story about why this happened? Oh, he told me why he did it. This is exactly why. No, he didn't. The master manipulator didn't come in and say that. What he did say is he reported a few things that Mr. Burns said and Mr. Burns did. Not much of a master manipulator when he didn't give us everything about that, but you know what? He still gave us enough. And a master manipulator doesn't come and do something if he doesn't have a deal, which he didn't have any kind of evidence of a deal here. So try all you want to smear Mr. Allison. He probably deserves it. He has a criminal record, but he's got no chips in this poker game. In closing, and I know you guys are ready to take this case and begin your deliberations, but there's one more topic I want to visit. The defense just justified the statements that were made by Mr. Burns during his transport to the Cedar Rapids Police Department as if the defendant was pontificating that a person, some person, not him, but some person, would block out tragic memories. We have a different take. I want you to look at that squad car video. And when you do, you'll see an investigator who, through his efforts, finally broke the case, found the person that killed Michelle Martinko, and just finished the interview with that person where he didn't adamantly deny that he didn't do it. He only said, test the DNA, and I don't know, when asked about what happened that night. So Matt had found the person. He had arrested that person. The science and the defense non-committal responses ensured that the right person was under arrest. But as you saw by Matt's questions, his inquiry changed. To something he wanted to know, and something we all want to know. From did you do this to why? Why did you do this? And next to him in that squad car was Jerry Burns, age 64. Now an older man. Not the same man he was back in 1979. He had close to a lifetime behind him. What was going through his mind? As the younger investigator asked him why this happened, Mr. Burns wasn't ready at first to answer that question. So he changed the subject a few times. What had been going through his mind? What do you suppose is going through his mind? Well, you can see it be unveiled during that transport video. The questions he had to be asking himself during that long car ride. Some of the things that he implied in that earlier interview video. How did they get my DNA? How did they find me after all those years? Told the police, he told Matt, well, the police have a tough job. I wouldn't want to do what you guys want to do. Then you hear him start making outwardly making plans for his incarceration. How was he going to get his medications? How was he going to get to his appointments? Pay people. Make sure his son could run the business. But the real question that he had to answer at that point in time was one that he had not had to answer for the prior 40 years. So he knew he had to provide some kind of answer. And as we heard, that answer wasn't, you got the wrong guy. This must be some kind of mistake. Somebody must be confused. Let's get this worked out. I got to get this worked out. What was his answer? What did he end up saying that moment to justify this brutal murder? From so many years ago where he was a different man, a younger man, one who drank too much, one who had made an awful and terrible decision, who had certain illicit motives when he approached Michelle Martinko, and knew what he had done once it had gotten out of his control. What he had to do. He knew what he had to do. Had to kill her so his life wouldn't be ruined. So it wouldn't be uprooted. What was he thinking at that video? Was he thinking at that point in time, at least he had the last 40 years to live with his family? Was he thinking he wished he would have cleaned up his mess? Was he trying to figure out how to explain such a hideous act? How does one explain that? Well, common human experiences and common sense tells us sometimes when you can't explain, you take yourself out of it. Because you're a different person now. So the way you decide to live with yourself is to block out the traumatic events. Because if you block it out, it never happened, right? But in this case, we know what happened. We know how it happened, and we know who did it. The evidence shows, beyond any reasonable doubt, the defendant killed Michelle Martinko. The evidence points in no other reasonable direction. And ladies and gentlemen, again, thank you so much for your time and your patience. The state of Iowa is asking you to enter a verdict of guilty of murder in the first degree. Thank you.
Thank you, Mr. Maybanks.
All right, guys. So that was the rebuttal, state's rebuttal. Let me give you a Polly moment there. She's all chill. She's all chill and relaxing, kicking me out of the chair. All right, Mr. Maybanks, he said maybe, possibly shopping at the mall at Christmas. He got pretty animated this go around. The only DNA found was Jerry's. Defense calls it a transfer event. Give me a break. Yeah, he got really heated this time. He said Michelle is unalived. I think we know what happened here. How would you act if law enforcement came up to you and said, laid this on you? And he says, I would say I didn't do it. He would say, I don't think anything happened. Give me a break. So those were the few moments that I pulled out that Mr. Maybanks there got pretty heated. All right, we are almost done here. I'm going to end the poll. All right, let's see here. What was the poll? All right, 84% say he's guilty. 3% say not guilty. Really? Oh, wait. There was a miss. I don't think that's real. I think that was a miss one. Not sure, really. 5% not sure. And 8% want sushi. That would be me. I voted guilty, but I definitely want some sushi. All right, I'm going to end the poll. I think the state proved their case pretty strongly. Pretty strongly. All right, let's get to this. All right, so now we're going to get to jury charges, which is about 8 minutes, and then the verdict, which is about 4 minutes. So we're on the home stretch. And thank you so much for hanging with me on a Friday night, chat. Appreciate it. Friday night, hanging with the chat. All right. Don't need to zoom, Julie. It's all tied up in a neat little bow, but you'll see in a second. All right. Squeegeeing down my little pip squeege. All right, I'll see you on the other side. This is only jury charge and then sent back to deliberate. All right, here we go.
During the trial, you have been allowed to take notes. You may take these with you to the jury room to use in your deliberations. Remember, these are notes and not evidence. Generally, they reflect the recollection or impressions of the evidence as viewed by the person taking them and may be inaccurate or incomplete. Upon reaching a verdict, leave the notes in the jury room and they will be destroyed. When you begin your deliberations, you should select a foreman or a forewoman. He or she shall see that your deliberations are carried on in an orderly manner, that the issues are fully and freely discussed, and that every juror is given an opportunity to express his or her views. In order to return a verdict, each juror must agree to it. Your verdict must be unanimous. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with the other jurors. During the deliberations, do not hesitate to re-examine your view and change your opinion if convinced to find the truth and to do justice. And you may not communicate about this case before reaching your verdict. This includes cell phones, electronic media such as text messages, Facebook, MySpace, LinkedIn, YouTube, Twitter, email, etc. Discussed in this case, and do not use internet maps or Google Earth or any other program or device to search for or to view any place discussed in the testimony. Also, do not research any information about this case, the law, or the people involved, including the parties, the witnesses, the lawyers, or the judge. This includes using the internet to research in events or people referenced in the trial. This case was tried on evidence presented in this courtroom. If you conduct independent research, you will be relying on matters not presented in court. The parties have a right to have this case decided on the evidence they know about and that has been introduced here in court. If you do some research or investigation or experiment that we do not know about, then your verdict may be influenced by inaccurate, incomplete, or misleading information that has not been tested by the trial process, including the oath to tell the truth and by cross-examination. All of the parties are entitled to a fair trial, rendered by an impartial jury, and you must conduct yourself so as to maintain the integrity of the trial process. If you decide a case based on information not presented in court, you will deny the parties a fair trial in accordance with the rules of this state, and you will do an injustice. It is very important that you abide by these rules. Failure to follow these instructions may result in the case having to be retried, and it could result in you being held in contempt and punished. The parties and the court appreciate that we have had your full and undivided attention throughout the trial. Occasionally, after a jury retires to the jury room, members have questions. I have prepared the instructions after carefully considering this case with the parties and the lawyers. I have tried to use language which is generally understandable. Usually, questions about the instructions can be answered by carefully rereading the instructions. If, however, any of you feel it is necessary to ask a question, you must do so in writing with the foreperson signing the request and dating the same and delivering the question to the court attendant. I cannot communicate with you without first discussing your question and any potential answer with the parties and the lawyers. Forms of verdict have been prepared for you and attached to these instructions. You will use only one form of verdict. When you have agreed upon a verdict and the foreman or the forewoman has signed the verdict, please notify the court attendant. Dated this 24th day of February, 2020, signed by myself, Faye Hoover, a judge, 6th Judicial District of Iowa. Ladies and gentlemen, as you have been aware, we need only 12 members of the jury to actually deliberate and decide the case. Each and every one of you has been incredibly patient and diligent in your work, listening to the evidence. And at this point, I'm going to ask Ms. Larson. She has placed each of your names into a box, and I'm going to have her draw 2 names from the box. Those 2 individuals will be the alternates.
Can you still hear the audio? I don't even know if is anybody out there? No problem. All right, playing it. Acting up. All right, I'll keep playing. And you guys can always go back, I guess, and I don't even, yeah, I mean, it is what it is.
You who are selected as the alternates will be excused. You will not participate in the deliberations. Until you receive word from the court, either from myself or from Ms. Larson, I'm going to ask you to abide by that admonition. When the jury, the 12 jurors, have reached and delivered to us in open court a unanimous jury verdict, you will be contacted immediately and released from that admonition. Larson, to please draw 2 alternates from the group. Appointment, it may be a relief, but whichever, please leave with the thanks of the parties for your attention and diligence in this matter, but you will not be permitted to deliberate and decide the case finally. Please leave your contact information with Ms. Larson so that we can notify you when there has been a verdict reached, so that you know that you are able to speak freely about your experience up to this point. So, thank you very much. Ms. Larson, if you would please raise your right hand. Do you solemnly swear that you will take and keep this jury together in their jury room unless specifically directed by the court, and not to allow any person to speak to or communicate with them, nor speak with or communicate with them yourself, except as to ask whether they have agreed upon their verdict, and not to communicate with them regarding the state of their deliberation or the verdict agreed upon until after the same shall. And do you further swear and affirm that you will take with you the exhibits and deliver them to the jury and not allow them to be unattended or tampered with until, again, the exhibits and the jury have returned to open court? If you so swear, please say I do.
I do.
Please rise for the jury. You can bring your notebooks with you.
All right, guys. News right now. We're dropping frames. We were pretty good the last couple of days, but sorry about that. Hang in there. No, it has just the problem we have with Comcast. All right, I'm gonna play. I'll play the verdict, and we'll see how it comes through. I know you. Yep. Okay. I'm gonna go ahead and play the verdict. You have no idea how frustrating this is. No idea. Here comes the verdict. Hopefully, you guys will be able to see it.
Good afternoon, members of the jury. Our court attendant informed me that you have reached a verdict. Is that correct?
That is correct.
Okay, if you would please hand that verdict form to Ms. Larson. Thank you. The verdict appears to be in order. The members of the jury, through the foreman, have signed verdict form number 1. We, the jury, find the defendant, Jerry Lynn Burns, guilty of the charge of murder in the first degree, dated this 24th day of February 2020, signed by the foreman of the jury, Mr. Lynch. I will now poll the jury. I'm going to ask you simply whether this is your verdict. Rather than name each of your names, I am going to proceed by seat number, and it will be in the order. The top seat on my right, we will go through that top row, and then we will proceed in the front row of jurors, beginning again to my right, nearest the back wall of the courtroom. Juror number 1, is this your verdict? Juror number 2, is this your verdict?
Yes.
Juror number 3, is this your verdict?
Yes.
Juror number 4, is this your verdict?
Yes.
Juror number 5, is this your verdict?
Yes.
Juror number 6, is this your verdict? Juror number 7, is this your verdict?
Yes.
Juror number 8, is this your verdict?
Yes.
Juror number 9, is this your verdict?
Yes.
Juror number 10, is this your verdict?
Yes.
Juror number 11, is this your verdict? Juror number 12, is this your verdict? Ladies and gentlemen of the jury, thank you again. At this time, we will excuse you. I will be in just a few minutes to thank you again and answer any questions that you have.
Please rise for the jury.
The record should reflect that Mr. Burns, as well as counsel, have remained in open court. The jury has retired again to the deliberation room. I will schedule a sentencing in this matter in the normal course. It will be approximately 6 weeks from now. I direct the 6th Judicial District Department of Correctional Services to prepare and file a pre-sentence investigation report and make that available to the attorneys as well as the court with no less.
Well, if you guys can hear me, I'll replay this on Monday because we just crashed and burned. So I'm going to end this now. I'll go back to chat and just chat with you guys a little bit. But thank you for watching. If anybody sees this, thanks. But I'll replay this on Monday. Thanks. Bye.